Losing lens. ಏನು urgency?
Earlier, he has been removed from service.
ಯಾವಾಗ?
Has been terminated.
ಯಾವಾಗ?
The last date of hearing the matter was posted before.
When he was terminated?
On in the month of August, my lords. Two times the matter has come up before this honorable court. Matter was last time it was listed on 20th/11, and your lordship has directed to post in the next week.
Next week ಹಾಕ್ಬಿಡಿ. Yes,
Lordship's kind permission.
Ah.
Contempt is coming up on Friday, my lord.
Friday,
Please, my lord.
Thursday.
Any date before that.
Thursday.
Obliged.
ಹಾ, ಸರತಿ. ಏನು?
In number 5,
5.
for correction and hackivity. That matter is now seized before the Honorable Supreme Court. The other side has taken to Supreme.
Is it? So we will adjourn it to Senate.
We posted after disposal, we file.
Call after 8 weeks. Call after 8 weeks as requested by the net counsel, as suggested by the net counsel appearing for the respondent, petitioner. Full stop. Memo for correction can be done, na?
Those matter correction upon it.
All right. It is said that the main matter is carried to apex court. Okay, or sentence, okay.
Please,
Ah,
shall I please?
ah,
Serial number 15, my lord.
15.
Yes.
ah,
Council, I'm told, is not keeping well,
not well.
not well. Needs a short accommodation.
Ah, 15, 2024 matter. All right. Call of provocation
Please,
on the health ground of arguing counsel for the petitioner. Okay.
Your Lordship's kindly, what's fresh matter pertaining to departmental inquiry merits. There is 14 years long delay in initiation merits. At the benefit of interim order before the tribunal merits, now they're likely to proceed with the inquiry.
ಯಾವತ್ತಿದೆ enquiry?
Let's inquiry next week. The date is 6 months.
Next week.
The date is
Call this matter next Monday.
great.
ಹಾಕ್ಬೋದಾ? ನೋಡಿ,
Kindly.
ಹಾಕಿ.
Serial number 21, my lords.
ಹಾ,
Appearing for appellants, my lord. Senior has some inconvenience. Request for short.
21.
21, my lords. For
Okay.
appellants.
ಬೈರಾರೆಡ್ಡಿ
Vaishali Agde, my lords. We have filed NOC.
ಅಲ್ಲಿ ಬೈರಾರೆಡ್ಡಿ ಟು ಪರ್ಮಿಟೆಡ್ ಟು ರಿಟೈರ್ ಮಾಡ್ಬೇಕಂತ ನೋಡಿ ಅದನ್ನ. ಶ್ರೀ ಬೈಯಾರೆಡ್ಡಿ is permitted to retire. First, call this matter in the first week of February 2025 as requested by counsel
Obliged.
for appellant. ಅವ್ರಿಗೆ ತಿಳಿಸ್ಬೇಕು.
Inform ಮಾಡ್ತೀನಿ.
Okay.
Please, oblige.
All right. Yes, Nagaraja. Yes, Nagaraja. ಯಾಕೆ?
R2 is concerned, my lord. Collected discussion.
All right, 2 weeks ಹೆಂಗಿದ್ರೆ ವೆಕೇಶನ್ ಬರ್ತಾ ಇದೆ. 2 weeks for compliance. Okay, finally. ಪೇಪರ್ ಬುಕ್ಸ್ ಯಾರಿಗೆ ಸರ್ವ್ ಮಾಡೋ ಪದ್ಧತಿ ಇಲ್ಲ ನಮ್ಮಲ್ಲಿ. ಕೋರ್ಟ್ ನಲ್ಲಿ ಇಟ್ರೆ ಆಯ್ತು, ರೂಲ್ ಹಂಗೆ ಇದೆ. ಅಮೆಂಡ್ ಆಗೋವರೆಗೆ ನಾವೇನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ. ಕೊಡಿ. The paper book is served on the counsel representing the respondents. Right. Yes. ಅವ್ರಿಗೆ ಹೆಂಗ್ ಗೊತ್ತಾಗ ಫೈಲ್ ಆಗಿದೆ ಏನು? ಹಾ,
ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್
ಪ್ರಕಾಶ್,
ಪೇಪರ್ ಬುಕ್ ಫೈಲ್ ಮಾಡಕ್ಕೆ ಹೇಳ್ಬೇಕು.
ಫೈಲಿಂಗ್ ಆಫ್ ಪೇಪರ್ ಬುಕ್ಸ್ 28/11/22 2 ವರ್ಷ ಆಗಿದೆ. ಒಂದು ಒಳ್ಳೆ ಬುಕ್ ಕೊಟ್ಬಿಡಿ ಲೈಬ್ರರಿ. 2 ಸಾರಿ, ಐ ವಾಸ್ ಆನ್ 3. ಅಕ್ಸೆಪ್ಟೆಡ್ ಮಾಡ್ಬೇಕಲ್ಲ? ಅಕ್ಸೆಪ್ಟೆಡ್ ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಫಾರ್ಮೆಟ್. ನೋಡಿ ಹೆಸರು ಕೂಗಿಬಿಟ್ರಿ ಒಂದ್ಸರಿ.
Respondent number 6, Balachandra. Respondent number 9, Udaya. Respondent number 11, Narayana Shetty. Respondent number 12, Vishwanath Shetty. Respondent number 17, Sanjeeva Shetty. Respondent number 19, Prema Shetty.
The names of subject respondents were loudly called out by the court officer. First off, there is no response. First off, in view of that, the service of notice on them by substituted mode is held sufficient. ಯಾವಾಗ ಆರ್ಗ್ಯುಮೆಂಟ್?
ಪೇಪರ್ ಬುಕ್ ಫೈಲ್ ಮಾಡಿ.
ಪೇಪರ್ ಬುಕ್ಸ್ ಎಷ್ಟು ಅವಾಗ ಮಾಡಬೇಕಿತ್ತು? 10 years ago. ಆಲ್ ರೈಟ್, 2 ಬುಕ್ ಕೊಟ್ಬಿಡಿ. ಒಂದು ಲೈಬ್ರರಿ ಅಸೋಸಿಯೇಷನ್ ಲೈಬ್ರರಿಗೆ ಭಾರತೀಯ ಛಂದೋ ವಿಕಾಸ ಬೈ DS ಕರ್ಕಿ ಬಹಳ ಉತ್ಕೃಷ್ಟವಾದಂತಹ ಪುಸ್ತಕ. ಛಂದೋ ವಿಕಾಸ, ಛಂದಸ್ಸಿನ ಮೇಲೆ ಇರುವಂಥದ್ದು. ಮೇ ಬಿ ಅವರ್ Mr. Raghavan might have seen that. Yes. Okay. Within 2 weeks, this should be done. All right, 4 weeks, madam, after vacation birth. Okay. Next.
Paper appellation. Kindly 2 weeks time may be granted. File a paper book.
Same order. ಬೇರೆ ಬುಕ್ಸ್ ಕೊಡಿ, ಯಾವ್ದನ್ನು ಕೊಡ್ತೀವಿ? ಕುವೆಂಪು ಅವರ ರಾಮಾಯಣ ದರ್ಶನಂ ಕೊಟ್ಬಿಡಿ ನೋಡಮ್ಮ, 2 ಪುಸ್ತಕ. 3 ತಗೋಬೇಕು, ನೀವು ಓದ್ಬೇಕು, ನೀನು ಓದ್ಕೊಂಡ್ಬರ್ಬೇಕು, ನೀನು ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಬರ್ತಾ. Yes.
I represent for the appellant in connected appeal 1374 by.
One side.
Huh?
The application filed by defendant number 19 LR and that matter was in fact in the trial court for inquiry. There have been findings that have been passed by the learned trial court.
Court.
And that application has been put up.
ಏನಂತ ಮಾಡಿದಾರೆ ಫೈಂಡಿಂಗ್?
Order was passed. The honorable court was directed to give a finding, but they have passed an impugned order saying that he is the LR and he has to come on record. The order of this honorable court, my lords, was very clear. The learned trial judge was only supposed to give the finding. An order has been passed on that application.
That he is the LR.
He is the LR.
Come on record.
22 rules 5. The impugned order is a.
Order 1 to 10. This application may be considered along with the main for this purpose, not the identity of the party itself.
See, even if it's an order, that doesn't bind this court, isn't it?
Please.
It's only a finding
That's
only.
all. On merits it will happen.
On merits, we will consider it. Even though they say that it is an order, it cannot be an order. In terms of the order which was made by this court, referring the matter to the trial court to give a finding on it, whether he is the
LR or not.
so and so LR, yes or no. He has given a report.
He has passed an order saying that he is the LR.
Say report. Report was called for. No, it is
Even though
called
the
as
order says the application is allowed, that may not be correct. Only the reasoning, my lords, will have to look at.
Subject to that, we will
Yes.
consider that with the main.
And
matter.
for that order, objections were also filed. To the findings, objections have been filed.
All parties have filed objections to this finding.
That we will consider it.
It may be
along with
considered
the
along
main matter itself.
Yes.
ಯಾವ್ದು ಎಲ್ಲದ್ರಲ್ಲೂ ಹಾಕಿದ್ದೀರಾ? None? I have 1 of 19. 4.1, 4.2, 4.3.
I mean, 4.4
in
as
the-
an apparent, my lord. 4.4 as an apparent, my lord.
Ah.
That lord is matter was for pioneering and statute appearing, my lord. At our request, it got reached, we requested to issue an order list, my lord. That's why it's supported, my lord.
Right, all these are arising out of the same.
Same judgment.
Then whatever that finding has been
Except
given,
4.1.
that we will consider it along with the main appeal itself.
Appeal has to be heard on merits so that my lords
I think
ultimately.
in 4.3, it's in 4.3, I think
4.1, my lord, does not arise out of this.
So now the question is whether that report or the finding given by the trial court is to be or not to be accepted.
no, that
Only
is,
that
that
much.
is only on the application. Manoj, in the main order is, Manoj, my suit for declaration has been decreed by the trial court.
That's all right. To maintain this,
Yes.
that report we will accept for the limited purpose of that. That's all. Alva?
No, that
Filer
cannot be.
objection.
But whether they are the LRs or not has to be
Yeah,
considered.
you-
Voting.
We have filed up
We've all filed
Maintenance.
objections.
They were
We-
heard by the,
because we have
they were heard in the court below.
only the plaintiff and the first defendant, we participated in the proceedings before the trial court.
Ah.
And others were not permitted because they had not filed the objections here. And we had disputed the very relationship and in fact, we have been able to cross-examine, we have demonstrated that he is not the LR. The finding is given and therefore, my lords may kindly permit us to argue on that application also because there are certain documents which would prima facie indicate that is not the LR.
ಒಪ್ಪಂಗಿದ್ರೆ.
Which I had 1/19, huh?
Yes.
To seeking permission to,
A perusal of, a perusal of the proceedings of this court would show that IA 1/19 was filed to bring the LRs of number
P19.
Respondent, defendant number 19.
Different number 19 happens to be which respondent?
in my appeal, my lords, is the 19th respondent.
That is
in
first
that-
one.
La- Second one.
132.
IA,
18. Respondent number 18.
IA 1/19 alwe,
ಹೌದು.
to bring the LRs of respondent number 18.
Please.
But the matter was referred to the trial court to hold an inquiry in respect of, they said, application as objections were filed by the appellant.
No, they had not filed the,
Who had filed?
they had not filed objections.
Who had filed objections?
The first defendant in the trial court, that is the appellant in RFA 1374 of
ಅದನ್ನೇ
2015.
ಕಂಪೇನಿಯನ್ 1324.
1374 ಅಲ್ಲಿ I am the appellant and I am the first defendant in the trial court, my lords.
In 1324, who are you? You had filed objections? No objections. Who had filed the objections?
My lords, the first defendant, that is RFA 1374 of 2015 appellant, he had filed the objections.
15 ನಲ್ಲಿ you are which respondent?
215.
Respondent number 2.
Two na?
Please.
Objections were filed by respondent number 2, who is the defendant number 1 before the trial court.
Also by the-
And also by
After
the,
holding an inquiry, the trial court has given its finding and has submitted its report to this court.
as the order.
Though the trial court, though such report of the trial court is titled as an order, it cannot be an order, but it is only a report as directed by this court. Objections are also filed to the said report by the respondents in the present appeals, which are arising out of the same common judgment and a decree. The correctness or otherwise of the finding / report of the trial court would be considered along with the main appeal.
Please.
Hence, this is the matter for paperwork ಎಲ್ಲ ಆಗಿದ್ಯಾ? This is the matter for final hearing.
But I think
Along with
4.3 ಅಲ್ಲಿ notice on LR application,
along with
notice
all
is not
companion
served.
matters.
In 4.3,
Yeah.
there is an LR application, notice not served ಅಂತ ತೋರಿಸ್ತಾ ಇದೆ.
ಆ ಎಲ್ಲರ ಬೇರೆ ಎಲ್ಲರ
ಬೇರೆಯವ್ರದ್ದು. ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್, ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 16.
ಅದರಲ್ಲಿ ಉಳಿದಿದ್ರೊಳಗೆ ಅಪಿಯರ್ ಆಗಿದ್ದಾರೆ ಅವರು.
I am not sure.
Same party appeared in other matters?
ಅದರ್ ಮ್ಯಾಟರ್ಸ್ ಇರ್ಲೇಬೇಕಲ್ಲ. Four point three, you are the appellant, ah?
ಇಲ್ಲ, I am not there.
You are. ಅದು ಬೇರೆ, next para. In RFA number 1730 of 2015, appellant to take steps in respect of deceased respond number
16.
Is the matter after vacation.
By 4.4, my lord, I am permitted to amend the cost title, my lord, office, my lord. I recently filed wakalat for appellants,
In 4.4,
non-amendment of cost title anta ಇದೆ, I will.
Impleading application allow ಆಗಿತ್ತಾ?
ಆಗಿದ್ಯಾ?
In 2 weeks, I will complete it.
Date for 2019.
In RFF 147 of 2016, appellant to carry out the amendment as per order passed earlier. And file amended cost rate.
Obliged.
Second respondent, the first respondent, that is who is the plaintiff, he had also filed his objections in the trial court.
ಇಲ್ಲಿ ಅದು.
Considered along with the main.
Available for all.
4.5 ದಲ್ಲಿ ಏನದು ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್?
Cost objection that's filed in the lot by.
Seven Lokre. In RFA crop 17 of 2023, the cross objected to comply the office objections within 2 weeks.
Much. of-
6.
Number 6, J. Nandalike.
I appear, my lord, for the petitioners.
ಕಾಸ್ಟ್ ಟೈಟಲ್ ಅಮೆಂಡ್ ಮಾಡಿ,
ಮಾಡಿದ್ ಸರಿ. We filed a fresh amended petition being filed.
ಅದನ್ನು ಅಮೆಂಡ್ ಮಾಡಬೇಕು. ಅಮೆಂಡೆಡ್ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಹಾಕ್ಬೇಕು, ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಬೇಕು. ದಟ್ ಈಸ್ ರಿಕ್ವೈರ್ಮೆಂಟ್ ಆಫ್ CPC.
We'll do it. ಈಗಲೇ
Actually, amendment.
ಎರಡನ್ನೂ
Petition ಹಾಕ್ಬೇಕು ಅಂತಿದೆ.
amended petition.
ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ನಿಮ್ಮ ಅನುಕೂಲಕ್ಕಾಗಿ ಅದು ಬರೀ ಕಾಸ್ಟ್ ರೈಟ್ಲಿಗೆ ಸೀಮಿತಗೊಳಿಸಲಾಗಿದೆ.
ಇಲ್ಲ, ಅಮೆಂಡೆಡ್ ಪಿಟಿಷನ್ ಹಾಕ್ಬೇಕು.
ಹಾಕ್ಬೇಕು.
Division bench said in 1975, following your father's judgment of earlier judgment, that where amendment is to be carried out, space is lacking. Minimum amendment by script should be done to the pleadings, and amended pleading should be filed.
ಇದೆ.
Justice, great Justice Gopi Vallabha Iyengar's judgment. Yes.
Not these writ petitions will not arise out of orders passed in execution proceedings initiated pursuant to an order that had been passed by the Consumer Commission on a complaint. I tell your lordships, my lord, why we are finding fault with every one of the orders that have been passed in the execution proceedings, and that's how we are before this court.
An urgency and idea.
My lord, there is one difficulty, my lord. 18th is the matter posted in the execution case, and now, my lord, the commission is now has passed series of orders, though we have been impleaded. We were not parties in the original complaint. We have been impleaded, and proceedings are now initiated against us. My lord, if the proceedings before the execution court are stayed, my lord, then I have no problem. It is posted on 18th. Our difficulty is that.
18th.
Yes.
18th, don't precipitate the matter.
My
We'll
lord,
have that immediately after.
There is no quorum in the commission.
Ah.
And no orders are being passed.
Suppose if orders.
ಅಲ್ಲ,
are
ನಾವೇನ್
passed on 18th.
precipitate ಮಾಡ್ತಾ ಇಲ್ಲ. ನಾವೇನ್
Circle. We asked learned senior advocate Mr. KG Raghavan appearing for the petitioner as to urgency. First off, he points out that execution is being levied on 18th, possibly. And if that happens, the petitioners would be put to great prejudice. First off. Next paragraph. First off, next paragraph. The winter vacation is fast approaching, and there are some urgent matters and part-heard matters that need to be attended to. First off. Next paragraph. In the above circumstances, the coercive action by in the subject execution is suspended.
Yes.
Suspended till next date of hearing. Call this matter in the third week of January 2025.
My request, my lord.
Yes.
Date may be fixed.
But the third week, we don't know which.
The
bench.
oldest executions pending before the state commission.
It will, therefore, third week ಹೇಳಿದ್ರು. Suppose if it is some senior judge ನಮ್ಗಿಂತ ಆ ಲೆವೆಲ್ ನಲ್ಲಿ ಇದ್ರೆ, we can't fix the date. ಅದಕ್ಕೆ. Okay. Next.
Matter has not yet been heard for argument. Lordship, can you post this matter for preview hearing, my lord?
ಏನಿದು ರವಿ?
My lord, we have questioned the appointment of the respondents to the environmental committee and authority. They don't have the qualification at all.
Are you ready in the matter?
No, my lord,
kindly post it in next week, my lord. We have to file one.
Fresh matter. Notice is not yet ordered.
ಅಲ್ಲ ಅದಕ್ಕೆ ಪ್ರಿಮಿಯರ್ ಹಿಯರಿಂಗ್ ಬರಬೇಕು. The matter has been referred to the division bench, my lord.
Second split ಕೊಡ್ಬೇಕು.
ಅಲ್ಲಿ ನಾನು ಕೊಟ್ಟಿದ್ದೀನಿ, ಅವ್ರು ಕೊಟ್ಟಿಲ್ಲ.
Objection ಅದು ಕೊಡ್ಬೇಕು.
Yeah. We have filed only one set of statement of.
The office objections to be addressed by the respondent. Respond within 2 weeks. First stop. Call in the second week of January.
First week of January.
First week. ರಜಾ ಇದೆ. We have.
ಮರ್ತೋಯ್ತು.
ಇಲ್ಲ, we have modified, you are right actually. It is yet to be notified. We have modified that one by full court resolution. We have location till 5th of.
6th ವರೆಗೆ ರಜೆಯನ್ನು ಡಿಕ್ಲೇರ್ ಆಗಿದೆ. 6th ವರೆಗೆ.
Trial ಕೊಡ್ಸಿ. 2 days sitting there. January 20, June 20. In the second week,
10th ಮೇಲೆ
date ಕೊಡಕ್ಕಾಗಲ್ಲ, ಯಾಕಂದ್ರೆ ಗೊತ್ತಿಲ್ಲ, we don't know which bench will come ಅಂತ. Okay.
Notice order already statement of.
ಹಾಕಿದ್ದಾರೆ. Let us. ಅದನ್ನು ತಪ್ಪು ಹಾಕ್ಯಾರೆ.
This, my lord,
ಆರ್ಡರ್ ಮಾಡಕ್ ಬರಲ್ಲ. That is order, very call in the second week. Okay.
this office objection is, my lord, the translated copy.
Huh?
Translated copy of the.
Yes, what is this matter?
This is, my lord, in respect of the penalty imposed, withholding the 3 annual increments, my lord, with cumulative effect. Here, my lord, he was.
For what is the delinquency?
Delinquency is, my lord, he was, my lord, sanctioned with the study leave, my lord, without leave without pay. And, my lord, after completion of that, my lord, he come back, my lord, and reported before the Directorate for Department of Health and Family Welfare. And his name was recommended for posting. Later on, my lord, no posting was given till 2011. Thereafter, my lord, in 2011, my lord, an order was passed and given a posting to the present place. After that, my lord, in the year 2013, articles of charge was issued saying that from this year 2009, when you reported for duty, and to till 2012, you are unauthorizedly absent.
You remained absent is true.
It is kindly, my lord, for one
King,
Yes, my lord. Absent is true.
Be honest to the court first.
Yes, my lord.
Then you can have some relief at, you
Ye-
may have
Yes,
some
ma'am.
relief at
Yes,
our
ma'am.
hands.
Yes, my lord.
So you remained absent, you were not on the seat.
Yes.
For how long?
It's, my lord, from, my lord, kindly, my lord, annexure A5.
We are asking you how many teeth you have.
It's
You need not wide open for us to
Yes.
count at all. You should tell.
September 2009 to
2006 to 2009.
9. No,
Date for
no, my lord. It's on permission leave, my lord.
Which is that date?
Kindly, my lord. 26/9/2009 to, that is 1/8/2012, my lord, they are considered. Earlier to that, my lord, on permission, I was on study leave to pursue my master's degree in the medical science
Study leave for what period?
for 3 years.
Is it a study deputation?
No, my lords, on
Study leave,
study leave, without leave without
like
pay.
sabbatical.
3, yes, leave without pay. My grievance is, my lord, when I completed my course.
You completed course and reported for duty when?
On, my lord, kindly, my lord, 22/6/2009, I reported at Directorate of Health and Family Welfare, and there no posting. And, my lord, again, I submitted on 24/7/2009 a request. Thereafter, my lord, on 26/9/2009, my lord, the note was put up by the Directorate to the first respondent government.
You said 22/6/2009, you reported for duty.
Yes, my lord.
Same day a note was put up.
No, my lord, next after 2 months.
22/10.
26/9/2009, note was put out for giving posting to me. But posting was not given. Pays, my lord, 67.
Where is proof that you reported for duty back on 22/6/2009?
That is, my lord, I have submitted request.
ಎಲ್ಲಿದೆ?
Kindly, my lord, page 63.
63.
Typed copy, my lord, is at 64.
Whether this is disputed or
Not disputed. Kind of annexure A5, another one document, page 60, page 67.
Okay. ಇಲ್ಲಪ್ಪ correct ಆಗಿ ನೋಡು.
May I read this document for a moment. Dr. Satish Kumar HR ಈ ಹಿಂದೆ ಪ್ರಾಥಮಿಕ ಆರೋಗ್ಯ ಘಟಕ ಬಿದರೆ ಗುಬ್ಬಿ ತಾಲೂಕಿವರು ಇಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿದ್ದು, ಇವರು ಖಾಸಗಿಯಾಗಿ ಸ್ನಾತಕೋತ್ತರ ವ್ಯಾಸಂಗವನ್ನು ಮುಗಿಸಿ ದಿನಾಂಕ 25/7/2009 ನಿರ್ದೇಶನಕ್ಕೆ ಹಾಜರಾಗಿರುತ್ತಾರೆ. ಸರ್ಕಾರ ಆದೇಶ ಸಂಖ್ಯೆ ಸೋನ್ಸರಲ್ಲಿ ಬೆಂಗಳೂರು ದಿನಾಂಕ 17/10/2006 ಸರ್ಕಾರಿ ಸದರಿ ವೈದ್ಯರಿಗೆ ಸ್ನಾತಕೋತ್ತರ ವ್ಯಾಸಂಗದ ಅವಧಿಯನ್ನು ಲೆಕ್ಕಕ್ಕಿಲ್ಲದ ದಿನಗಳು ಅಥವಾ ಕರ್ತವ್ಯರಹಿತ ದಿನಗಳು ಎಂದು ಪರಿಗಣಿಸಿ ಆದೇಶಿಸಲಾಗಿದೆ. ಸದರಿ ವೈದ್ಯರು MSGS ವಿದ್ಯಾರ್ಹತೆ ಹೊಂದಿದ್ದು, ಖಾಲಿ ಇರುವ ಸಾರ್ವಜನಿಕ ಆಸ್ಪತ್ರೆ ಶಿರಾ, ತುಮಕೂರು ಜಿಲ್ಲೆ ಇಲ್ಲಿಗೆ ನೇಮಿಸುವ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಸಲ್ಲಿಸಿದೆ. ಈ ಪ್ರಪೋಸಲ್ ಸಬ್ಮಿಟ್ ಆದ್ಮೇಲೆ ಇಲ್ಲಿ ನೆಕ್ಸ್ಟ್ ಅಪ್ ಟು 2011 they have not taken action to given any posting.
how tribunal treats this argument? How tribunal treated this argument?
This argument, my lord, at the time of granting, my lord, kindly, my lord, I have submitted one affidavit in the year, my lord, 2012, when I requested for duty. Then I asked for one affidavit. That I have submitted an affidavit, my lord, page 76. Page 76. Typed copy is at page 77. May I read, my lord. May I read, my lord. HR ಸತೀಶ್ ಕುಮಾರ್ MBBS MS ಜನರಲ್ ಸರ್ಜನ್ ಆದ ನಾನು ನನ್ನ ಸ್ವಂತ ಖರ್ಚಿನಲ್ಲಿ ಸ್ನಾತಕೋತ್ತರ ವಿದ್ಯಾಭ್ಯಾಸ ಮುಗಿಸಿ ಮರಳಿ ಇಲಾಖೆಗೆ ದಿನಾಂಕ 22/5/2009 ಹಾಜರಾಗಿದ್ದೆ. ಆದರೆ ನನಗೆ ಯಾವುದೇ ಖಾಲಿ ಇರುವ ಜಾಗದ ಹುದ್ದೆ ನೀಡದೆ ಇದುವರೆಗೂ ನೇಮಕಾತಿಗೆ ಕಾಯುತ್ತಿದ್ದೆ. ಈ ಅವಧಿಯಲ್ಲಿ ಬೇರೆ ಕಡೆ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದೆ. ಆದರೆ ನನಗೆ ದಿನಾಂಕ 22/5/2009 ಆದೇಶ ದಿನಾಂಕದ ಲೆಕ್ಕಕ್ಕಿಲ್ಲದ ಅವಧಿ ಎಂದು ಪರಿಗಣಿಸಿ ಚನ್ನಗಿರಿ ಆಸ್ಪತ್ರೆಗೆ ಸ್ಥಳ ನಿಯೋಜಿಸಿ ನನಗೆ ಕೆಲಸ ನಿರ್ವಹಿಸಲು ಅನುಕೂಲ ಮಾಡಿಕೊಡಬೇಕಾಗಿ ಈ ಮೂಲಕ This, my lord, the affidavit is filed. This has taken consideration by the tribunal, my lord. The tribunal has held. You have admitted that you are absent for this period from 2009 to 2012. And my lord,
Admitted alla. He has worked in a private hospital.
Correct.
Correct, ನೀವು ಕೊಡ್ಲಿಲ್ಲ.
Did you pay salary to him? How he should survive? He
Yes.
comes back with value addition. You did not make use of him. Where he should go? Who will look after his wife and
Government's-
children?
It is against the.
You do not
laws,
give
my lord. He
posting.
Cannot,
You ask him, don't work. You want to kill him?
scope of judicial review, my lord.
Huh?
Scope of.
That's
judicial-
all right. What is that judicial review? The apex court said in Volga Tellis, where means of livelihood is taken away, that is violation of Article 21. You did not give only. You said a proposal is being considered. You went on considering.
What happened to your, that proposal?
no, my lord, they are not even considered.
It has never reached any.
Then, my lord, the one of the person
Page
from
85 is
MLA who
suspension
find
order.
out there is a vacancy in the Changiri and he find out I am without waiting for posting. Then, my lord, he requested the department and taken me to that place, the present place,
How can he be punished for this? We do
where the
not
new
know.
hospital was opened. I am apologizing.
Be seated. How can that doctor be punished? ಮೊದಲೇ ಡಾಕ್ಟರ್ ಇಲ್ಲ ಅನ್ಕೊಂಡು ನಮ್ಮ ಮುಂದೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಕೊಂಡು ಆರ್ಡರ್ ತಗೋತೀರಿ. ಇಂಥ ಡಾಕ್ಟರ್ ಕೆಲಸ ಮಾಡ್ತೀನಿ, ಪೋಸ್ಟ್ ಕೊಡಿ ಅಂದ್ರೆ ಕೊಡಲ್ಲ. And he has come back after value addition. Where you do not give him posting at all, how he should hold his body and ಆ ಪೀರಿಯಡ್ಗೆ ಸ್ಯಾಲರಿ ಗಿಲ್ರಿ ಏನಾರ ಕೊಟ್ಟಾರ?
ಏನು ಕೇಳಿಲ್ಲ sir.
What is this?
My lord, being a government doctor, my lord, he is not supposed to work in a private
Then what
hospital.
he should do?
How he should hold his body and soul together and of his family?
The inquiry time he admits, my lord, that he files application after a lapse of 2 years.
You dismiss him from service. Why you did not take action? You said your proposal is being considered. Proposal to send him to that ಯಾವ್ರದ್ದು?
Shira, my lord.
ಚನ್ನಗಿರಿ ಆಸ್ಪತ್ರೆ.
Chandagiri.
Shira, my lord. Shira.
ಪರಿಗಣಿಸಿ ಚನ್ನಗಿರಿ ಆಸ್ಪತ್ರೆಗೆ ಸ್ಥಳ ನಿಯೋಜಿಸಿ ನನಗೆ they said Shira
Shira.
and he is asking whatever. You should have taken a decision.
ಈಗಾದ್ರೂ posting ಕೊಡ್ಬೇಕಾಗಿತ್ತು.
ಕೊಡ್ಬೇಕಲ್ಲ?
That was by none than by the director, Ayuktar, Commissioner of Health and Family Welfare. He proposes to the secretary.
Yes, my lord.
And why it was not acted upon? You hold
That you,
hold the inquiry against the
person,
secretary-
concerned person,
concerned person who
not
did not,
against him.
who did not give the posting. Have you initiated that?
ಅದನ್ನ ಮಾಡಲ್ಲ ಅವರು.
Why the services of this person was not taken by the government?
Let my lord
ಇಲ್ಲ
inquiry
ಇಲ್ಲ
be
ಇಲ್ಲ
conducted.
ಡಾಕ್ಟರ್ ಇಲ್ಲ ವೈದ್ಯರಿಲ್ಲ ಅಂತ ಹೇಳಿ ಹೇಳ್ತೀರಿ, ಇದ್ರೊಳಗೆ ನಾ ಬರ್ತೀನಿ ಅಂತಂದ್ರೆ ನೀವು ಅವ್ರಿಗೆ ಕೊಡೋದೇ ಇಲ್ಲಲ್ಲ ಮತ್ತೆ.
And ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಮಾಡ್ಕೊಂಡ್ ಬಂದ ನಾನು. ನಿಮ್ permission
Representation,
ತಗೊಂಡೇ ಹೋಗ್ತಾರೆ.
they have given representation.
ಮತ್ತೆ
And instead you try to punish him.
Affidavit he says that he has worked
ಹೌದು.
Hold inquiry against the secretary also.
back against the conduct rules.
No, this is
ಈಗ ನೀವು ಇದನ್ನ ಏನ್ ಮಾಡ್ತೀರಿ?
To inquiry, let inquiry be
what
initiated.
inquiry?
Why inquiry?
Where is he at fault?
Should
ನೀವು
we kindly
ನಿಮ್ದು
wait
ನಿಮ್ಮ
85?
ಕೋರ್ಸ್ ಮುಗಿದಿತ್ತು ಯಾವಾಗ?
Inquiry ಅಂದ್ರೆ
It's 2009, May 2009.
Inquiry ಮಾಡಿ.
May 2009,
ಮೇ ಅಂದ್ರೆ ಯಾವ ಡೇಟ್?
May, the 18th, kindly, my lord, the 18th May 2009.
ವೇರ್ ಇಸ್ ದಟ್?
That is, my lord, kind. Page, my lord, 61. I have relieved on 17/6/2009. Page 61, annexure A2, my lords.
61.
Yes.
ಆಮೇಲೆ ಡಾಕ್ಟ್ರು ಬಿಡಪ್ಪ ಯಾವ್ದೋ FDC ಅಂತದ ಮಾಡ್ತಾ ವಿ ಕ್ಯಾನ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್. 17/6 no due certificate it is.
Yes,
We did not ask for no due certificate. We asked when your course was over.
April 2009, my lords.
You should tell the truth first. Don't hide anything.
I'm authorized.
You start doubting in everything.
I'm
Falsus uni, falsus omnibus.
I'm authorized.
April 2000,
To 9, my lords.
which date? April.
That is, my lord, it is not indicated in the notice.
But for
Convocation is
2
given.
months, you did not do anything. 22/6/2009, for the first time, you
Well,
went and asked for a report.
Kindly, my lord, this, my lord, the no due certificate is not issued by an authority, my lord. I am not going to report for a duty because, my lord.
Which rule says, unless no due certificate is given, your report will not be
It
accepted?
is not, my lord, but they have insisting, my lord, to bring the no due certificate in the college.
Where have you stated?
It is, my lord, not stated.
Petition.
It is-
Don't you argue, see, lawyers ಅಂತಂದ್ರೆ ನೀವು ಪಿಟಿಷನ್ ಏನಿರ್ತದೆ ಅದರಲ್ಲಿ ಆರ್ಗ್ಯೂ ಮಾಡ್ಬೇಕು.
ಅಲ್ಲ, before the-
ನಿಮ್ಮ ಪರ್ಸನಲ್ ನಾಲೆಡ್ಜ್ ಅನ್ನ ಇಂಟ್ರೊಡ್ಯೂಸ್ ಮಾಡಬಾರ್ದು.
Before the-
Unless that is
before
wide
the-
open in the public domain.
Yes, my lord. Before the tribunal, it is not stated.
So, 2.5 months you were away from service without reporting for duty.
Yes,
2.5 ತಿಂಗಳು ವ್ಯಾಲ್ಯೂ ಅಡಿಷನ್ ಆದ್ಮೇಲೆ 2.5 ತಿಂಗಳು ಬಂದೇ ಇಲ್ಲ ನೀವು.
but my lord, I will verify, my lord, the convocation certificate is issued and later.
ಕನ್ವೊಕೇಶನ್
ಅಲ್ಲ.
ಬೇಕು. ನಿಮ್ ಕೋರ್ಸ್ ಆದ್ಮೇಲೆ
ಹೌದು.
the educational deputation rule, which other day Mr. Khan argued,
Yes,
it does not require obtaining of convocation certificate. ನಿಮ್ ಎಜುಕೇಶನ್ ಮುಗ್ದಾಕ್ಷಣ ಈವನ್ ಎಕ್ಸಾಮಿನೇಷನ್ ರಿಸಲ್ಟ್ ಕಾಯ್ಬಾರ್ದು, ನೇರವಾಗಿ ವಾಪಸ್ ಬರ್ಬೇಕು.
that is,
ಅದರ್ವೈಸ್ ಪೇಷಂಟ್ ವಿಲ್ ಸಫರ್. ಅಲ್ಲಿ ಮಜಾ ಮಾಡ್ಕೊತ ಕೂತ್ಕೊಂಡ್ಬಿಟ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕು ಮುಂದೆ ಅವ್ರ ಗತಿ ಏನು? 2.5 months ಎಕ್ಸಾಮ್ ಯಾವಾಗ ಎಕ್ಸಾಮ್ ಕೊಟ್ರಿ ನೀವು ಅದರಲ್ಲಿ? Tell the date, on which date you gave examination.
that I will furnish. Because before the tribunal, it is not stated, my lord.
Anyway, 2.5 months.
Yes.
A doctor remaining away, it may be more also, we do not know, is a misconduct. It's a misconduct. For other things, ಅದ್ ನೋಡೋಣ, but ಇದಕ್ಕೆ misconduct ಆಗ್ತದೆ. He wants to gloss over things. He is not fair to the court. He should have said, I stayed away after getting, mostly he wanted to go elsewhere, searching greener pastures, and you said that therefore you have stayed away for more than 2.5 months. When the examination, ಏನು ಮಾಡೋದೇ ಇಲ್ಲ.
This, my lord.
When the examination you wrote last day, the pass over, you ask your client by phone and come back.
Kindly,
Otherwise you'll pass on.
kindly, tomorrow, my lord.
No.
I will get the complete information, my lord, including the certificate.
No, we have heard now. ಬೇಗ ಕೊಡಿ, ಇಲ್ಲಪ್ಪ we are dismissing the matter.
Plus, I see.
ನೋಡಿ. Anyway, we call this matter after vacation to enable counsel for the petitioner to come. Court mood idu. Pass over. Yes. Yes, sir.
Lord, the petitioner is working as in-charge drugs controller,
In charge,
drugs controller.
drugs controller.
He is placed under suspension, my lords, on the, for works which he has not been entrusted with, number one. Number two, my lords, for not doing the impossible.
Which
Now,
is
my
that?
lord, there were certain maternity deaths in Ballari District Hospital. Then, my lords, on 29th of November, the 30th November, the Chief Minister called for a review meeting. In the review meeting, my lords, it was said how it has occurred and how it has happened and all that. Then, my lords, lactate solution, IFS is supplied by one particular manufacturer is the cause, that was the suspicion. Then, my lord, he said, well, yakri ನೀವು ಟೆಸ್ಟ್ ಮಾಡಿಲ್ಲ 2 days ಅಲ್ಲಿ ಆಗತ್ತೆ ಅಂತ. I pointed out, my lords, as per the standard operating procedure, the sample will have to be incubated for 14 days. Thereafter, 3 days, the tests will take. Then, my lords, that is taken as a evasive reply. I placed on record, my lords, IP, which says at page 80, my lords, if my lords would kindly take the page 86, my lords.
How many deaths have taken?
3 or 4, my lords.
How many deaths have
6,
taken?
my lord.
Huh?
6 deaths, but my lord, matter seems,
Deaths.
yes, my lord. Matter seems to be sensitive, my lord. What are the latches on the part of the petitioner?
And
I have
my
to
lord,
take
so
instructions on that regard.
Immediately
And my lord,
sample has been drawn.
KT has
And
the
now, my
request
lord,
to
the
grant
test-
interim order, my lord.
Test report,
Therefore, he is here.
test report has come, which they have web hosted yesterday. That the IV solution, the solution is normal. I am passing on to my lord. This is web hosted on the website of the drugs controller after my suspension.
Where is your suspension order?
Suspension is, my lord, is made on 2nd of
Page number?
page number 81, my lords. It does not speak of any evidence against me.
It is suspension order you need.
The
not speak.
suspension rule 10(3) requires, my lords, a prima facie satisfaction of existing of the first paragraph, my lords, that ಮೇಲೆ ಹೋದಲಾದ ಒಂದರಲ್ಲಿ ಪಶ್ಚಿಮ ಬಂಗಾಳದಿಂದ 192 ಬ್ಯಾಚ್ಗಳ ಪೈಕಿ ಕೇವಲ 95 ಬ್ಯಾಚ್ಗಳನ್ನು ಪರಿಶೀಲಿಸಿರುತ್ತಾರೆ. ಉಳಿದ ಬ್ಯಾಚ್ಗಳು ಬರೆದ ಇದುವರೆಗೂ ವಿಫಲರಾಗಿರುತ್ತಾರೆ. ಅಲ್ಲದೆ ಪರಿಶೀಲನೆಗೊಳದ ಪೈಕಿ 22 ಸಂಖ್ಯೆಯ ಬ್ಯಾಚ್ಗಳು ಕಳಪೆ ಗುಣಮಟ್ಟವಾಗಿದ್ದು, ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಉಳಿಕೆ ಬ್ಯಾಚ್ಗಳ ಪರೀಕ್ಷೆ ಆಗುವವರೆಗೆ ಅವುಗಳ ಸರಬರಾಜು ಮಾಡಕೂಡದ ಸಂಬಂಧಿಕರು ಸುತ್ತೋಲೆಯನ್ನು ಹೊರಡಿಸಬಹುದಾಗಿತ್ತು. ಇನ್ಫ್ಯಾಕ್ಟ್, my lords, on the substandards report which I submitted to the by which I have hosted, my lords, the Karnataka State Medical Supply Corporation, it first suspended the delivery. Thereafter, suo moto on its own, without even my knowledge, they released it for delivery. And I have placed on record the contract which says that supply and procurement and supply.
When NSQ report came?
When NSQ reports, my lords, in the last 20 days it has come. Out of that, my lords, once the NSQ report comes, there is a 28 days window, my lords, in law where the manufacturer can apply to the Central Drugs Laboratory for retest. And only after 28 days and after the report comes, section 25(3) of the Drugs Act, my lords, it says that I can take action only after the conclusive report comes from the.
Where is that any report?
That book, that act is there, my lords. Section 25, my lords. It's not a case where I can file an FIR. It is the inspector has to draw the samples. Section 25, if my lords take.
ಉಳಿಕೆ ಬ್ಯಾಚ್ಗಳ ಪರೀಕ್ಷೆ ಆಗುವವರೆಗೆ ಅವುಗಳ ಸರಬರಾಜು ಮಾಡಕೂಡದೆಂದು ಸರ್ಕ್ಯುಲರ್ ಯಾಕೆ ಇಶ್ಯೂ ಮಾಡಿಲ್ಲ?
That was to be issued by the Karnataka State Medical Supplies, and then, in fact, my lords, we at page 55 on the report, on the NSQ reports, the firm is blacklisted. Supply is stopped by the Karnataka State Medical Supplies Corporation. Thereafter, my lords, even without consulting the Drugs Control Department, they release it.
Who released it?
That is Karnataka State Medical Supplies Corporation.
Which is whom? To whom they released it?
They released it to the for supplies to the district hospitals and other hospitals.
What is your job chart?
In that there is no job. I have nothing to do in either procurement or supply. My job is, my lord, to carry out the regulatory inspections. At page 51, I have placed that contract on record, my lords. Page 51. This is the tender special conditions of contract.
When copy was served on you? This petition copy was served on you when?
Lord, at the time of filing, my lord, they have to serve on the government, then only the matter will be placed before.
Asking you, you are selling the rule position. We know the rule
612, my lord.
When
It
was
is,
it
it is
served
endorsed
you?
as 612, my lord.
Huh?
It is endorsed here as 612 on our file, my lord.
Copy was served on which date? On 6.
612, my lord.
So
Yes.
6, 7, 8, 9.
Please, my lord.
4 days. Why you did not prepared objection statement?
My lord, it is, Lord, when the matter gets listed, we come to know, my lord. Copy serve ಮಾಡ್ತಾರೆ. The rule is like this, my lord.
Correct.
They
But
serve the copy and get the matter listed, my lord.
why that is given is,
Yes,
it's a rule caveat. Without filing a caveat, we are, because rule we have structured that way. It's a statutory caveat.
Yes, my lord.
Therefore, you should have kept your objections ready.
We will, my lord. We will file it, my lord. Moreover, my lord, the
When?
petitioner, my lord, he is an assistant additional drug controller. His duty, my lord, though there was
And I have
the
also, and I also
it was
pointed, my lord,
substantial.
out of 112 sanctioned posts of drugs inspectors, 103 posts are vacant. There are only 9 drug controllers working
In the whole state.
in the whole state. And under the Drugs and Cosmetics Act, drugs inspector is defined as the officer notified by the state government as drugs inspector. They have, for the entire state, drugs inspectors and then assistant drugs controllers. These are the 2 categories of persons that are notified as drugs inspectors. Others are prohibited by law from drawing the samples. And there are for the entire state, my lords, including administration of the entire department at the district level, inspection of all the drugs and pharmaceutical outlets, their godowns, manufacturing
So file
facilities.
your objections
Yes, ma'am.
tomorrow. And
Yes,
call
ma'am.
this matter tomorrow. It's a sensitive matter.
Please, ma'am, please.
Tomorrow.
Like day after, my lord.
No.
Instructions to
You notice? Call day after.
oblige.
Day after. ನಾಡಿದ್ದು ಹಾಕೊಂಡಿದ್ದಾರೆ ಸರ್.
Day after it will come.
Because tomorrow is a holiday, they think.
Likely to be. Yes. Yes.
In this matter, my lord, I want to file the memo with the orders of the Supreme Court
ಅವ್ರಿಗೆ ಒಂದು ಕಾಪಿ ಬಸವರಾಜು ಕೊಟ್ರಾ?
as well as the SLP, my lord, filed in that
No,
case.
but why they are not served in advance? ಅಲ್ಲೇ ಕುತ್ಕೊಂಡಿರಿ ಇಷ್ಟೋ ತನಕ. ಈ ಕೊಟ್ರೆ how he should read?
Sorry.
Actually, he was here.
No. I'm sorry. I can only apologize.
But
That should have been served earlier.
like
But anyway, they were entered appearance in that matter, not Mr. Basuraj, of course.
somebody,
We are aware of all this, no problem.
But not
ನಾವು ಒಂದು ನೋಡ್ತಾ ಇದೀವಿ ಬಾರ್ನೆ ಇಲ್ಲಿ ಕುತ್ಕೊಂಡು ಲಾಸ್ಟ್ ಮೂಮೆಂಟಿಗೆ ಅಬ್ಜೆಕ್ಷನ್ ಕಾಪಿ ಕೊಡೋದು ಹಿಂಗೆಲ್ಲ ಯಾಕೆ ಹಿಂಗಿದೆ ನೋಡಪ್ಪ ದಿಸ್ ಓಪನ್ಲಿ ಹಿಂಗಿದೆ.
ಅದೆಲ್ಲ ಮೊದಲು ಮುಗಿಸ್ಕೊಂಡು ಆಮೇಲೆ ಬರ್ಬೇಕು. ಸ್ವಲ್ಪ strategic.
Even the list of authorities, my lord, His Lordship Justice Arvind Kumar said,
ಕೊಡ್ಬೇಕು.
serve in advance.
ಮಾಡ್ಕೊಂಡು ಆಮೇಲೆ
Not only the fact, not only the facts, even the legal position which
Correct.
you are arguing,
As
disclose.
if-
Let the light come from all the sides, not the heat,
Correct.
not the heat.
Correct.
That's what
It
Justice
is,
Krishna.
I believe,
Small.
it is as if to show a proof to the court.
ಅಂತ
Serve ಮಾಡಿದೀವಿ ಅಂತ.
ಮಾಡಿದ್ದೀವಿ.
Let the very short question, my lord.
Once, if my learned friend wants to argue the main matter, I have to file my objections.
No,
I've already filed my
this is not fair. The reason is this. They are not even the applicants. The corporate, creditor, he is served with the notice. He initiated the proceeding. They entered the proceedings with the mercy of this honorable court as an intervener. They are claiming some amount. The creditor who filed the application is served with the notice. Now, yesterday, the IRP has taken out a publication in Mumbai Financial Express calling for interest. Now, they have the protection which was granted by your lordship, they questioned before the Honorable Supreme Court, I do not have the protection now. If the appeal is restored on file, the interim order will continue. But they cannot have the cake and eat it to the reason is this. They are not the contesting respondents either before the NCLT or before the NCLAT or even before the Honorable Court.
Now, what orders?
But what happened is this.
Apex court orders, what they say?
But Apex Court has discontinued the order interim protection granted by your lordship and saying that the writ petition should continue. Kindly see the order passed by the page number 3, my lord.
Yeah.
I
think
the contesting respondent is served and the matter is ready for hearing because to protect my interest. My lord, kindly see paragraph 3.
Page
She,
2,
as an interim
take
measure.
Page 2. Let us read each of
Yes,
them.
yes, ma'am. We have been taken through the facts of the present case, including the fact that the earlier writ petition was dismissed on the ground that it should not have been entertained. Lord, I will, for a moment, I'll pass. For immediate necessity, a writ petition was filed when the interim order was granted by the appellate court. It was withdrawn almost. The effect of the impugned order on the corporate insolvency resolution process. Issue notice. Service is waived and notice is accepted on behalf of so and so, so and so, so and so. Hence, notice the next one. As an interim measure, direct that the CRP proceedings will continue in accordance with law, subject to the final outcome of writ petition number so and so, titled Bhaskaran versus so and so, and other connected writ petitions pending before the High Court and the present special petition. Now, the protection which was granted by your lordship is lifted. That this could have been sorted out here. I don't know which Solomon advised them, and it is their prerogative, their money.
How it should be done then?
If the appeal, which was filed by the promoter, is restored on file, then the interim order granted by the appellate authority will continue automatically. They have found fault with your lordship's protection granted to me till the disposal of the writ petition. Now, what has happened is this. The creditor initiated the proceedings under section 9, claiming to be operational creditor. Then NCLT ordered that the appointing the CRP and commencing the process. We filed a writ petition challenging the process for a limited period. The interim order was granted. Now, that writ petition became infructuous when we filed the appeal before the NCLAT. The NCLAT, after hearing the parties, elaborately passed an order staying the proceedings before the NCLT. Then what happened?
What order was taken to
NCLT, the order admitting the petition and appointing the CRP, which commenced the moratorium and all that, which are against me. Therefore, the suspended director of the operational debtor filed the appeal. Suspended director, the operational debtor filed the appeal. Now, the operational debtor, there is an interesting story. Operational debtor is Tarun Realtors. It has two promoters. One is Mantri Developers Private Limited. Another is Virtuous. Now, these two people have about 50% and 49% respectively. Now, Mantri has appointed Mr. Bhaskaran as the director, nominee director. He filed the appeal before the NCLT. Now, when the proceedings were pending before the NCLT, Mr. Bhaskaran resigned. Now, kindly see the predicament. For example, a suspended director files appeal. For whatever reason, he fights with the promoters. Or he is induced to resign. The moment he resigns, the promoter under the Companies Act has an option to appoint a new director. Because the promoters have under section 168, they have the power to. Now, what the appellate authority says, now the suspended director has resigned, the company has become non-existent, the appeal itself is dismissed. Now, in the meanwhile, the Mantri developer, the promoters, filed an application before in the appeal that we will continue the proceedings. That application was not listed on that day. If the application was listed, there could have been an order whether the promoter can continue the appeal or not. The matter is fully covered by the judgment of the Honorable Supreme Court interpreting section 62 of the IBC that any person aggrieved has a wider connotation. It includes those persons who are affected. The promoters are certainly affected. There is a judgment of this Honorable Court which is taken to Supreme Court that against an order passed in the company petition, if the official liquidator does not file an appeal, then the shareholder can file an appeal. But if this, kindly see the predicament. Suppose there is only one suspended director. Suppose he is induced or he fights with the promoters. He resigns, saying that no, I am fed up with this company, or for whatever reason he resigned. Then the company becomes non-existent and the appeal is dismissed and the proceedings will go on, moratorium is lifted, everything. But this is not the intentment of the IBC. Therefore, my lord, the entire gamut of the proceedings before the Supreme Court is whether the promoter can continue the appeal, number one, or can the NCLAT dismiss straight away the proceedings without waiting for the promoter to appoint a substituted promoter and the nominee. nominee director, Mr. Bhaskaran, is resigned. It's like the king is dead, long live the king, and the company is dead, therefore long live the company. Now today, they have initiated the proceedings. They have taken out the paper publication yesterday in Mumbai Financial Express, and the contesting respondent is served. All I'm requesting is, there is a violation of principles of natural justice. On the day when the matter was listed before the
Application was pending,
Yes.
as the date it was dismissed.
yes,
No order is passed on that.
unfortunately, the cause list shows the application was not listed. Therefore, it's only fair that the application should go back to the NCLAT. Let the NCLAT pass an order, appropriate order. Kindly see, my lord, the impugned order was passed on 14/10/2024. The application was filed on 12/10/2024 to bring the promoters on record.
He resigned on,
But he resigned, suspended director resigned on 12/8/2024.
1 second. When the appeal before NCLT was filed?
But NCLT appeal before the I'll give the list of dates. On 20th of July 2023, the NCLT passes an order. Then we filed a writ petition.
What is that order?
The order is, my lord, appointing the CIRP and thereby, my lord, imposing moratorium and all other aspects. Then we filed
This
a
was under section?
under section 9, operation. They are claiming to be
5%.
operational creditors. Now, a writ petition was
Against this,
filed.
1 second.
I'm sorry.
Against this NCLAT appeal you had filed.
In the meanwhile, there was a writ petition, and writ petition, there was an interim order granted because appeal was to be filed. Anyway, appeal was filed, and the NCLAT granted the interim order on 18th of April 2024. 18th of April 2024.
Much due to? No.
He resigns on 12/8.
They
Then
got-
12/8/2024, I will give only two dates I will give. 12/8/2024, two more dates. 12/8/2024, the suspended directors of the operational creditor, debtor resigns.
12/8,
2024, he resigns. Petitioner resigns. Then, my lord, we filed an application to amend the cast title that include the promoter, monthly developers on 12/10/2024.
resigned ಅಂತ
They informed.
They informed.
They informed. 12th of October 2024, we filed the application.
When you came to know that?
Sorry?
When you came to know that he resigned?
That date I'll furnish in a minute. Then 12th of October 2024, we filed the application.
Saying that he has resigned, and
Yes.
therefore we want
Therefore,
to
my lord,
prosecute the appeal
yes,
ಅಂತ.
in the matter of, therefore, seeking a prayer that consequent resignation, therefore just and necessary, the tribunal be pleased to permit the applicant hearing to amend the cast and MD, monthly developers, to continue. The matter was listed on 14/10/2024.
26.
Now I draw your lordship's attention to the order. It's only one paragraph order. Annexure A, page
First one. Which petition you want?
in the writ petition filed by Plaza Agencies, that was the first writ petition, 19137 of 2020.
9137.
Yes, yes, ma'am. In that page 26.
Sorry, in that plot, there's an issue of maintainability of the petition
No,
itself.
now all of them are now. Mr.
not all of
Bhaskar
them
is also
now.
before. I'm only taking the order. I'm only bringing these lordships, the order, my lord. All the three persons are now, Mantri is before the court, Bhaskaran is before the court, Plaza is also before the court. All of them have challenged. Just for the convenience purposes, page 26. Or I can take out the Mantri's writ petition and satisfy my friend. But in that, page 20.
Same order is challenged.
In all the cases.
Same order.
Yes, therefore, my lord, kindly see, my lord, para 26, page 26. Your lordship got it?
Yes.
Yes. The instant company appeal, as it was then preferred by Mr. Bhaskaran, the suspended director of Tarun Realtors, seeks to challenge the NCLT, the impugned order 27/2023 as it was passed in CB number so and so. An interim order was granted initially on 18/4/2024 by this tribunal, which continues to operate. It has been submitted by respondent that appellant Mr. Bhaskaran, suspended director, is now resigned from the post of director on 12/8/2024, and that as a consequence of his resignation, the present appeal is no more maintainable. In
Whole
this
case is that your application ought to have been
considered,
and then main matter ought to have been
Considered.
taken up anta.
and the next sentence is very intense. The appellant has become a non-existing entity. The appellant has become a non-existing entity. The instant appeal cannot be permitted to be sustained and continued. Hence, the same is accordingly dismissed. Interim order granted, stand vacated. Now, I have an option to appoint the director.
You had filed application on 12/10.
Yes, Miller. It was not listed, unfortunately, on 14/10. We have the application. The cause list also does not show. Therefore, the matter has to go back to the appellate authority to consider. Or my friend says that on a larger question of law, whether the promoter can continue, I am ready with at least 3 judgments of the Honorable Supreme Court. Now, kindly see the convenience memo which you are filing.
This order has gone. All orders, interim orders have gone because of the apex court judgment.
Now, what happened? Your lordship said no coercive. Yeah, I am without protection now. Basically, that's the scenario. But in that.
But apex court permitted that we can go on with this.
Certainly.
That's the correct position, Mr. Dan.
Both.
It
It
permitted.
says it is subject to the outcome of the writ petition and the SLP. If your lordships kindly notice the order.
So writ petition we can take.
Cannot state the proceedings. That is
No,
quite.
permitted us to entertain the petition.
Ah.
That will be subject to outcome of the SLP.
Yes.
Of
Pending
course,
SLP.
we have issues with respect to I wouldn't say maintainability in that sense, because maintainability may be wrong to say, but whether your lordship must entertain it or not is an issue which I want to raise before my lord. And as to whether in these 3 petitions, which one your lordships can entertain. That
Whichever.
becomes-
You say we'll take.
Man,
all the
I'll-
three.
No, all 3, in that 2 must go.
Even
straightway.
if 2 go.
One can remain, which is
One
only
can
monthly
remain. Let
development.
us, then if we pass order in one, it's very simple case. The NCLT passed the order on NCLT order 20 July 2023 under section 9.
Yes.
IBC.
Yes.
It is an appealable order,
It has been.
correct?
Correct.
Who can appeal? We will come to that point. Appeal was filed by the suspended director. That director resigns. And on coming to know of that, these petitioners filed an application saying that we want to continue.
Correct.
Prosecute the appeal. Some order ought to have been passed on that before dismissing the appeal itself.
I'll tell you lordship what happened there. No one pointed out the application. That is one thing. Application was still in defects, not even numbered.
But it is filed.
It has been
Once
filed.
it is given in the window, he has no control as to what happens in the indoor.
that they only have control, because they are the ones who have to get the defects rectified and get it listed before the court.
Now, how he will know? See, Justice Ramajoy said,
Yes.
no court can say that we will not receive the application. You have to receive the application. They received the application. The registry ought to have placed it before the tribunal, appellate tribunal. For the fault of registry, what should happen to that application? We are not saying now. It is for him to fight the battle there. And you perhaps argue, maybe your client also will oppose it there. That's another thing. How can appeal be disposed of without treating the application? Maybe your application could have been dismissed with costs.
Yes.
But where is the treatment of the application?
No, I agree, my lord. But the only circumstance in which you can then deal with that scenario is by either filing an appeal under section 62 before, my lord, the Supreme Court, because that is the statutory remedy provided. And that is one of the grounds, my lord, also raised in our SLP.
Yes.
That should be the only mechanism which should be followed. The second is, you should have made an application for recall of the order, saying this had to be considered. Now, you come to this honorable court and then, my lord, file a petition under 227.
All right.
No,
We are
Just one more.
See, if you say, all right, you complete that also. Third.
227, my lord, cannot be entertained by this court.
On what ground?
Because 227, Lord, is not jurisdiction specific in terms of cause of action.
No, it's a supervisory jurisdiction. All tribunals.
All tribunals
Within
within
the
the
jurisdiction of
jurisdiction
the
of the
High Court.
court, inclined is in Chennai, and therefore it can only be a Chennai High Court which have jurisdiction over it. Unlike a petition under 226, where a part of cause of action can arise here.
No. The NCLT is where?
NCLT is Bangalore.
Bangalore.
N-
Supreme Court say
Madam.
where one tribunal in Bangalore, another in Himachal Pradesh. If that Himachal Pradesh passes the order, Bangalore court will have jurisdiction.
No, true, but in an appellate tribunal, where it is an appellate tribunal's order which is under question, not the first tribunals. NCLT's order, of course, is subject to your lordship's jurisdiction. There is
And
no,
it's a continuing appeal it is.
it is, my lord, but in my humble
Continuation
no,
of
no,
the-
but your lordships don't exercise supervisory jurisdiction because you only exercise supervisory jurisdiction over tribunals within the territory of the jurisdiction of the High Court. Lordship may see 227.
Correct. I understand that. But I think
Sir,
that's
all the
judgment
parties
of
are in
not-
Bangalore. All the parties are in Bangalore.
Parties, my lord, in my humble submission are very little.
Chennai, it is there because
27.
the bench is not in Bangalore, that's all.
My lord, every High Court.
But that writ
One
petition has
minute.
become infracted, it is already dismissed.
1 minute, sir.
I'm
Let me
sorry.
now also have a
Sir,
chance.
just to save some time ಅಷ್ಟೇ ಇನ್ನೇನಿಲ್ಲ.
ಅಲ್ಲ ಅವ್ರು ಹೇಳೋದೇನು ಅಂದ್ರೆ ಬೆಂಗಳೂರು ಟ್ರೈಬ್ನಲ್ಲೇ ಎರರ್ ಮಾಡಿತ್ತು ಅಂದ್ರೆ ಇಲ್ಲಿ ಬರ್ತಿತ್ತು. ಈಗ ಚೆನ್ನೈ ಟ್ರೈಬ್ನಲ್ ಮಾಡಿದ್ದಕ್ಕೆ ಚೆನ್ನೈ ಹೈಕೋರ್ಟಿಗೆ ಹೋಗ್ಬೇಕು ಅನ್ನೋದು ಒಂದು ವ್ಯೂ.
Now, my lord, what-
Tribunals within the supervisory jurisdiction
Yes.
of the authorities.
every High Court, 227, it's like taking coal to Newcastle, but I'll anyway
No,
read
no,
it.
sir, we should read like that. There is no res judicata for reading the law. Any reading for that matter.
Every High Court shall have superintendents over all courts and tribunals throughout the territories in relation to which it exercises jurisdiction.
Tribunals, see how it is worded.
Yes.
Situate within the jurisdiction of the court of law. We can entertain writ petition even if the person or the entity is elsewhere, provided cause of action arises.
That is
here.
226. Lordship can
this
see the
is
language of
interpreted?
226.
All right, what Sirvai says on this? How Mr. Sirvai says that?
So I don't have Sirvai right now.
Anyway, whichever, anyway, any
Of course not.
decision, which is that decision, how it, because it does not say.
Yes, Lord.
Tribunal situate within the jurisdictional limits of the High Court.
Yes.
Wherever we exercise jurisdiction, High Court exercise jurisdiction up to
Yeah.
Jammu Kashmir, Ladakh also. How courts have said.
Please see the latest, right? There are a number of them, but give them also a copy.
Which paragraph, which
Now,
decision?
would your lordship kindly take page 135, Ibrat Faizan. This is not the one.
135.
Para 22, my lord.
27. 27. ಎಲ್ಲಿದೆ? Petition ಏನಾದ್ರು?
Page 146. May I just read para
Last but two
22 and
paragraphs.
23? In view of the above, in the present case, High Court has not committed any error in entertaining the writ petition on 227 of the Constitution against the order passed by the National Commission which has been passed in appeal under so and so. We are in complete
High
agreement.
Court passed that order.
Delhi High Court.
Yes.
Delhi High Court. We are in complete agreement with the view taken by the High Court. However, at the same time, it goes without saying that while exercising the power under 227 of the Constitution, High Court subjects itself to the rigor of 227, and the High Court has to exercise jurisdiction under 227 within the parameters within which such jurisdiction is required to be exercised. Scope and ambit of 227 of the Constitution has been explained with this court in Estrella Rubber, which has been consistently followed by this court. Therefore, while exercising the powers under 227, the High Court has to act within the parameters to exercise power under 227 of the Constitution. It goes without saying that even while considering the grant of interim relief or stay in a writ petition under 227 of the Constitution, High Court has to bear in mind the limited jurisdiction of superintendents under 227. Therefore, while granting any interim relief in a writ petition under 227,
Not on territorial jurisdiction at all.
of course,
Judgment is not an authority
yes,
for the
I agree.
territorial
It's
jurisdiction.
not.
Not.
But not,
It is a substantive jurisdiction. How court can
I'll-
exercise?
yes,
Where is the judgment which says, because I read, during my college days, I read a few decisions, which Professor K.N. Seshadri used to very often tell this one. Where the jurisdiction of the High Court, even under 227, is founded on location of the tribunal or on the cause of action.
Please see the difference in 226 and 227 in the language,
Correct. Language does not say, Mr. Dan.
my lord.
Very
I'll-
carefully they have crafted
I'll,
the text of
It is-
226.
it is like, it emanated from Bangalore.
Correct.
It went to Chennai because the NCLAT is
Is
in
in
Chennai,
Chennai.
not in Bangalore.
We don't
just
have
to
the-
give your lordships an example, my lord. State Consumer Forum passes an order against which an appeal is filed to the National Consumer Forum. Against which, my lord, in some cases there is an appeal to Supreme Court, in some cases there are no appeals.
No, National
The
Commission
question is-
appeals all come here.
Yeah.
After appeal, challenge is here. I think
Not
there is
under,
a judgment
no,
of the.
not under 227, it is under 226. The writ petitions, my lord, which is challenged under 226 can certainly come before your lordships. I don't dispute that at all. But challenges under 227 are location specific. That judgment doesn't answer the question, I'm sorry, but I can place before my lord other authorities, which your lordship have it in the afternoon or day after. I will place those authorities before my lord.
Okay.
And I'll also file a short statement, my lord, of objections.
Tomorrow, madam. Now.
Tomorrow is a holiday in Karnataka.
Ah,
Day after. So what the news says, my lord, I'm not sure.
But that's what.
Day after, my lord, I'll file that short statement and the judgments before your lordship.
Thursday morning is there. All right. Call day after.
One another angle, Millers.
Ah.
The NCLAT is jurisdiction. Spreads across other NCLTs.
NCLT jurisdiction.
NCLAT is jurisdiction is over
Southern states.
others, there are 4 or 5 states.
Correct.
Then
That supports our view now.
You, that's why. Because of that.
Anyway, just like,
I'll
I feel there is a judgment, Swaraj. There is
So
a
vice
judgment.
versa. you
Yes,
like the-
Lord, this Anadimukta
Also,
Sad,
by
that
NCLAT,
Anadimukta
which is sitting in
Sadguru,
Chennai,
so
has
the
jurisdiction
longest
here.
cast title judgment,
Okay.
wherever injustice, but 226 and 227 strikes. But it's too late. I will give an example. Under the Advocates Act, against the order of the Bar Council, appeal lies to the
Central Bar Council.
Bar Council.
Order
Against that,
passed
there is a
again High
statutory,
Court.
there is a statutory appeal to the Supreme Court. But against the revisional order passed by the Bar Council of India, writ petition lies before this court because the cause of action, the parties are here.
How?
But it is-
I
but-
read that, but at least we'll have, now Mr. Dan is making
But
that
these,
way. If it is 226, yes, but not 227.
I'll answer your letter. The reason is this, but we could not have the bench in Bangalore. But now big fight is going on to bring it also in Bangalore. Suppose if it is
All
Bangalore,
practical purposes, it is
should
Bangalore.
have every departments, ever major departments are in Chennai. No, we are deprived. That is the that's a larger issue.
Then my life would be clear. We would have had a lot more writ petitions before your lordships. From all other states would have come here.
It happens, happens.
But
But,
if I'm right.
argument is.
If my argument is right,
They
then everything will come here.
Chennai, Kerala, all
Yes,
those.
no,
things will come.
then the test would
Then
be,
not,
where is the tribunal? NCLT, where is the NCLT?
tribunal will decide.
NCLT.
In Bangalore.
yes, but
Or-
But it's
How that.
ready. But it's too late, day in and day out. If something is not heard, the matter will go back. That ultimately, my lord, all these arguments can be resolved before the NCLAT.
according to me, they should file an appeal before the Supreme Court. Section 62 provides for it from every order.
No,
Now, if your lordships have to exercise jurisdiction under 227, the contours and parameters your lordships will have to decide. The second point, of course, Supreme Court is also looking at the same question.
ಅಲ್ಲ ರಿಕಾಲ್ ಹಾಕ್ಲಿಕ್ಕೆ ತೊಂದ್ರೆ ಇದೆಯೇನು
Recall
Really?
ಆಗ್ಲಿ, ಅಲ್ಲೇ.
ನಾವು ಪರ್ಮಿಟ್ ಮಾಡಿ
CLAT.
ರಿಕಾಲ್ ಅಪ್ಲಿಕೇಶನ್ ಇವ್ರು ಹಾಕ್ತಾರೆ ಅದನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡ್ರಿ ಅಂತ
The reason is this, blood. It's
ಅಲ್ಲ,
day in and a Tahsildar without consent passes an order, straight away your lordship quash it and
No, no,
hear
that's
it.
not it. That's another thing. We are asking you. We are working out some alternate patterns.
Yes, yes, yes.
Suppose we permit you and direct the NCLT to receive your application for recall and consider it on merits.
Here ends the matter.
Which you
That's the
suggest.
matter.
Lords may have day after, I find out.
There ends the matter.
ಇಷ್ಟೇ ಇರ್ತದೆ.
That's all, that's all.
Asking, we are telling him, you go before the NCLT.
Certainly, that's all I want.
And make the application for recall.
Certainly. But there is a forum.
Larger issue have raised.
Then
ಅದ್ರ
two,
ಸಲುವಾಗಿ ಬೇರೆ ಆಗುತ್ತೆ.
two matters your lordship may dispose of. That is Plaza and Bhaskaran, because both of them can't really file.
All right, anyway, one matter.
Company developers.
Mantri developers is the promoter.
Got it.
Let that writ petition can be
All
disposed of.
these three applications seek to lay a challenge to the
Your Lordship,
order of
disposing-
the
Yes,
NCLAT, which whereby the subject appeal was dismissed on the ground that the appellant Shri Bhaskaranna
Yes, ma'am.
Bhaskaran,
Petition, yes, sorry, sir.
Appellant.
appellant, Bhaskaran had resigned to the, from the office, resigned to the office in question. First. Learned senior advocate, Mr. Be seated, kindly be seated. Learned senior advocate appearing for the petitioners submits that regard being had to the scope of right of appeal availing under section ಯಾವ್ದದು 61 of the IBC, comma, the promoters too could have prosecuted the appeal, and therefore they had filed application seeking leave of the court to prosecute the said appeal on 12/10/2024, semicolon, without even adverting to the said application, comma, 2 days thereafter, that is on 14/10/2024, the impugned order has been passed. Correct?
Yes.
14/10/2020 passed. ಕೂತ್ಕೊಂಡೆ ಹೇಳಿ. Semicolon. Where an application is filed, application of the kind is filed, it's the duty of the court or the tribunal to pass orders thereon before taking up the papers of the main matter. Semicolon. This having not happened, the impugned order is liable to be voided. First. Learned senior advocate, Mr. Dan, appearing for the intervener.
Now I'm a respondent. I've been impleaded as a respondent.
For impleaded respondent.
Number? Numbers, what numbers?
Opposes the petitions contending that under Article 227 of the Constitution, in contradistinction to Article 226, comma, it's only the Madras High Court arguably could have had supervisory jurisdiction, since the NCLAT is situated in Madras jurisdiction, within the jurisdictional limits of Madras High Court. Semicolon. He also alters the filing of petition contending that the petitioner could have moved a recall application before the tribunal itself.
Or an appeal.
Semicolon.
Or an appeal before. Supreme
Further, he points out that against the order in question, an appeal lies to the apex court, and therefore this court should not grant indulgence in the matter. First. Next paragraph. Having heard the learned counsel for the parties and having perused the petition papers, we are of the considered view that the petitioner, comma, as rightly pointed out by Mr. Dhan Chinnappa, could have filed a recall application before the NCLAT itself. Taking up the contentions which have been now traded in this petition. First, the recall application can be treated as an alternate remedy for declining indulgence in the matter. First, that being said, it needs to be made clear that if the petitioners file the recall application within a period of 2 weeks from this day, comma, the same shall be heard and decided by the tribunal. First, in that connection, all contentions of the parties are kept open. First.
Because in all fairness, I must point out, in para 16 of the monthly petition, they have said they moved the Supreme Court also.
taken
Cut and paste
appropriate
problem
steps.
ಇದೆಲ್ಲ.
You can take up that contention.
Well, that they have challenged that order. If they've challenged the order in an appeal, I don't know, my lord. They've said specifically in the writ petition that they filed and they've taken appropriate steps to challenge it.
Petition has also instituted appropriate steps to file appropriate application.
To file.
Possibility after possibility.
Have you filed one?
No,
Not filed. All right. All, this cost paid is. ಅಲ್ಲಿ ಒಂದು ಪ್ಯಾರಾಗ್ರಾಫ್ ನಲ್ಲಿ ಮೆನ್ಷನ್ ಅಬೌಟ್ ಅಪೆಕ್ಸ್ ಕೋಡ್ rescinding our order. Okay.
Resume to oppose Mr. Jan.
And see, here is there is a final aspect actually.
Our contours.
When it comes to 226, yes, but not 227.
We go back and now research for a different matter.
In every matter, we have to do that only.
I may be permitted to file memo of appearance for the respondent number 1 in all matters.
Ah,
But my problem is ARP has already published yesterday.
ಇಲ್ಲೇ ಕೇಳಿ
ಅಲ್ಲೇ ಕೇಳು.
ಅಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಹೆಂಗು
ಬರ್ಕೊಳ್ಳಿ. It is also
Go ahead,
open to
bring to the
the
notice of-
petitioner to seek appropriate interim protection if grounds do exist therefore.
If the appeal is restored, the earlier order is revised.
Anyway, even in application also,
Yes.
recall application, that power may be.
ಇರ್ಲಿ the suspended director is appointed by ಮಂತ್ರಿನಾ?
Yes. Was appointed.
ಅಲ್ಲ, ಅವರು he has resigned.
They have power to appoint.
But he resigned to ಮಂತ್ರಿ.
He resigns to the company, my lord.
Company itself.
Company is Tarun Realtors.
Tarun-
So when he resigns as the director of Tarun Realtors, the company which is under CIR.
I may permitted to file.
But in that, ಮಂತ್ರಿ was having a shareholder.
Mantri is a shareholder apparently.
Shareholder, on its behalf, he was appointed.
Yes.
Nominated, yes. That's what they say, my lord. We do not know. That is
They
their
have-
case.
Prima facie,
Anyway,
it
but
appears that
it-
they have a right to appoint another. director.
Allah, that is not, can't be done. That can't be done. Once a resolution starts under the IBC code, the right of the shareholder to appoint a director is taken away. They don't have any right.
Do you agree the suspended, Mr. Bhaskaran had right of appeal?
He had a right. That he had.
Then it goes without saying that others also will. If he has right of appeal,
The
for
promoter-
those who are having larger stake in the matter, will
That
not
is
have.
I personally agree with my lord.
Of course.
What
we
I'm
have-
saying is, NCLAT has taken a view. This is Mukhopadhyay, as he then was my lord of
Gujarat Supreme Court.
Supreme Court. He was the president of NCLAT. He's taken a view. I mean, I don't know if it's right or wrong, but he's taken a view that the shareholder cannot come, only a director can come.
He is representing the shareholder.
Allah, I know, but that's the view taken. I'm just saying, I'm not
But
saying
if
anything.
the
about directors.
director is not there, then
Shareholder can come.
it has the right to appoint another person.
If you want to ask me personally, my lord, out of context of this case, I'll say
Yeah,
yes.
a shareholder, let us say some gamut of shareholder, they don't have any voice there. They have a stake there.
Under 167.
Correct. I agree with you.
168(3) minutes of the Companies Act provides for
But
promoter to appoint the director. In the absence of any promoter, central government can appoint the,
So I
Director.
will appoint promoter.
in the absence.
You go with an appointment only.
Allah, you appoint ಮಾಡಕ್ಕಾಗಲ್ಲ ಈಗ.
No, no, we are making.
I know,
extended
but I'm
drastic.
saying now he can't appoint. Once the company is admitted, it becomes proceeding in rem, and therefore you cannot pass any order.
For
One
some
intelligence-
humor, we said that.
It is indicating the.
And then
No, for that again, there should not be escalation.
maybe many stages.
On intelligence matters, I may permitted to file wakalat,
Alright.
MOA for respondent 1 in all matters.
Permitted to.
Okay.
Name is shown, but yet to file the MOA matters.
All right, we're permitted to file the MOA, memorandum of appearance,
Yes,
memo of
within-
appearance within
Publish.
4 weeks. Over, all three petitions, no.
Petitioner.
Yeah. ನೋಡಿ ಮೈಕ್ ನಲ್ಲಿ ಮಾತಾಡ್ಲಿ ಅಂದ್ರೆ ನಮ್ಗೆ ಸಿಟ್ಟು ಬರ್ತದೆ ಆ ಒಂದು ಗ್ರೌಂಡ್ ಮಾಡ್ಕೋತೇವೆ ನಾವು ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಲಿಕ್ಕೆ
Application for dispensation.
ಡಿಸ್ಮಿಸ್ ಎಸ್
Removal from service.
ಸ್ವಲ್ಪ ಜೋರಾಗಿ ಮಾತಾಡ್ಬೇಕು.
Petitioner removal from service.
ಹಾ.
Petitioner removed from service for unauthorized absent for 55 days without leave.
5 days.
55 days.
Why he
55.
was absent?
Mother was not keeping well, my lordship.
Whether not keeping even.
Yes, my lordship.
Do son,
Son, my lordship, son.
where have you stated that?
In the
Your defense.
in the reply, my lordship.
Yes.
In page number 39, typed copy of 41, my lordship.
41.
41.
ತನ್ನ ತಾಯಿ ಅನಾರೋಗ್ಯದಿಂದ ಏನಾಗಿತ್ತು ತಾಯಿಗೆ?
Is not keeping well anta they stated.
ವಯಸ್ಸೆಷ್ಟು?
I permitted to read last paragraph.
He was appointed on compassionate ground, your lordship,
That's right.
as a guard.
Correct.
And he did not serve for 1 day he has taken leave, your lordship. He remained absent for 13 days. Thereafter, next day he appears, he attends to the duty. Again, he will disappear, lordship. Then in the, when the, demand was, claim is made, your lordship, he says that it because of ill health of mother, he could not appear. Now, your lordship may kindly see the reason assigned. Lordship.
No,
may
did you ascertain whether mother was well or not?
ಆದ್ಮೇಲೆನೂ he does not come and attend to the duty.
ನೋಡಿ,
Your lordship, up to 3.
we understand that.
Please, lordship.
What is the grade? ಅವನು ಏನು? ವಾಚರ್.
ಅಲ್ಲಲ್ಲ, ಹಾಗೆ ಆಗಿಲ್ಲ, ಸ್ವಲ್ಪ ಪ್ರೊಬೇಷನ್ ಅಲ್ಲಿ ಇದ್ರು ಅವರು. He was in probation, lordship may kindly.
ತಾಯಿಗೆ ಆರಾಮಿಲ್ಲ.
ಅಲ್ಲ, not that. That is later. First, your lordship, he was not at all interested to attend to the duty. He wanted a transfer. And your lordship may kindly appreciate that para 60, page 16, your lordship.
Correct.
Page 16.
ಕರೆಕ್ಟ್. ಅಂತವ್ರಿಗೆಲ್ಲ ನೀವು ತೆಗೆದ್ಬಿಟ್ರೆ ಮುಂದೆ ಜೀವನ ಮಾಡೋದು ಹೆಂಗೆ? ಆಮೇಲೆ ನೋಡಿ ನಮ್ಮ
ಅಲ್ಲ, ಅವ್ರು ಹೋಗ್ಲಿಕ್ಕೆ ತಯಾರಿಲ್ಲ.
ಅದಕ್ಕೆ ಈಗ ಹೇಳೋಣ,
I'm ready to.
ಅದನ್ನ ಡೈಸ್ ನಾನ್ ಮಾಡಿ ಆ ಪೀರಿಯಡ್. ಸಿ,
2007, your lordship.
ಜನನಿ ಜನ್ಮ ಭೂಮಿಶ್ಚ ಸ್ವರ್ಗಾದಪಿ ಗರಿಯಸಿ. ತಾಯಿ ಮತ್ತು ತಾಯ್ನಾಡು ಸ್ವರ್ಗಕ್ಕಿಂತ ಹೆಚ್ಚಿನದು ಅನ್ಕೊಂಡು ರಾಮ ಹೇಳ್ತಾನೆ ಲಕ್ಷ್ಮಣಗೆ. ಡು ಯು ನೋ ದಟ್ ಇನ್ ರಾಮಾಯಣ?
Please.
ಹಾ,
ಅದು ಬರೀ 3 days ಗೆ. ಆಮೇಲೆ ಬರಲಿಲ್ಲ. Again, he did not turn up and he did not produce any document.
ಕೇಳ್ಕೊಳ್ಳಿ.
Please.
ರೀಡ್ ರಾಮಾಯಣ.
Please.
ರೀಡ್ ಅವರ ಕುವೆಂಪುಸ್ ರಾಮಾಯಣ ದರ್ಶನಂ ಎಷ್ಟು ಚೆನ್ನಾಗಿದೆ. ಲಕ್ಷ್ಮಣ ಸೇಡ್, ಭರತ ಆ ಟೈಮ್ನಲ್ಲೆಲ್ಲ ತುಂಬಾ ಒಳ್ಳೆಯವನಿದ್ದ. ನಿನ್ನ ಪಾದಕ್ಕೆ ತಲೆ ಮೇಲೆ ಹೊತ್ಕೊಂಡು ಬಂದು ಅಣ್ಣ ವಾಪಸ್ ಬಂದ್ಬಿಡು ಅಂತ ಹೇಳ್ದ. ಹೋಗ್ಲಿದ್ದಕ್ಕೆ ಯು ಸೆಂಟ್ ಯುವರ್ ಪಾದುಕ ಅಂಡ್ ಹಿ ರ್ಯಾನ್ ದಿ ಗವರ್ನೆನ್ಸ್. ಈ 14 ವರ್ಷ ಪೊಲಿಟಿಕಲ್ ಪವರ್ ಹಿ ಹ್ಯಾಸ್ ಎಂಜಾಯ್ಡ್. If both of we go there, don't be under the impression that he would show same deference, same respect, love, affection. And Lanka is so beautiful. We have vanquished Ravana. Let us, and people are saying that you should rule kingdom. Rama said that. Janani janma bhumischa swargadapi gariyasi. No, nothing what mother and motherland. He has given a reason now. ಏನು ದೆಬ್ದ ಆಫೀಸ್ ಏನ್ ಡೆಪ್ಯೂಟಿ ಕಮಿಷನರ್ ಅಲ್ಲ.
ಅಲ್ಲ, ಅದಕ್ಕೆ ರೀಸನ್ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ. ನಾಟ್ ಓನ್ಲಿ ಆನ್ ದಟ್ ಗ್ರೌಂಡ್. ಲಾರ್ಡ್ಶಿಪ್ ಮೇ ಕೈಂಡ್ಲಿ ಸಿ, he attended on 13/6/2003. He has taken leave for 1 day. Then he remains absent for 15 days. Again, your lordship, on 29th he will work. Then again he will go on leave, your lordship, without information, without giving a information. And
ಇನ್ಮೇಲೆ ಹಾಗೆ ಮಾಡಿದ್ರೆ
then again, without any leave, lordship may say, on probation he was there.
Correct.
He was on probation. Then again, your lordship, he sends a telegram saying that his mother is ill. Thereafter, he never turns up. When the notice is issued also, your lordship may see, he admits that he will.
ಟರ್ಮಿನೇಷನ್ ಬೇಡ. Some other.
ಅಲ್ಲ, probation ಅಲ್ಲ ಇದ್ದಾರೆ. Probation within 2 years.
ಬ್ಯಾಕ್ಟೀರಿಯಾ ವೈರಸ್ಗಳು ಏನು ರಜಾ ತಗೋತಾವ. ಪ್ರೊಬೇಷನ್ ಅಲ್ಲಿ ಇದಾನೆ.
ಅಲ್ಲ, ಅವ್ರು ಹೇಳ್ತಾರೆ ಕೆಲಸನೇ ಮಾಡ್ಲಿಕ್ಕೆ ನನ್ಗೆ ಆಗೋದಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
ಎಲ್ಲಿದೆ?
That is what he says, your lordship may kindly appreciate.
Posing major punishment.
ಆಮೇಲೆ he blames the authority, saying that deliberately they have posted him to that ಇದು. On that ground it was done, your lordship may kindly appreciate. 16, page 16, your lordship. Para 16, your lordship. ಅವನ ಕುಟುಂಬ ಹಿಂಸೆ ನೀಡಲು ಉದ್ದೇಶದಿಂದಲೇ ಅವರನ್ನು ಮಡಬುದು ಗಸ್ತಿಗೆ ನೇಮಕ ಮಾಡಲಿಕ್ಕೆ ಎಂದು ನೇಮಕಾತಿ ಪ್ರಾಧಿಕಾರವನ್ನೇ ನೇರವಾಗಿ ದೂರಿರುತ್ತಾರೆ. ಇಟ್ಸ್ ಆನ್ ಕಂಪ್ಯಾಷನೇಟ್ ಗ್ರೌಂಡ್ ಅಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ.
ಅವರಿಗೆ ಬೇರೆ ಒಂದು ಬೇರೆ ಒಂದು ಪನಿಷ್ಮೆಂಟ್ ಕೊಡಿ. Some punishment.
ಅಲ್ಲ ಪ್ರೊಬೇಷನ್ ಅಲ್ಲಿ
Lesser
ಏ,
punishment,
ಹಂಗನ್ನಕ್ಕಾಗಲ್ಲ.
lesser punishment, please.
Lesser punishment. ಅವನು ಆ ರೀತಿ ನೀವು ಸ್ಲೆಡ್ಜ್ ಹ್ಯಾಮರ್ ನಿಂದ ಹೊಡೆದು ಬಿಟ್ರೆ ವೇರ್ ಹಿ ಶುಡ್ ಗೋ.
ಅಲ್ಲ
Poor fellow.
page 42.
42.
40. ಅಲ್ಲಿ ಎನ್ಆರ್ ಪುರದಲ್ಲಿ ಅವ್ರು ಕಳ್ಸಿರೋದೆ ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು ಚಿಕ್ ಫಾರೆಸ್ಟ್ ನನ್ ಕೆಲಸ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗೋದಿಲ್ಲ. ದಟ್ ಈಸ್ ಮಿನಿಮಮ್ ವೇರ್
ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ?
ಲಾರ್ಡ್ಶಿಪ್ ತಮ್ಮಲ್ಲಿ ನಿವೇದಿಸಿಕೊಳ್ಳುವುದೇನೆಂದರೆ ತಾವು ನನ್ನನ್ನು ಎನ್ಆರ್ ಪುರ ಬಿಟಿಗೆ ನೇಮಿಸಿದಲ್ಲಿ ಅಥವಾ ಶಿವಮೊಗ್ಗಕ್ಕೆ ಹತ್ತಿರುವ ಅರಣ್ಯ ಇಲಾಖೆ ನೇಮಕ ಮಾಡಿ ನಾನು ಪ್ರತಿದಿನ ಆರೋಗ್ಯ ತಾಯಿಯ ತಂಗಿ ನೋಡಿಕೊಂಡು ಹೋಗುವ ಆಗುತ್ತಿತ್ತು. ಸರ್ಕಾರದವರು ಅನುಕಂಪದ ಆಧಾರದ ಮೇಲೆ ನೇಮಕಾತಿ ಮಾಡಿದ ನನ್ನ ಕುಟುಂಬಕ್ಕೆ ಅನುಕಂಪ ಅಥವಾ ನನ್ನನ್ನು ಅತಿ ದೂರದ ಮತ್ತು ಅರಣ್ಯ ಬಗ್ಗೆ ಎಳ್ಳಷ್ಟು ಮಾಹಿತಿ ಇಲ್ಲದ ಹಾಗೂ ಯಾರಿಗೂ ಕೆಲಸ ಮಾಡದ ಅಪಾಯದ ಸ್ಥಳಕ್ಕೆ ನೇಮಕ ಮಾಡಿರುವ ಸಮಂಜಸವೇ ಎಂಬ ಅಂಶವನ್ನು ತಾವು ಪರಂಪರಿಸಬೇಕಾಗಿ ತಮ್ಮ ಬೇಸರದ ವಿನಂತಿಸಿಕೊಳ್ತಾರೆ.
ಲಾಸ್ಟ್ 3 lines ಓದಿ.
ಮೇಲೆ ವಿವರಿಸಿದ ಕಾರಣದಿಂದ ನನ್ನ ಮೇಲೆ ಹೊರಿಸುವ ಆರೋಪವನ್ನು ನೇರವಾಗಿ
41. Come to 41.
ಪ್ಲೀಸ್ ಲಾರ್ಡ್ಶಿಪ್.
ಲಾಸ್ಟ್ 4 lines.
ಲಾಸ್ಟ್ 4.
ಹಾ.
ವೇದಿಕೆ ಚಿಕಿತ್ಸೆ ನೀಡಬೇಕಾಗಿರುವ ವಲಯದ ಅರಣ್ಯ ಅಧಿಕಾರಿಗಳಿಗೆ ತಿಳಿಸಿ ದಿನಾಂಕ 14/9/2000 28/9/2006 ಮತ್ತು ದಿನಾಂಕ 30 25/10/2 ಮಂಜೂರು ಮಾಡುವಂತೆ ಕೋರಿ ತಾಯಿ ಸುಶೇಷಿಗೆ ಬಂದಿರುತ್ತೇನೆ ಅಂತ ಹೇಳ್ತಾರೆ.
ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀವಿ? 41 ಟೈಪ್ಡ್ ಕಾಪಿ.
ಪ್ಲೀಸ್ ಲಾರ್ಡ್ಸ್, ಐ ಆಮ್ ರೀಡಿಂಗ್.
42 ಏನ್ರಿ ಎಷ್ಟು ಪೇಜ್ ನಂಬರ್?
ಇಲ್ಲ 41.
ಎಷ್ಟು ಪೇಜ್ ನಂಬರ್ಸ್ ಇದಾವೆ ನಿಮ್ ಪಿಟಿಷನ್ಗೆ? Substandard advocacy. Come to the typed copy A2 ಅಂತ ಬರ್ರಿ, ಅದಕ್ಕೆ ಯಾವ ಪೇಜ್ ನೋಡ್ಕೊಳ್ಳಿ.
41.
Petition is as shall be as
41. A2. Typed copy.
ಅದೇ ತಾಯಿಯ ಶುಶ್ರೂಷೆಗಾಗಿ
ಹಾ.
ಬಂದಿರುತ್ತೇನೆ ಅಂತ
ನನ್ನ ತಾಯಿ ಆರೋಗ್ಯ ಪರಿಸ್ಥಿತಿ
ಬಟ್ ನೋ ಡಾಕ್ಯುಮೆಂಟ್ ವಾಸ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್.
ಹೇಳಿ, ಓದ್ಲಿಕ್ಕೆಲ್ಲ ಬಿಡ್ಬೇಕಲ್ಲ, ಬರೀ ನಿಮ್ದ ಹೇಳ್ತೀರಾ ಏನು? ನನ್ನ ತಾಯಿ ಆರೋಗ್ಯ ಪರಿಸ್ಥಿತಿ ಅತಿ ಗಂಭೀರವಾದ ಕಾರಣ ಕ್ರಮವಾಗಿ ಮತ್ತು ಆಗಾಗ ವೈದ್ಯಕೀಯ ಚಿಕಿತ್ಸೆ ನೀಡಬೇಕಾಗಿರುವುದರಿಂದ ವಲಯದ ಅರಣ್ಯಾಧಿಕಾರಿಗಳಿಗೆ ತಿಳಿಸಿ ದಿನಾಂಕ 14/9/2000 ಸೆಪ್ಟೆಂಬರ್ 2006 ನಂತರ 30/9/2006 25/10/2000 ರಜೆ ಮಂಜೂರು ಮಾಡುವಂತೆ ಕೋರಿ ತಾಯಿ ಶುಶ್ರೂಷೆಗೆ ಬಂದಿರುತ್ತೇನೆ.
No leave was there, Lordship, no permission was taken, but
ತಾಯಿ
he had
ನೋಡ್ಕೋಬೇಕು.
stated it.
ನೀವು
There's only
ಸೀನಿಯರ್
stated-
ಸಿಟಿಜನ್ಸ್ ಆಕ್ಟ್ ಏನ್ ಹೇಳ್ತದೆ? What your senior citizens act says, there is a duty to look after the parents.
ಅಲ್ಲ ಇವ್ರಿಗೆ ಹೋಗ್ಲಿಕ್ಕೇನೆ ಅಲ್ಲಿಗೆ ಇಷ್ಟ ಇಲ್ಲಲ್ಲ ಸುಮ್ಮನೆ, ಅದು ಪ್ರಾಬ್ಲಮ್ ಆಗಿರೋದು. For that reason he is finding these
ಬೇರೆ ಏನ್
reasons
ಪನಿಷ್ಮೆಂಟ್
ಅಂತ.
ಕೊಡ್ಬೋದು ನೋಡಿ.
This is the only reasons he is finding just to avoid
ಬೇರೆ ಪನಿಷ್ಮೆಂಟ್ ಏನ್ ಕೊಡ್ಬೋದು ನೋಡಿ, ಹೇಳಿ.
probation ಅಲ್ಲಿ ಇದ್ದಾರೆ.
ಇರ್ಬೋದು ಇದ್ರೆ
ಅದು ಈಸ್ ಅನ್ಸೂಟೇಬಲ್ ಅನ್ನುವಂತ ಗ್ರೌಂಡ್ ಮೇಲೆ ನೀವು ತೆಗೆದಾಕ್ಬೋದು.
ಹಾ.
ಈ ಗ್ರೌಂಡ್ ಮೇಲೆ
ನಾಟ್ ಆನ್ ದಿಸ್.
ಅದಕ್ಕೇನೆ ಟ್ರಾನ್ಸ್ಫರ್ ಕೇಳಿದ್ದಾರೆ, ನಮ್ಗೆ ಆಗೋದಿಲ್ಲ ಅಂತಾನೆ ಹೇಳಿದ್ದಾರೆ.
He is not catching the point.
ಕಂಪ್ಯಾಷನೇಟ್
I got it.
You are not catching the service law point
ಅಂತ
at all.
ಹೇಳೋದು ಅದಕ್ಕೆ.
I got it.
Compassionate appointment ಯಾಕೆ ಕೊಟ್ಟಿರಿ ಅಂದ್ರೆ ಫ್ಯಾಮಿಲಿ ಶುಡ್ ನಾಟ್ ಡೈ ಅಂತ.
ಹೌದು.
ಇದನ್ನ ಮಾಡಿದ್ರು ಫ್ಯಾಮಿಲಿ ವಿಲ್ ಡೈ. The object of granting compassionate appointment will be defeated by order of the kind ಅಂತ ರೂಲಿಂಗ್ಸ್ ಇದೆ. ಜಸ್ಟಿಸ್ ರಾಮಜೋಯಿಸರ ಇದರಲ್ಲಿದೆ, ಸರ್ವಿಸಸ್ ಅಂಡರ್ ದ ಸ್ಟೇಟ್ ನಲ್ಲಿ.
Leave it to the court.
ಯಾವ್ದು ಕೊಡ್ಬೋದು ಅಂತ ಹೇಳಿ ಪನಿಷ್ಮೆಂಟ್ ಯಾವ್ದು ಕೊಡ್ಬೋದು? ಬೇರೆ ತೀರಾ ಹಂಗ ಬಿಡೋದು ಬೇಡ, ಇವನ್ನ ಏನೋ ಒಂದು ಮಾಡಿ ಕಳ್ಸಿ.
Holding back wages.
Again 2007 ಅಲ್ಲಿ ಆಗಿದೆ ಸ್ವಾಮಿ.
ಎಷ್ಟು ವರ್ಷ ಈಗ ಅವನಿಗೆ?
ಆಲ್ಮೋಸ್ಟ್ 20
ಹ?
ಆಗ್ಲೇನೆ 16 ವರ್ಷ ಆಗಿದೆ ಡಿಸ್ಮಿಸಲ್ ಆಗಿ.
16 ವರ್ಷ.
ಹೌದು.
ದೇರ್ ಫಾರ್ ಕಂಪ್ಯಾಷನೇಟ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಏನು ಪರ್ಪಸ್ ಸರ್ವ್ ಆಗಿದೆ, ಎಲ್ಲ ಆಗಿದೆ ಈಗ.
ಇಲ್ಲ. Lesser punishment may be imposed.
ಏನ್ ಪನಿಷ್ಮೆಂಟ್ ಲೆಸರ್?
Withholding back wages. They may be reconstituted.
ಅದೇ ಪನಿಷ್ಮೆಂಟ್ ಆಗುತ್ತೆ. ಯು ಆರ್ ನಾಟ್ ವರ್ಕ್ಡ್, ಯು ವಿಲ್ ನಾಟ್ ಗೆಟ್ ಎನಿಥಿಂಗ್. ಪನಿಷ್ಮೆಂಟ್ ಬೇರೆ
Withholding any increments and
ಏನು
back wages.
ಪ್ರೊಬೇಷನರಿ ಪೀರಿಯಡ್ ನಲ್ಲಿ ಏನು ಇನ್ಕ್ರಿಮೆಂಟ್ ಬರ್ತದೆ ನಿಮ್ಗೆ?
In future, not entitled for any increment, he continue as a forest guard.
ಏನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. ಈಸ್ ರೈಟ್ ಇನ್ ಸೇಯಿಂಗ್ 2006 ಆಗಿದ್ದೆಲ್ಲ. 25/2007.
Case is pending for more than 17 years before the KCT.
Huh? How many years? He was still in probation only.
Yes,
Compassionate appointment to probationary period ಇಷ್ಟು ರೆಸ್ಪಾನ್ಸಿಬಿಲಿಟಿ.
yes, sir.
ಆಮೇಲೆ ತಾಯಿ ಹುಷಾರಿಲ್ಲ ಅನ್ಕೊಂಡು ವೇರ್ ಇಸ್ ದ ಮಟೀರಿಯಲ್? 17 ವರ್ಷ ತಾಯಿ ದರ
ಇದಾರೆ. At present.
ಅವಾಗ ಏನಾಗಿತ್ತು?
ಅವಾಗ ಹೆಲ್ತ್ ಅಪ್ಸೆಟ್ ಅಂತ.
ಏನ್ ಹಂಗೆ ಹೇಳಿದ್ರೆ ಅಪ್ಸೆಟ್ ಆಗಿತ್ತು ಅಂದ್ರೆ ತಲೆನೋವು ಬಂದ್ರು ಅಪ್ಸೆಟ್ ಆಗುತ್ತೆ. ಅದು ಏನು ವಾಟ್ ಇಸ್ ದಿ ಡಿಸೀಸ್ ವಿಚ್ continuously required your attention. And there is a sister.
Yes, my lord.
There is a sister. You have admitted in your petition. ಏನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. ಮೆಡಿಕಲ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಟ್ಟಿಲ್ಲ. ಹೇಳ್ಕೊತೇನ ಮತ್ತೊಂದು ಟೆನರ್ ಆಫ್ ದಿ ಲ್ಯಾಂಗ್ವೇಜ್ ಇದೆಯಲ್ಲ, ಯಾ ಕೆಲಸ ಮಾಡಬಾರ್ದು ಅನ್ನೋ ಅಟಿಟ್ಯೂಡ ಕಾಣ್ತದೆ. ಹಂಗೆ ಹೇಳಿದ್ದ ನಿಜ. ಬರ್ಕೊಳ್ಳಿ, ಏನಿಲ್ಲ ಬರ್ಕೊಳ್ಳಿ. ಕೂತ್ಕೊಳ್ಳಿ. Petitioner removed employee is knocking at the doors of writ court for assailing state tribunal's order dated 25 September 2024, whereby relief has been denied to him. First, in the said application, he had laid a challenge to the removal order dated 2/5/2007. First. Next, learned counsel for the petitioner vehemently argues that the very appointment of his client was on compassionate ground, and he was the only breadwinner of the family, and therefore, while awarding punishment of the kind, the relevant factors like this ought to have been considered, and that having not happened, the tribunal grossly erred in upholding the removal order. First off, he also contends that the reason for his being away from service was the ill health of mother and that he had to look after a daughter also. First, so contending, he seeks invalidation of order of the tribunal and the punishment order. First. Next paragraph. Learned DGA appearing for the official respondents vehemently opposed the petition, contending that the tribunal, having looked into all aspects of the matter, has upheld the punishment order dated 2/5/2007. Semicolon. Petitioner, a probationer, when the punishment order was made, semicolon. He was very often absent from duty, and absolutely there is no justification whatsoever for the said absence. First, he adds that version of the petitioner is not vouched by producing medical certificates about the pleaded ill health of mother. First, even otherwise, the tenor of his defense and communication in writing is not happy, and it shows some elements of insubordination and disinterest in service, public service. First, so contending, he seeks dismissal of the petition. Having heard the learned counsel for the parties and having perused the petition papers, we decline indulgence in the matter, broadly agreeing with the submission of learned AGA. First up, petitioner was only a probationer, having been appointed on compassionate ground. First up, a person in probation has to be doubly cautious, which is missing in this case. Which aspect is missing in this case? Semicolon. It is not that for a few days the petitioner was absent. Semicolon. He was absent for long, and absence was intermittent. Semicolon. Absence of the personnel in the cadre of the petitioner would expose the forest to enormous risk, in days like this. First, the disciplinary authority, after considering all aspects of the matter, has issued the punishment order. And the same having been examined by the tribunal in its accumulated wisdom, the same has been upheld. First, the jurisdiction of the High Court in the light of L. Chandrakumar versus Union of India, 1997 Supreme Court, so and so, is essentially of supervisory jurisdiction under Article 227, comma, Article 226 having been ornamentally employed in the petition, comma, subject to all just exceptions. First, in the above circumstances, petition being devoid of merits is liable to be and accordingly dismissed. Courts having been made easy. Next. Pagination ಸರಿ ಇಲ್ಲ ಎಂತದಿಲ್ಲ. Yes.
Lordship, in this matter, I'm for the petitioner.
But
Your Lordship, the petitioner was selected as for a B group post through KPC, Your Lordship. After selection list was published, his documents were sent for verification, Your Lordship. The document at page number 272, that is rural certificate, was sent to the respondent number 5 for verification, Your Lordship.
Then district verification committee na? Cash, ಯಾವ್ದದು?
Commercial tax department, Your
No,
Lordship.
certificate was sent to whom?
BO, Your Lordship. BO.
ಯಾರವರು? BO ಅಂದ್ರೆ
Education
Officer,
block education officer.
Ramdurga.
Ah.
But he refused to verify the certificate and issued an endorsement saying that the school was situated within the limits of town municipality, Your Lordship. Thereafter, it was challenged before the KAT, Your Lordship. The KAT allowed our appeal and remanded the matter to consider all the documents that are produced by us and also
Remand happened. Next one.
and also getting report from the taluk office and municipalities and also village panchayat, Your Lordship.
ನಿಮ್ದು ಇದು ಸ್ಟೇಟಸ್ ರೂರಲ್ ಕ್ಯಾಂಡಿಡೇಟ್ ಆರ್ ನಾಟ್ ಅನ್ನೋ ಸ್ಟೇಟಸ್ ಅಷ್ಟೇ.
Please,
ರೂರಲ್ ಅನ್ಲಿಕ್ಕೆ ಏನು ಮಟೀರಿಯಲ್ ಇದೆ ಇಲ್ಲಿ?
R1, Your Lordship, 269 page.
269. Huh. 269. ಏನ್ 269?
It is at page.
ಸ್ವಾಮಿ 269 ಅಲ್ಲಿ
ಹಾ.
ರಾಮದುರ್ಗ ಪುರಸಭೆ ಅಂತ ಇದೆ. 5/6/1997 ವರೆಗೆ
ಪೇಜಿನೇಷನ್ ಸರಿ ಮಾಡಲ್ಲ ಅವರು. ನಾವು ಅದೊಂದು ಗ್ರೌಂಡ್ ಮಾಡ್ತಾ ಇದ್ದೇವೆ. ಡಿನೈಂಗ್ ರಿಲೀಫ್ ಇನ್ ದ ಅರ್ಲಿಯರ್ ಮ್ಯಾಟರ್ ಆಲ್ಸೋ ವಿ ಡಿನೈಡ್ ರಿಲೀಫ್ ಬಿಕಾಸ್ ಪೇಜಿನೇಷನ್ ಇದು ಹೆಫೆಜಾರ್ಡ್ ಇತ್ತು. ಅಲ್ಲಿ ಏನು ಬ್ಯೂಟಿ ಒಂದು ಏನು ಇರಲಿಲ್ಲ. ಆಲ್ರೈಟ್, ಇಲ್ಲಿ ಹಂಗೆ ಆಗ್ಬೋದು ನೋಡೋಣ. ವಿಚ್ ಇಸ್ ದಿ ಪೇಜ್ ಯು ಆರ್ ರೀಡಿಂಗ್?
269, Your Lordship.
269 ಹೆಡ್ಡಿಂಗ್.
ಬೆಳಗಾವಿ ಜಿಲ್ಲೆಯಲ್ಲಿ ರಾಮದುರ್ಗ ಪುರಸಭೆ 5/6/1927 ಈವರೆಗೆ ಅದು ಪಟ್ಟಣ
Your
ಇದಾಗಿದೆ.
Lordship,
ಪೇಜಿನೇಷನ್
pagination
ಹೌ ಯು
270.
ಶುಡ್ ಆರ್ಗ್ಯೂ?
Your Lordship, there is some mistake in pagination, Your
No, no,
Lordship.
will not
We'll
do.
rectify it, Your Lordship.
Will
Please,
not,
Your
will not,
Lordship.
will not. This is a disrespect shown to the court.
Please, kindly pass over.
How he should argue? How we should, will be not on the page only. Same
Because
page ಇರುವುದೇ ಇಲ್ಲ ನಾವೇ.
some translation copies have been inserted, therefore
ಪೇಜಿನೇಷನ್ ಯಾಕೆ ಹೆಚ್ಚು ಕಡಿಮೆ ಆಯ್ತು?
we'll rectify, Your Lordship. Kindly pass over, Your Lordship.
No, no.
We'll now.
We are dismissing it. There is material
Please,
to
Your
show that he is not a rural candidate.
Please, Your Lordship.
ಎಲ್ಲಿದೆ ಅದು?
ಅದು ಪೇಜ್ 270 ನಾವೇ ಕೊಟ್ಟಿದ್ದೇವೆ ಸರ್. 270 RP ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೇವೆ, ಅದರಲ್ಲೇ ಬಂದಿದೆ. ಆಮೇಲೆ
ಗ್ರಾಮೀಣ ಅಭ್ಯರ್ಥಿ
ಕ್ಲಾರಿಫೈ ಮಾಡಿದ್ದಾರೆ 267 ಅಲ್ಲಿ ಸರ್ಟಿಫಿಕೇಟ್
ಅಲ್ಲ,
ಸರ್ಟಿಫಿಕೇಟ್ ಮಾಡಿದ್ದಾರೆ.
ಯಾರು ಕೊಡಬೇಕು? ಗ್ರಾಮೀಣ ಅಭ್ಯರ್ಥಿ ಅನ್ಕೊಂಡು ಸರ್ಟಿಫಿಕೇಟ್ ಯಾರು ಕೊಡಬೇಕು?
ಅದನ್ನ ಕನ್ಫ್ಯೂಷನ್ ಇದ್ರೆ ಸ್ವಾಮಿ, ಇಫ್ ದೆರ್ ಈಸ್ ಎನಿ ಕನ್ಫ್ಯೂಷನ್ ರಿಗಾರ್ಡಿಂಗ್ ದ ರೂರಲ್, whether it comes within the rural or not, it has to be clarified through the ಪುರಸಭೆ ಅಂತ ಸರ್ಕ್ಯುಲರ್ ಇದೆ. ಪುರಸಭೆಯಿಂದ ಪುರಸಭೆ ಅವರು ಕೊಟ್ಟಿದ್ದಾರೆ. ಲಾರ್ಡ್ಶಿಪ್ that circular, ಲಾರ್ಡ್ಶಿಪ್ finds it
ರೂರಲ್ ಕ್ಯಾಂಡಿಡೇಟ್ ಅಂದ್ರೆ ಏನು? What is, how it is defined?
ಲಾರ್ಡ್ಶಿಪ್ that 260 file
260.
ಸರ್ಕ್ಯುಲರ್ ಇದೆ ಸರ್.
265.
ಅದರಲ್ಲಿ ಸರ್ಕ್ಯುಲರ್ ಇದೆ.
ಹಾ.
ಸಣ್ಣ ನಗರ ಅಥವಾ ಗ್ರಾಮೀಣ ಸ್ವಾಮಿ 3 ಗ್ರಾಮೀಣ ಪ್ರದೇಶ ಗುರುತಿಸುವ ಸಂಬಂಧದಲ್ಲಿ ತೊಂದರೆ ಉಂಟಾದಲ್ಲಿ ಲಾಸ್ಟ್ ಲೈನ್ ಅವರುಗಳ ಸಂಬಂಧಿಸಿದ ಸ್ಥಳೀಯ ಮಹಾನಗರ ಪಾಲಿಕೆ, ಪುರಸಭೆ, ನಗರಸಭೆ ಅಥವಾ ನಗರ ಪಂಚಾಯತ್ ಇವುಗಳ ಕಚೇರಿಯನ್ನು ಸಂಪರ್ಕಿಸಬಹುದು ಅಥವಾ ನಿರ್ದೇಶಕರು
ಎಲ್ಲಿ ಓದ್ತಾ ಇದೀರಿ? ಯಾವ ಪೇಜ್
ಸ್ವಾಮಿ,
ಹೇಳೋದು?
264
ಅವ್ರಿಗೆ ಕೇಳಿ ಯಾವ್ದೊಂದು
264 your lordship.
264.
264 ಮತ್ತೆ ಏನೇನೋ ಹೈದರಾಬಾದ್, ಕರ್ನಾಟಕ ಇದೆ.
KPSC ಅವರದ್ದು ಲಿಸ್ಟ್.
Your lordship, there is a mistake in pagination, your lordship.
ಅಲ್ಲ, ಒಂದು ಡಿಸ್ಮಿಸ್ ಮಾಡ್ರಿ, ಉಳಿದವರಿಗೆಲ್ಲ
Yes, sir,
ಗೊತ್ತಾಗ್ತದೆ
lordship.
ನಾವ್ ಏನ್ ಮಾಡ್ತೀವಿ ಅಂತ.
ಈಗಲೇ rectify
One
ಮಾಡ್ತೀನಿ.
of the grounds was that it was ill drafted and pagination ಸರಿ ಇರ್ಲಿಲ್ಲ.
Your
It
lordship,
did not permit us to be on the same page.
your lordship.
ಒಬ್ಬೊಬ್ರು ಒಂದೊಂದು ಪೇಜ್ ಹಿಡ್ಕೊಂಡಿದ್ವಿ, ಅದಕ್ಕೆ ಎಲ್ಲ ಏನ್ ಮಾಡ್ಲಿಕ್ಕೆ
Kindly
ಮೆರಿಟ್
pass
ಮೇಲೆ ಹೇಳಿ, ಮೆರಿಟ್ ಮೇಲೆ ತೋರಿಸಿ. There is a limit for indiscipline, no respect for the court, no respect for the
16
institution.
6 2019 14/6/2001 circular.
14/6/2001 circular ಏನು ನಿಮ್ಮ
R2, we have produced it before the KAT. The procedure to be followed.
call immediately after vacation. In the meanwhile, petitioner counsel to repair the petition paper book. And he should repair it in the copy given to the learned AGA also. Okay. Yes.
May I please, my lord? I seek my lord's indulgence
Yes.
and guidance in this matter, my lord. This is a short issue involved in this matter, my lords, in respect to charge memo, my lords, which has been issued to the jail superintendent when she was working as a jail superintendent in Bangalore Central, wherein, my lords, various Kannada television channels telecasted about the irregularities in Central Prison, Bangalore, my lords. All the photos which were telecasted is downloaded by the from the YouTube, and which were prior 4 to 5 years pictures, my lords. During her period, my lords, while working as a superintendent, that has been telecasted. On that ground, my lords, there was an inquiry has been held by the ADGP. And in that inquiry report, there is not a single evidence which says against the petitioner, my lords. My lords, may I take the charge memo, my lords?
That memo, page number?
Page number A2, ink page number
38.
37.
37, 38.
7.
Yes, my lord, 37. Ink page number 37. Entire report, my lords, where which says, my lords, with regard to the pictures which were telecasted, were earlier to her reporting to duty in the central jail. And
You reported to central jail when?
my lords, have reported, my lords, 27/6/2019 to 2/7/2022. I have worked there as a jail superintendent.
Into
27/6/2019 to 2/7/2022. And my lords, during that period, my lords, chart also there with regard to entrustment of duty.
what are the charges?
Charges are that, my lords, may I read? It is in Kannada, my lords.
Huh.
Huh.
We have great affection, love affection for Kannada.
Please,
And
please.
Kannada, Nadu, Nudi,
Yes.
Jala, Jala.
Yes.
Yes.
ಅನುಬಂಧ 1. ನೀವು ಮೇಲೆ ವಿವರಿಸಿದ ಆರೋಪಿತ ಸರ್ಕಾರಿ ನೌಕರರು ದಿನಾಂಕ 27/6/19 2/7/22 ಬೆಂಗಳೂರಿನ ಕೇಂದ್ರ ಕಾರ್ಯಾಗಾರದಲ್ಲಿ ಅಧೀಕ್ಷಕರಾಗಿ ಸೇವೆಯನ್ನು ಸಲ್ಲಿಸುತ್ತಿದ್ದಾಗ ಬೆಂಗಳೂರು ಕೇಂದ್ರ ಕಾರ್ಯಾಗಾರದಲ್ಲಿ ನಡೆಯುತ್ತಿರುವ ಅಕ್ರಮ ಚಟುವಟಿಕೆಗಳ ಬಗ್ಗೆ ವಿವಿಧ ದೃಶ್ಯ ಮಾಧ್ಯಮಗಳಲ್ಲಿ ದಿನಾಂಕ 25/1/22 31/1/22 ಪ್ರಸಾರ ಮಾಡಿವೆ. ಸದರಿ ಸುದ್ದಿಗಳ
ದೃಶ್ಯ ಮಾಧ್ಯಮವನ್ನು ಆಧರಿಸಿಕೊಂಡೇ ಇದೆಯಾ? All charges?
Pardon, my lords?
All charges
Huh.
are dependent upon what was telecast.
My lords,
Other charges also are there.
ಅದರ್ ಅಂತಂದ್ರೆ ಇವ್ರ ಮೇಲೆ ಒಂದೇ ಚಾರ್ಜು. ಶಿ ಇಸ್ ಡೈರೆಕ್ಟ್ಲಿ ಸೂಪರ್ವೈಸಿಂಗ್ ಅಥಾರಿಟಿ ಟು ಲುಕ್ ಇನ್ ಟು ಆಲ್ ದೀಸ್ ಆಸ್ಪೆಕ್ಟ್ಸ್. ಸೊ ವೇರ್ ಇನ್ ಮೈ ಲೋಡ್ಸ್
ನೀವ್ ಹೇಳೋದು ಆ period
ಅಂಡರ್ ಹರ್ ಸಾರಿ ಮೈ ಲೋಡ್ಸ್.
ನೀವ್ ಹೇಳೋದು ಆ ಪೀರಿಯಡ್ ನಲ್ಲಿ ನೀವು ಇರ್ಲಿಲ್ಲ ಅಂತ.
ಇಲ್ಲ,
ಆ ದೃಶ್ಯ ಮಾಧ್ಯಮಗಳೇನು ಇವರು ಪಬ್ಲಿಷ್
ಟೆಲಿಕಾಸ್ಟ್
ಮಾಡಿದ್ದಾರೆ
ಮಾಡಿ
ಆ ಫೋಟೋಗ್ರಾಫ್ಸ್ ತಗೊಂಡಾಗ ನೀವಿರ್ಲಿಲ್ಲ.
Yes.
ಅದ್ ಹೆಂಗ್ ಗೊತ್ತಾಗ್ತದೆ? ಆ ಫೋಟೋಗ್ರಾಫ್ ಆ ಇಯರ್ದು ಅಂತ ಹೆಂಗ್ ಗೊತ್ತಾಗ್ತದೆ?
ಎವಿಡೆನ್ಸ್ ಸಜಾಬಂದಿಗಳ ಅವ್ರ ಸ್ಟೇಟ್ಮೆಂಟ್ಸ್ ಗಳೇ ತಗೊಂಡಿದ್ದಾರೆ. ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ಇದೆ ಮೆಲೋಡ್ಸ್. ದಟ್ ಮೇ ಐ ಟೇಕ್ ಮೆಲೋಡ್ಸ್ ಇಂಕ್ ಪೇಜ್ ನಂಬರ್ ಮೆಲೋಡ್ಸ್ 155. ಇಂಕ್ ಪೇಜ್ ನಂಬರ್ 155. ನಜೀರ್ ಬಂದಿ ಎಲ್ಲರದು ಸ್ಟೇಟ್ಮೆಂಟ್ ತಗೊಂಡಿದ್ದಾರೆ. ಅದ್ರಲ್ಲಿ ಅವರೇ ಹೇಳಿದ್ದಾರೆ ಸುಮಾರು 4-5 ವರ್ಷ ಹಳೆಯದಿರಬಹುದು.
ಅವ್ರಿಗೆ ಹೆಂಗ್ ಗೊತ್ತಾಗ್ತದೆ?
ಅಲ್ಲ ಎಲ್ರದ್ದು ಇವನ್ ಇನ್ಕ್ಲೂಡಿಂಗ್ ಜೇಲ್ಸ್. ಎಸ್ ಹಾ, ಚಾರ್ಜ್ ಮುಂದೆ ಒತ್ತು. ಹಾ, ಸುವರ್ಣ ಸುದ್ದಿಯಲ್ಲಿ ಸಂಖ್ಯೆ 2 ಅನ್ನು ಫೋಟೋ ಸಹಿತ ಪ್ರಸಾರ ಮಾಡಿದೆ. ಈ ಫೋಟೋದಲ್ಲಿ ಒಟ್ಟು 8 ಬಂದಿಗಳು ಕಂಡು ಬಂದಿದ್ದು, ಅದರಲ್ಲಿ ಸಜಾ ಬಂದಿ ಫಹೀದ್ ಬಂದಿ ಕುಳಿತಿದ್ದು, ಸಜಾ ಬಂದಿ ಸೋ ಲಿಯಾಖತ್ ಮೊಬೈಲ್ ಬಳಸುತ್ತಿರುವುದು ಕಂಡು ಬಂದಿದೆ. ಮೊಬೈಲ್ ಫೋನ್ ಸಂಖ್ಯೆ ಸೋ 13/4/21 10/3/22 ಬೆಂಗಳೂರಿನ ಕಾರ್ಯಗೃಹದಲ್ಲಿದ್ದು, ಅದರಿಂದ 15,000ಕ್ಕಿಂತ ಹೆಚ್ಚು ಕರೆಗಳು ವಿವಿಧ 20 ಜಿಲ್ಲೆಯ ಸ್ಥಳಗಳಿಗೆ ಮಾಡಿರುವುದು ಈ ಮೊಬೈಲ್ ಫೋನ್ CDR ವಿಶ್ಲೇಷಣೆಯಿಂದ ಕಂಡು ಬಂದಿದೆ. ಕಾರ್ಯಗೃಹದಲ್ಲಿ ಮೊಬೈಲ್ ಬಳಕೆ ಕಾರ್ಯಗೃಹದ ಅಧಿನಿಯಮ 45/12 ಪ್ರಕಾರ ನಿಷೇಧವಾಗಿದ್ದು, ಅದು ಸದರಿ ನಿಯಮದಿಂದ ಕಲಂ 42ರಲ್ಲಿ ಶಿಕ್ಷಾರ್ಹ ಅಪರಾಧವಾಗಿದೆ. ಒಬ್ಬ ಜವಾಬ್ದಾರಿಯುತ ಸಂಸ್ಥೆಯ ಮುಖ್ಯಸ್ಥರಾದ ನೀವು ಈ ಸಂಸ್ಥೆಯ ಅಧಿಕಾರಿ ಸಿಬ್ಬಂದಿಗಳ ಅವರಿಗೆ ವಹಿಸಿರುವ ಕರ್ತವ್ಯಗಳನ್ನು ಸರಿಯಾಗಿ ನಿರ್ವಹಿಸುತ್ತಿರುವ ಬಗ್ಗೆ ಹಾಗೂ ಕಾರ್ಯಗೃಹದಲ್ಲಿ ಮೊಬೈಲ್ ಮತ್ತು ಮಾದಕ ವಸ್ತುಗಳು ಬಳಕೆಯಾಗುತ್ತಿರುವ ಬಗ್ಗೆ ವ್ಯಾಪಕವಾಗಿ ಮಾಹಿತಿ ಪಡೆದು ಇವುಗಳನ್ನು ತಡೆಗಟ್ಟುವ ನಿಟ್ಟಿನಲ್ಲಿ ಕ್ರಿಯಾತ್ಮಕ ಕ್ರಮಗಳನ್ನು ತೆಗೆದುಕೊಳ್ಳದೆ ತನ್ಮೂಲಕ ನೀವು 21ರ ಕರ್ನಾಟಕ ಕಾರ್ಯಗೃಹ ಮತ್ತು ಸುಧಾರಣಾ ಸೇವೆಗಳ ಕೈಪಿಡಿಯ ಅಧ್ಯಾಯ 7 ಮತ್ತು 61ನೇ ನಿಯಮ 61ರ ಉಪನಿಯಮ 3ರಲ್ಲಿ ಉಲ್ಲಂಘಿಸುತ್ತಿರುತ್ತದೆ. This is the one charge, my lords.
15,000 phone calls.
Yes, my lord. CDR is there, my lords. Even in the enquiry report, my lord, it is been said.
That shows the call details during
That period.
Yes, yes, my lord.
Your
what do you say on that?
Yes, my lords. With regard to that, my lords, enquiry report has to be looked into, my lords, because they have taken that contention. Where here it says that Liaquat Khan has been done, my lords. That, my lords, may I take with regard to CDR analysis, ink page number 167, where with regard to that 15,000 call details, my lords. It is a
Terrorists?
ಅವರೆಲ್ಲ ಸಜಾ ಬಂದಿ ಇದ್ದವರೆಲ್ಲ ಅಲ್ಲಲ್ಲ ಅವ್ರು ಟೆರರಿಸ್ಟ್ ಇದ್ರು ನನಗೆ ಐ ಆಮ್ ನಾಟ್ ಅವೇರ್ ಆಫ್ ದಟ್. Where, my lords, here in the charge memo it is stated, my lords, even including the phone numbers have been given.
ಶಂಕಿತ ಉಗ್ರರು ಅನ್ಕೊಂಡೆಲ್ಲ ಇದ್ರಲ್ಲೆಲ್ಲ ಹಂಗೆ ಇದೆ.
ಇದೆ,
terrorist ಅಂತಾನೆ ಇದೆ.
might be, my lord. My lords, ಸಂಖ್ಯೆ 8867 ಅಂತ ಫೋನ್ ನಂಬರ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅದರಲ್ಲಿ ಚಾರ್ಜ್ 1ರಲ್ಲಿ. Ink page number 167 of the report, my lords. 1.11. ಹಾ, ಇದರಲ್ಲಿ ಥರ್ಡ್ ಪ್ಯಾರಾ.
During.
ಹಾ, ಇದರಲ್ಲಿ CDR of suspect prisoners mobile number ಅಂತ ಹೇಳ್ತೆ. This is the where, my lords, phone number has been mentioned in that. That belongs to one Devraj, my lords. In the charge, my lords, it says that Liaquat, my lords.
ಅವ್ರ ಹೆಸರಿಗೆ ಇರಲ್ಲ, ಅದು ತೊಗೊಂಬಂದು ಇಟ್ಕೊಂಡಿರ್ತಾರೆ ಬೇರೆ ಹೆಸರಿಗೆ.
ಅದೇ ಅದೇ, ಸೊ ಬೇರೆಯವ್ರ ಹೆಸರಿಗಿದೆ. ಆಮೇಲೆ ಅದರಲ್ಲೇ, my lords, in continuation of that analysis, conclusion part, my lords, 171. Last tower dump analysis, conclusion portion, my lords. Jail authorities are not equipped to take up this task of wiping of mobiles from jails. There are legal hurdles that need to be urgently addressed in this regard. A superintendent of police level officer in prison headquarters can be given the responsibility to develop the trained staff in this regard. Then, my lords, tower dump analysis, where, my lord, is last line, my lord, database of mobile numbers belonging to officers, staffs, civilians residing nearby. Next page, my lords, 172. Visitors to jail, etc. Including ಎಲ್ಲರದು ಅಲ್ಲಿ ಆ ಲೊಕೇಶನ್ ಅಲ್ಲಿ ಟವರ್ ಡಂಪ್ ಅಲ್ಲಿ ಅದು ಬಂದ್ಬಿಡುತ್ತೆ. ನಂಬರ್ಸ್
ಅವ್ರು ಮಾಡಿದ್ದು ಬೇರೆ ಬೇರೆ ಡಿಸ್ಟ್ರಿಕ್ಟ್ಗಳು.
ಅಲ್ಲಲ್ಲ, ಜಿಲ್ಲೆಗಳಿಗೂ ಇದೆ ಅಂದ್ರೆ
ಬೇರೆ ಬೇರೆ ಇದೆ, 20 ಜಿಲ್ಲೆಗಳು ಬೇರೆ.
ಹೌದೌದು. ಸೊ ಎಲ್ಲಾ ನಂಬರ್ಸ್ ಗಳನ್ನು ಅನಲೈಸ್ ಮಾಡಿ ಬೇಸ್ಡ್ ಆನ್ ದ ಟವರ್ ಡಂಪ್ ಮೇಲೆ.
Also emanated from that tower. It started from that
The
tower.
power went to other districts.
Other district.
All terrorists.
Yes, my lords, with regard to that, my lords, it is not saying that, my lords, numbers not belonging to database need to be looked into in detail. Detail analysis need to be done and check whether these belongings to passerby or visitors or whether they are being used in a prisons regularly inside the jail. That is how, my lords, the conclusion has come, my lords. And next contention, my lords, charge number 2, my lords, where it says, my lords, ನಗದು ಹಣ ಪಡೆಯುತ್ತಿರೋದು, ಬಂದಿಗಳ ಸೆಲ್, ಮೊಬೈಲ್, ಗಾಂಜಾ ಸೇದುವ, these all things, my lords, which have stated in the charge memo, that is not this central jail, my lords. The clipping of the telecasted, my lords, based on that, it shows Chikballapur jail anta heli. That is also the witness have stated in the report, my lords. May I take that, my lords?
Who are the witnesses?
Jailers and jail, even
after-
jailers also there, my lords.
Which jailer has said?
Jailers ಇದ್ದಾರೆ ಅದರಲ್ಲಿ.
Which jailer?
ಆಮೇಲೆ the witness whom, my lords, they have made an as witness during their period that has been happened. One of the example which I would like to show, my lords.
No, assuming, we'll assume that that is not true. What about the first charge?
Yes, ma'am. This.
15,000 ಕರೆಗಳು ಮೊದಲೇ ಇಡೀ ದೇಶದಲ್ಲಿ ಟೆರರಿಸಂ
Yes.
ಜಗತ್ನಲ್ಲಿ ಅಡ್ಡಾಡ್ತಾ ಇದೆ ಈಗ.
Yes, yes, sir.
Everybody has to be very effective, strong and
Yes.
do everything to
Yes.
finish off all that.
Huh.
And
ಇದರಲ್ಲಿ ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ಹೇಳುತ್ತೆ, my lords, she is a superintendent, the hierarchy, my lords, how it flows, my lords. There were this, my lords, in the jail authority, my lords, there is in chapter 4 of the report, where, my lords, control of entry of prohibited articles in the jail.
yes,
Chapter 4, my lords, in the inquiry report, my lords.
page number.
Page number, my lords. 4.1, my lords. 4.1.
Running page number. ಇಲ್ಲಿ ನೋಡಿ.
One.
ಇಲ್ಲಿ ಇದೆ.
ಅಲ್ಲ, ಇದೆಲ್ಲ ರಿಪೀಟೆಡ್ ಆಗಿ ಮುಂಚೆನೂ ತೋರಿಸಿರೋದು ಅವೆಲ್ಲಾನು ಇದ್ರಲ್ಲಿ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಬೇರೆ ಜೈಲಲ್ಲಿ ಆಗಿರೋದನ್ನು ಇದರಲ್ಲಿ ತೋರಿಸಿದ್ದಾರೆ. ಡ್ಯೂರಿಂಗ್ ಹರ್ ಪೀರಿಯಡ್, ಮೈ ಲಾರ್ಡ್, ಇಟ್ ಇಸ್ ಬಿನ್ ಟೆಲಿಕಾಸ್ಟೆಡ್. ಆಮೇಲೆ
ಆಯ್ತು, ಇದು 15,000 ಫೋನ್ ಕಾಲ್ಸ್ ಏನ್ ಹೇಳ್ತೀರಿ ಅಂತ?
ಅದೇ ಟವರ್ ಡಂಪ್ದು CDR ನಾವು ಹಾಕಿದ್ದಾರೆ.
10 districts.
ಅಲ್ಲ,
Enquiry ಒಳಗೆ
ಹಾ, ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ, we have, when we are the working there, we have lodged 27 cases with respect to that whenever we come across it, my lords. The subordinate officers, my lords, there are 6,000 warder and 81, the chart, my lords, I have furnished, my lords, the respondent themselves, my lords, given in their reply statement. 600 warders and head warders are 90 and assistant jailers are 35, 20 jailers, then 6 assistant superintendent of prison, then the superintendent, my lords. The one of the major charges, my lords, I am the direct supervisory, my lords. And under the warder, my lords, there is one more thing, my lords, where they look after with regard to barricade whoever enters into the jail authority, my lords. ಅವರೇ ಇರೋದು, that is deputing a KSIFS unit, Bangalore Central Jail. This unit, my lords, it is particularly appointed in the year 2016 to look after the barricade whoever enters into, including the superintendent and chief superintendent has to go through, my lords, with the checking, then they have to enter. So whomever, my lords, it is come across to notice of these chief superintendent, my lords, Chief Superintendent has taken action and lodged. My contention in this matter, my lords, the charges are vague. There is a no specific charges against the superintendent, my lords. And only one word in the last, my lords, being a higher authority, my lords, it is a responsible, direct supervisory responsible. If my lords, if they give a specific charge against me, I could have defend my lords. If that is not provided, it amounts to violation of principal natural justice, my lords. With regard to that, I quote one judgment of our Chief Justice of India, of our Karnataka High Court, my lords, 1986. My concern will, I'm ready with the go with the my lords, if they provide me with the specific charges where my involvement is there, my lords, if they choose.
What is the proposition?
Proposition is that charges are vague and evidence is not sufficient.
That does not need any ruling at all.
With regard to that, my
That,
lords.
whether they vague ಅನ್ನೋದನ್ನ ತೋರಿಸ್ಬೇಕು.
ಅಲ್ಲ, vague ಅನ್ನೋದಕ್ಕೆ there is a no specific date, time, and my lords.
During your period, they have said, they have mentioned during what period you were working there.
Yes, my lord.
During that period, 15,000 phone calls
Yes,
have gone from jail
Yes.
to 10 districts.
Yes, my lord, 20
It's serious
districts.
matter.
Yes, my lord, sir. So with regard to that, whomever we find, may I take, my lords, my reply to that show cause notice, my lords?
Yes.
Annexure A6, my lords.
Page number?
Page number, my lords, 414. Annexure A6.
Yes.
ಇದರಲ್ಲಿ ಅಲಿಗೇಷನ್ ಏನು ಅನ್ನೋದು ಫಸ್ಟ್ ಪ್ಯಾರಾದಲ್ಲಿದೆ. ಆಮೇಲೆ ಯಾವ್ಯಾವ ದಾಖಲಾತಿ ಕೊಟ್ಟಿರೋದು 416 ನಲ್ಲಿ ನಾನು ದಿನಾಂಕ, ಸೊ ಸೆಕೆಂಡ್ ಪೇಜ್ ಇಂದ ಶುರು ಆಗುತ್ತೆ. ಚಾರ್ಜಸ್ ಹೇಳ್ಬಿಟ್ಟು ನೆಕ್ಸ್ಟ್ ಇಂದ ಸೊ ಅಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸ್ತಿರೋದು. ಆಮೇಲೆ ಒಂದು ಆರ್ಡರ್ ಇದೆ, ಕಚೇರಿಯ ಆದೇಶ. ದ ವರ್ಕ್ ಎಂಟ್ರಸ್ಟೆಡ್ ಮೀ ಆನ್ ದ್ಯಾಟ್ period, my lords, to my lords, during that period, what the work which I have been entrusted with.
In fact, 20 district, above 15,000 calls during that particular period from this phone number.
That phone number.
13/4/2021 to 10/3/2022, less than a year.
Yes, ma'am.
15,000ಕ್ಕಿಂತ ಜಾಸ್ತಿ ಕಾಲ್ಸ್ ಮಾಡ್ತಾರೆ ಅಂದ್ರೆ.
CDR ವಿಶ್ಲೇಷಣೆಯಿಂದ ಅಂತ ಇದೆ. So CDR, how it has to be looked into another report, they themselves have stated, my lords, and even in their conclusion part, they have stated that it is not a particular, my lords, surrounding persons, whoever call from that place, my lords, it will be traced. And it has to be looked into in detail what they have stated, my lords, in the conclusion part of that. So in the event of that, my lords, page number 420, my lords. ಕೇಂದ್ರದ ಬೆಂಗಳೂರಿನ ಅಧೀಕ್ಷಕ ಬಂದು 6 ತಿಂಗಳಲ್ಲಿ ಮಾದಕ ವಸ್ತು ಸಾಗಿಸಿ ಸಿಕ್ಕಿಬಿದ್ದ ಡಿ ಗ್ರೂಪ್ ನೌಕರರು ಶಿಸ್ತು ಕ್ರಮ ಕೈಗೊಳ್ಳಲಾಗಿರುತ್ತದೆ. ನಂತರ ದಿನಗಳಲ್ಲಿ ಸೋ ಕೋವಿಡ್ ಇರೋದ್ರಿಂದ ಆ ತಪಾಸಣೆ ಅದೆಲ್ಲ ನಡೀತಾ ಇತ್ತು. ಅದಾದ್ಮೇಲೆ ಯಾವುದೇ ಇದ್ರೂ ಕ್ರಮ ತಗೊಂಡು 27 ಪ್ರಕರಣಗಳನ್ನು ನಾವು ಇದು ಮಾಡಿದೀವಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. And in this also I have stated that, my lords, ಮೌಖಿಕ ಅಥವಾ ಲಿಖಿತ ಮೂಲಕ ಯಾವುದೇ ರೀತಿಯ ವರದಿ ಮತ್ತು ಮಾಹಿತಿ ನೀಡಿರುವುದಿಲ್ಲ. ವಾಸ್ತವವಾಗಿ ಆರೋಪ ಪಟ್ಟಿಯಲ್ಲಿ ಪ್ರಸ್ತಾಪಿಸಿರುವ ದೃಶ್ಯಾವಳಿ ಯಾವ ದಿನಾಂಕ, ಯಾವ ವರ್ಷದಲ್ಲಿ, ಯಾವ ಸಂದರ್ಭದಲ್ಲಿ ಆದರೆ ಸಜಾಬಂದಿಗಳಿಂದ, ವಿಚಾರಣಾ ಬಂದಿಗಳಿಂದ ಅಥವಾ ವಿಶೇಷ ದೃಶ್ಯ ಮಾಧ್ಯಮಗಳ ವರದಿಗಾರ ಚಿತ್ರಿಸಲಾಯಿತು ಎಂಬ ಬಗ್ಗೆ ನನ್ನ ವಿರುದ್ಧ ಆಪಾದಿಸಿರುವ ಆರೋಪ ಪಟ್ಟಿಯಲ್ಲಿ ಸ್ಪಷ್ಟಪಡಿಸಿರುವುದಿಲ್ಲ. ಕೇವಲ ಸುದ್ದಿ ಮಾಧ್ಯಮದಲ್ಲಿ ಪ್ರಸಾರಗೊಂಡ ಬಗ್ಗೆ ಸ್ಪಷ್ಟನೆ, ನಿರ್ದಿಷ್ಟ ಆರೋಪವಿಲ್ಲದ ವರದಿ ಪ್ರಸಾರಗೊಂಡು ದಿನಾಂಕವನ್ನು ಮಾತ್ರ ಉಲ್ಲೇಖಿಸಿರುತ್ತಾರೆ. ಆಮೇಲೆ ನಾವು ಹೇಳ್ತೀವಿ, ನಿರಂತರ ಕಾರಣದಿಂದ ಕಾರ್ಯಾಗಾರದಲ್ಲಿ ತಪಾಸಣೆಗಳನ್ನು ಕೇಂದ್ರ ಗಾಂಜಾ ಮತ್ತು ಮೊಬೈಲ್ ಬಳಕೆಯನ್ನು ವಿಷಯವನ್ನು ಗಂಭೀರವಾಗಿ ಪರಿಗಣಿಸಿದ್ದು, ತಪಾಸಣೆ ವೇಳೆಯಲ್ಲಿ ಸಿಕ್ಕಿ ಹಾಕಿಕೊಂಡ ಸಿಬ್ಬಂದಿ ವಿರುದ್ಧ ಸೂಕ್ತ ಕ್ರಮಗಳನ್ನು ಕೈಗೊಂಡಿರುತ್ತೇವೆ. ಮೊಬೈಲ್ ಬಳಕೆಯನ್ನು ನಿಯಂತ್ರಿಸುವುದಕ್ಕಾಗಿ ಅತ್ಯಾಧುನಿಕ ಉಪಕರಣಗಳನ್ನು NLID, DSMAD, MESA ಉಪಕರಣಗಳನ್ನು ಬಳಸಿ ಗೃಹದ ಒಳಾಂಗಣ ಮತ್ತು ಹೊರಾಂಗಣದಲ್ಲಿ ಹಾಗೂ ಭೂಮಿಯ ಒಳಗೆ ಬಚ್ಚಿಟ್ಟಿರುವ ಮೊಬೈಲ್ಗಳನ್ನು ಕೂಡ ಕ್ರಮ ಕೈಗೊಳ್ಳಲಾಗುತ್ತಿದೆ ಅಂತ. ಆಮೇಲೆ ಈ ಹಿಂದೆ ಮಾಧ್ಯಮದಲ್ಲಿ ಪ್ರಸಾರವಾದ ಪ್ರಪಂಚ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಕಂಡು ಬಂದಂತ ಸಿಬ್ಬಂದಿಗಳ ವಿರುದ್ಧ ಇಲಾಖಾ ವತಿಯಿಂದ ವಿಚಾರಣಾ ಸೂಕ್ತ ಕೈಗೊಳ್ಳುತ್ತಾರೆ. ರೌಂಡ್ಸ್ನಲ್ಲಿ ಬಂದಿಗಳು ನೇರ ಭೇಟಿ, ಸಮಸ್ಯೆ ತುರ್ತಿಗಾಗಿ ಸ್ಪಂದಿಸಲಾಗಿ ಮನವಿಯನ್ನು ಕೇಂದ್ರದಿಂದ ಆರಂಭಿಸಲಾಗಿದೆ.
Yes. What do you say?
But CDR reveals the usage of mobile phones, my lord, despite knowing that the prisoners are possessing mobile phones, my lord. Being a jail superintendent, my lord, has not taken any action.
Without a tower dump analysis, how do you say that the calls emanated from this or from the inside of the jail?
Lord, possessing mobile phone itself
Possessing ಅಲ್ಲ, possessing ಅದು ಹೊರಗಡೆಗಿದೆ, ಅಲ್ಲಿಂದ ಇದ್ದಿದ್ದಲ್ಲ ಅದು. ಎಲ್ಲಿದೆ? ಈ ಮೊಬೈಲ್ ಫೋನು ಒಳಗಡೆ ಇದ್ದವನ ಕೈಯಲ್ಲಿ ಸಿಕ್ತು ಅನ್ನೋದಕ್ಕೆ ಎಲ್ಲಿದೆ?
ಅಲ್ಲ,
CDR ನಲ್ಲಿ ಏನಿರುತ್ತೆ? CDR ನಲ್ಲಿ ಈ ಫೋನ್ ನಿಂದ ಈ ಫೋನ್ಗಳಿಗೆ ಎಷ್ಟು ಕಾಲ್ಗಳು ಎಮಾನೇಟ್ ಶುರು ಆಗಿವೆ ಅಂತ.
And one more contention, my lord, sir.
Evidence.
ಈಗ ಮೊಬೈಲ್ ಫೋನ್ ಅಲ್ಲಿಂದನೇ ಅದು ಶುರು ಎಮಾನೇಟ್ ಆಗಿದೆ ಕಾಲ್ಸ್ ಅನ್ನೋದಕ್ಕೆ ಎಲ್ಲಿದೆ? ಚಾರ್ಜ್ ಮೆಮೊದಲ್ಲಿ ಬೇಕಾಗಿತ್ತಾ? 15,000 calls emanated from the tower which is located very near to the
This is a very serious
prison. ಅದು ಬೇಕು ಅಲ್ವೇ? ಕಾಲ್ ಡೀಟೇಲ್ ನಲ್ಲಿ ಇನ್ನೂ ಟವರ್ ಡಂಪ್ ತಗೋಬೇಕಾಗಿದೆ ಅಂತ ಹೇಳ್ತೀರಿ. ಕಾಲ್ ಡೀಟೇಲ್ ರಿಪೋರ್ಟ್ ಅಲ್ಲೇ ಅಲ್ಲ ಅದು. ಇಟ್ ಇಸ್ ನಾಟ್ ಎ CDR ಅನಾಲಿಸಿಸ್ ರಿಪೋರ್ಟ್.
15,000ಕ್ಕಿಂತ ಹೆಚ್ಚು ಕರೆಗಳು ವಿವಿಧ 20 ಜಿಲ್ಲೆಗಳಲ್ಲಿ
ಆ ಫೋನ್ ನಿಂದ ಹೋಗಿದೆ, ಹೌದು. ಬಟ್ ಆ ಫೋನು ಈ ಲೊಕೇಶನ್ ನಲ್ಲಿ ಇತ್ತು ಅನ್ನೋದಕ್ಕೆ ಎಲ್ಲಿದೆ?
Evidences are there, madam.
ಎಲ್ಲಿದೆ?
Page 75 may kindly be perused for a moment, madam. Please come for. Page 75.
One statement of the jailer, my lord, sir.
page 75 allo. They have recovered the mobile phones.
How many police officers have been examined?
My lords. Page number 90, my lords.
Is number?
90, ink page number 90, my lords.
90.
ಅದರಲ್ಲಿ ಜೈಲರ್ಗಳನ್ನು ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲ.
ಫಾರ್ ಎಕ್ಸಾಂಪಲ್, ಐ ಜಸ್ಟ್ ಶೋ ಒನ್ ಮೈ ಲೋಡ್ಸ್. ಈ ವಿನ್ಹಾ ಅಂತ ಸಹಾಯಕ ಜೈಲರ್ ಇವರು ಹೇಳ್ತಾರೆ, ಈ ಹಿಂದೆ ದಿನಾಂಕ 3/2/21 TV9 ದೃಶ್ಯ ಮಾಧ್ಯಮದಲ್ಲಿ ಸೋ ಅಂಡ್ ಸೋ ಶೀರ್ಷಿಕೆಯಲ್ಲಿ ಪ್ರಸಾರವಾಗಿದ್ದು, ಈ ಸುದ್ದಿಯಲ್ಲಿ ಮಾಡಲಾದ ವಿಡಿಯೋದಲ್ಲಿ ನಾನು ಬಂದಿಯೊಬ್ಬನನ್ನು ನಗದು ಹಣವನ್ನು ಪಡೆದುಕೊಂಡು ಆರೋಪದ ಮೇಲೆ ನನ್ನನ್ನು ಕರ್ತವ್ಯದಿಂದ ಅಮಾನತು ಮಾಡಲಾಗಿರುತ್ತದೆ. ಇದೇ ವಿಡಿಯೋವನ್ನು ಈಗ ದಿನಾಂಕ 25/1/22 ಪಬ್ಲಿಕ್ ವಾಹಿನಿಯಲ್ಲಿ ಸುದ್ದಿಯಲ್ಲಿ ಮರುಪ್ರಸಾರ ಮಾಡಲಾಗಿರುತ್ತದೆ ಎಂದು ಹೇಳಿ. ಸೊ ಲೈಕ್ ದಿಸ್ ಮೈ ಲೋರ್ಡ್ಸ್, ಆಮೇಲೆ ಅದೆಲ್ಲ ಯಾವ
question is, how
Yes.
many police officers have been examined as witnesses of the employer side?
ಟೋಟಲ್ ನಂಬರ್ ಮೈ ಲೋರ್ಡ್ಸ್.
ಯಾರ್ಯಾರು?
ಇದೊಂದು ಚಾರ್ಟ್ ಹಾಕಿದೀವಿ ಪರಿವಿಡಿ ಅಂತ.
ಎಲ್ಲಿ page number?
ಪೇಜ್ ನಂಬರ್ 70 ಅಲ್ಲಿ.
70.
70 ಅಲ್ಲಿ.
Huh?
70, 170.
70.
ಹಾ. ಇದರಲ್ಲಿ ವಿಡಿಯೋ ಕ್ಲಿಪ್ ಮತ್ತೆ ಗುರುತಿಸಲಾದ ಅಧಿಕಾರಿಗಳು ಅವ್ರದ್ದೆಲ್ಲ ಇದೆ. ಸೊ 4th ಕಾಲಮ್ ಅಲ್ಲಿ ಬಂದಿಗಳನ್ನು ಗುರುತಿಸಲು ಸಾಧ್ಯವಾಗಿರುವುದಿಲ್ಲ ಅಂತ ಅವ್ರದ್ದು ಸ್ಟೇಟ್ಮೆಂಟ್ ಶಾರ್ಟ್ ಆಗಿರೋದಿದೆ.
ಅವ್ರು ಯಾರು ಅಂತ ಗೊತ್ತಿಲ್ಲ, ಐಡೆಂಟಿಟಿ ಇಲ್ಲ, ಬಟ್ ಬಂದಿಗಳು ಅನ್ನೋ ಬಗ್ಗೆ ಡಿಸ್ಪ್ಯೂಟ್ ಇಲ್ಲ.
ಅಲ್ಲ ಬಂದಿಗಳು, ಬಟ್ ಯಾವ ಪೀರಿಯಡ್ ಅಲ್ಲಿ ಇದು ಮಾಡಿರೋದು ಅನ್ನೋದು ಆ ಬಂದಿಗಳಿಗೇನು ವಿಚಾರಿಸಿದ್ದಾರೆ. ಸೊ ಪೀರಿಯಡ್ ಅಲ್ಲಿ ಎಲ್ರು ಹೇಳಿರೋದು 3 ವರ್ಷ 4 ವರ್ಷ ಹಿಂದಿರೋದು ಅಂತ ಹೇಳಿದ್ದಾರೆ.
I'll accept notice in this matter, my lord. Fresh matter.
I am the next person in the seniority list for a promotion, my lords.
There are evidences, my lord.
And my lords,
121, 120.
due to that, now I am in a Ballari jail, my lords, due to my efficient work, my lords, recently, my lords. The actor Darshan has been shifted there, my lords.
ಅಲ್ಲ, ಇಷ್ಟು ಜನ ಪೊಲೀಸ್ ಆಫೀಸರ್ಸ್ ಯಾಕೆ ಸುಳ್ಳು ಹೇಳ್ತಾರೆ ಅಂತ. Why they will say falsely, why they will depose against you?
ಅಲ್ಲಲ್ಲ, ಯಾರು ಇದರಲ್ಲಿ ಎಲ್ರು ಹೇಳಿರೋದು ವಾಟ್ ಎವರ್ ದ ವಾಸ್ತುಸ್ಥಿತಿ, ಫೋಟೋದಲ್ಲಿ ಏನ್ ಕಾಣಿಸ್ತಿದೆ, ಯಾವಾಗ ತೆಗ್ದಿರೋದು, ಅದ್ರಲ್ಲಿ ಯಾರಿದ್ದಾರೆ, ಸೊ ಆ ಯೂನಿಫಾರ್ಮ್ಗಳೆಲ್ಲ ಯಾರು ಹಾಕೊಂಡಿದ್ದಾರೆ, ಅದು ಯಾವ ಪೀರಿಯಡ್ ಅಲ್ಲಿ ಹಾಕೊಂಡಿದ್ದಾರೆ, ಸೊ ದಟ್ ಟು ಐಡೆಂಟಿಫೈ ದಟ್ ಫೋಟೋಸ್ ಮೈ ಲಾರ್ಡ್ಸ್ ವೆನ್ ದೋಸ್ ಫೋಟೋಸ್ ಹ್ಯಾವ್ ಬಿನ್ ಕ್ಲಿಕ್ಡ್ ಅಂತ ಅಂಥದ್ದೆಲ್ಲ ಇದೆ. ಸೊ ಬೇಸ್ಡ್ ಆನ್ ದಟ್ ಮೈ ಲಾರ್ಡ್ಸ್, those are the photos which were not taken during her period, my lords. ಎಲ್ಲ ವಿಟ್ನೆಸ್ ಓದಿದ್ರು, ಈವನ್ ಎಂಟೈರ್ ರಿಪೋರ್ಟ್ ನೋಡಿದ್ರು, ಒಂದರಲ್ಲೂ ಸೂಪರ್ಡೆಂಟ್ ಪೆಟಿಷನರ್ ಇನ್ವಾಲ್ವ್ಮೆಂಟ್ ಎಲ್ಲೂ ಇದರಲ್ಲಿ ಕಾಣ್ ಬರೋದಿಲ್ಲ. ಓನ್ಲಿ ವಿತ್ ರೆಸ್ಪೆಕ್ಟ್ ಟು ದಟ್ ಫೋನ್ ಕಾಲ್ಸ್ ಮೈ ಲೋಡ್ಸ್ CDR ಒಂದು ಹೇಳೋದಾದ್ರೆ.
Lord, page 111 may kindly be seen.
My contention, my lords, if they give a specific and clear charge, my lords, I may defend myself, my lords, without providing that.
Page 111, my lord.
Huh?
Page 111. Several photographs have been taken, my lord. In this particular photograph, which was taken on 19/2/2022.
111.
Yes, my lord. There is a video clip 39 second ದಾಗಿದ್ದು ಕಪ್ಪು ಬಣ್ಣದ ಟಿ ಶರ್ಟ್
ಕಂಡು ಬಂದಿರುತ್ತದೆ.
ಇದು ಡೌನ್ಲೋಡ್ ಮಾಡಿರೋದು.
ಕುಳಿತಿರುವ ಖಾಕಿ ಸಮವಸ್ತ್ರ ಧರಿಸಿರುವ ಅಧಿಕಾರಿಗೆ ನಗದು ಹಣವನ್ನು ಕೊಡುತ್ತಿರುವುದು ಕಂಡು ಬರುತ್ತದೆ.
ಯಾವ ಡೇಟ್ ಇಂದದು ಅಂತ, ಯಾವಾಗಿಂದದು ಅಂತ, ಇವ್ರು ಇಲ್ದಾಗಿ ಆಗಿದ್ರೆ he came there on a particular date. ಅದು 5 ವರ್ಷಕ್ಕಿಂತ ಹಳೇದು ಅಂತ ಅವ್ರು ಹೇಳಿದ್ರೆ, ಬಟ್ ಅದನ್ನೆಲ್ಲ ಹೇಳ್ತಾ ಇರೋದು 5 ವರ್ಷಕ್ಕಿಂತ ಹಳೇದು ಅಂತ ಹೇಳ್ತಾ ಇರೋದೆಲ್ಲ ಇದು ಟೆರರಿಸ್ಟ್ ಗಳೇ ಹೇಳ್ತಾ ಇರೋದು ಆ ಡೇಟ್.
ಈ ವಿಡಿಯೋ ಸೀಜ್ ಆಗಿರೋದು ಅವಾಗ ಅದು.
There are laxes on the part of the superintendent jailer
Even in
for
my-
having permitting them to use.
Whether in any of these.
Fresh matter, I'll take notice.
Any
I'll
of
take notice,
these
my lord.
videos,
But
whether the-
it's not a case.
the
ಏನ್ ಹೇಳ್ತಾರೆ
petitioner is
ಕೇಳ್ಕೊಬೇಕು.
there.
Please, my lord.
In any of these videos, petitioner is identified.
Lord, what is her role, my lord? Her role,
ಅಲ್ಲ,
not necessarily, my lord, that
ಅದು
she has
direct evidence
to.
ಆಗುತ್ತೆ. ಇದು indirect evidence ಆಗುತ್ತೆ.
Is it?
ಆ period ನಲ್ಲಿ
There are evidence, my
What
lord,
is
it
there
needs
to
to be.
show that this is during the period
Tenure
of
of this
tenure of
lady
this
ಅಂತ.
petitioner. ಅದು
except
ಅದಕ್ಕೆ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಎಲ್ಲಿದೆ?
There evidence
ನೀವು
ಎಲ್ಲ
seize
ಓದ್ಬೇಕು.
ಮಾಡ್ಕೊಂಡಿರ್ಬೋದು.
ಅಲ್ಲ ಎವಿಡೆನ್ಸ್ ಎಲ್ಲ ಓದ್ಬೇಕು. I'll get ready, my lord. It is a matter which requires fresh matter, my lord. I'll accept notice.
all right, issue emergent notice. Learned AG is requested to accept notice for respondents 1 and 2. How many states of Karnataka in Karnataka? Just states ಇದೆ ಕರ್ನಾಟಕದಲ್ಲಿ. See your caste title. Karnataka is one state. ಕರ್ನಾಟಕ ಏಕೀಕರಣಕ್ಕೆಲ್ಲ ಫೈಟ್ ಮಾಡಿದವ್ರು ನಿಮ್ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಓದಿದ್ರೆ ಏನ್ ಅನ್ಕೋತಾರೋ?
ಸ್ಟೇಟ್ ಆಫ್ ಕರ್ನಾಟಕ 2.
ಎರಡು ನೀವು ಹಾಕಿ, ಮೊನ್ನೆ ಇನ್ನೊಬ್ರು 7 ಹಾಕಿದ್. 7 states of Karnataka.
My lord,
Karnataka is one. Read what Alur Venkatrao wrote in Karnataka Gata Vaibhava.
yes.
ಮತ್ತೆ ಇಂಥದ್ರಿಂದನೇ ಎಲ್ಲ ಡಿವಿಜಿವ್ ಟೆಂಡೆನ್ಸಿ ಎಲ್ಲ ಸ್ಟಾರ್ಟ್ ಆಗೋದು.
Moreover, my lord, KAT has held, my lord, it's a premature application.
ನೋಡ ಅವ್ರಿಗೆ ನಮ್ಗೆ ಇಷ್ಟು
Mere show cause notice, my lord.
that's all right.
Yes,
Just
ma'am.
you took a notice and you wanted to prepare.
Yes, my lord. I'll go through every evidence, my lord.
Yes.
One,
She argued so well. Though when we opened, totally we were against her. Good. Ah,
Petitioner, my lord, being aggrieved by the impugned recommendation, my lord, made by the State Human Rights Commission, paragraph 7B, my lord, yes, before my lordship. My lord, on 13/7/2018, my lord, when these petitioners, my lord, were working as head constable and police constable in the police station at Malvalli, my lord, one accused, my lord, has committed suicide inside the police station, my lord. My lord, with regard to the same, my lord, on 13/7/2018, my lord, these petitioners were kept under suspension, and thereafter, my lord, suspension was revoked and departmental inquiry was ordered, my lord. Simultaneously, my lord, the State Human Rights Commission, my lord, based on the newspaper report, has also initiated the suo motu proceedings, my lord, about the custodial death of the accuser, my lord. Thereafter, my lord, departmental inquiry was
ಯಾವ offense accused?
only, my lord, they have failed to take care of the accused.
That accused
Accused theft, my lord,
theft.
theft. The charge made against these petitioners is that, my lord, they committed negligence while they are on the duty, my lord. The departmental inquiry, my lord, charges were proved and the punishment was imposed, my lord, on 31/12/2020, imposing the penalty of withholding next annual increment for a period of 6 months, my lord. Against the
For a
said
period of 6 months.
6 months. Without cumulative effect, my lord.
Annual.
Annual increment. Lord,
ಆ period ದುಡ್ಡು ಸಿಗಲ್ಲ.
my lordship, based on the said punishment order, my lord, the petitioner being aggrieved with the same, my lord, they have prepared the statutory appeal before the authority, my lord. That appeal came to be dismissed also, my lord. Thereafter, my lord, the petitioner.
Requires consideration.
My lord, may I request, my lord, this writ petition is not maintainable only on one ground, my lord. The petitioner has challenged this, the State
report.
Human Rights Commission report only on the one ground that the application before the tribunal is allowed, his application allowed and that was quashed. Lord, the inquiry conducted by the Human Rights Commission, it is under statutory inquiry, my lord. They have a right to conduct inquiry.
They
There
have
it is
made
proved.
recommendation, government has to
There
act
it is
upon that
approved.
recommendation.
It shows that the petitioners were omission in their part of the work, my lord. That is a different aspect. Here, my lord, what is that? The tribunal has set aside only on one ground that it is not on the merit, my lord. It's only on the charge sheet which is issued by is supposed to be issued by the inquiry officer. It is issued by the appointing authority. On that ground, it
On
was
jurisdiction.
also.
Whether liberty is reserved.
No, my lord.
Liberty is not reserved. But only why I am submitting this, my lord, because the inquiry officer before the Human Rights Commission, he has not taken aid of this inquiry, my lord. He has conducted inquiry. He has seen that there is a omission part of the petitioner hearing.
No,
So
when,
because of that, recommendation is made.
All right. When disciplinary action is set aside
Obliged, my lord.
on the ground of lack of jurisdiction, competence, it's not end of the matter.
That is, I agree, my lord.
That's what.
I agree.
Whether no liberty is reserved or not, it is always open to the
Obliged, my lord.
authorities to take that.
Obliged.
Because there is nothing on record which prevents you.
I deeply oblige, my lord, what my lord has said, but the inquiry which is conducted by the Human Rights Commission, it is under the different statute. That is
Correct.
not, he has not relied on that, the
Report at
the
all.
report which is issued by the
Independently.
discipline.
No, my
So
lord.
what you are going to do to this report?
Lord, it will be submitted to the government, my lord.
Government and government,
Government
how
will
government
take a
treats it?
decision.
What
He
is
has
the
allo-
legal framework?
ಹೌದು.
Legal framework ಏನಿದೆ? How that
17
report is treated?
Lord, may I read 17, my lord, section 17, my lord.
Page 70,
17, my lord.
17,
Section 17 of the Karnataka Human Rights Commission.
Human
There
Rights
is
Commission Act.
there is a power of Human Rights Commission to make an inquiry.
ಕರ್ನಾಟಕ ಆಕ್ಟ್ ಇದೆಯಾ?
Human Rights Commission Act.
ಕಮಿಷನ್ ಇದೆ, ಕರೆಕ್ಟ್?
ಹೌದು.
ಸೆಂಟ್ರಲ್ ಆಕ್ಟ್ ಅಲ್ಲ ಅನ್ನೋದು.
My lord,
Lord,
this
protection
report,
of human rights,
this report is
1993.
purely based on the departmental inquiry report.
Only report.
No, my lord,
Huh?
this recommendation and the opinion submitted by the commission, my lord, is purely based on the departmental inquiry report, my lord. Kindly see, my lord, page number 25.
Correct. Now, after this report has come,
Please, my lord,
it is not going to affect proprietary vigor. It does not, on its own, it does not operate.
please, my lord.
This is submitted to the government.
Government,
Government
If
has.
government wants to take action personally against you,
Please.
they will issue notice to you.
yes, issued, my lord.
Thereafter, you will send your reply to that.
Yes, my lord.
Have you sent that reply to?
Yes, my lord.
And what they said?
My lord, annexure C, my lord, now they have issued notice.
Ah.
Why that amount should not be recovered from my salary, my lord?
Show that.
Annexure C, my lord.
Correct. You show that.
Yes, my lord, you have submitted our reply
A reply consider ಮಾಡ್ಲಿ ಅಂತ order ಮಾಡಂತ.
stating that, my lord, honorable tribunal has set aside the penalty order. But in spite of that, my lord, they have issued notice,
ನೋಟಿಸ್ ಕೊಟ್ಟಾರ ಅಷ್ಟೇ.
notice ಕೊಟ್ಟಿದ್ದಾರೆ.
ಹಾ. ಅವ್ರು ಮಾಡ್ಲಿ ಅದ್ರ ಮೇಲೆ ಇದನ್ನ ನೋಡ್ಕೊಂಡು ನಿಮ್ ನೋಟಿಸಿಗೆ ನೀವು ಉತ್ತರ ಕೊಟ್ಟಿರಿ ಈಗ.
ರಿಪ್ಲೈ ಕೊಟ್ಟಿದ್ದೀವಿ
ಹಾ,
ಸರ್.
ಆ ರಿಪ್ಲೈ ಮೇಲೆ ಕನ್ಸಿಡರ್ ಮಾಡ್ಲಿ ಅವ್ರು.
That may be done.
ಅಷ್ಟೇ.
Obliged.
ಬರ್ಕೊಳ್ಳಿ. This petition by two police officials calls in question the Karnataka State Human Rights Commission's report dated 31/3/2022, wherein certain recommendation is made for taking action against them. First, learned counsel for the petitioner argues that the report of the commission is structured on the basis of disciplinary action which has been set aside by the tribunal in his application number
1400 and 1401 of 23, page number 41.
400
And-
and 1401 of 2023, by the order dated 2/11/2023. Toli, ಕುತ್ಕೊಂಡೆ ಹೇಳಿ. He also points out that the notice now has been issued to him based upon the report, to which the petitioners have replied, pointing out the defect therein, apparent defect therein. First, apprehending some penal action based on the said report, comma, petitioners are grieving before this court. First. Next paragraph. Learned AGA appearing for the answering respondents vehemently opposes the petition, contending that the report is prepared by the Karnataka Human Rights Commission, which is a statutory body constituted under the provisions of ಯಾವ section, ಯಾವ act?
Lord, Karnataka Human Rights, sorry, my lord.
Karnataka
Protection
Human
of,
Rights Act ಇದೆಯಾ?
sorry, my lord, sorry. Protection of Human Rights Act 1993, my lord.
ಅಲ್ಲೋಡಮ್ಮ. Under the provisions of Protection of Human Rights Act 1999,
93.
semicolon, 89,
93, my lord.
93, semicolon. Report as such does not have enforceability, proprio vigor, semicolon. On the basis of report, notice is issued to the petitioners and they have replied to. Semicolon. Matter is being examined at the hands of the government, examined at the hands of the government, and therefore the petition is premature. So contending, he seeks dismissal of the writ petition. Having heard the learned counsel for the parties and having perused the petition papers, we are broadly in agreement with the submission of learned AGA that the petitioners hastily have invoked writ jurisdiction of this court, apprehending action, apprehending immediate action. Semicolon. The report is prepared by the commission and it is submitted to the jurisdictional authority. Semicolon. Petitioners have been issued a notice on the basis of the report as to why a particular action should not be taken against them. Semicolon. Petitioners have sent their reply to the same. So that being the position, they should wait the action to be taken on the basis of the report, keeping in view the reply sent by the petitioners to the show cause notice. First, thus the challenge is preposterous. First, in the above circumstances, petition is disposed of, reserving liberty to the petitioners to take appropriate proceedings if and when any adverse order is made in terms of the report. First, in that connection, all contentions are kept.
Back to appear for the complainant.
I am appearing for accused number 1 and 5, my lordship. The accused number 1 and 5 are present.
Case
before
of
the Honorable
criminal
Court, sir.
contempt
I'm
with the filed, my lord, after having obtained the consent of the learned advocate general. My lord, the contention is that the petitioner, my lord, was a successful auction purchaser. And a series of cases, my lord, numbering 14 cases is mounted, all with, my lord, the sole intention of avoiding handover of possession to the auction purchaser.
my lordship.
ಈಗ possession ಕೊಟ್ಟಿದ್ದಾರೆ ಈಗಾದ್ರೂ?
Yes, my lord. Now I'm in possession, my lord. I've placed a memo with those documents to show that I'm in possession.
Delivered the possession now? ಯಾರಿದ್ರು possession ದಲ್ಲಿ? ಬನ್ನಿ ಈ ಕಡೆ.
ಇದೇ ಕೋರ್ಟ್ ಅಲ್ಲಿ ನನಗೆ ಆರ್ಡರ್ ಕೊಟ್ಟಿದ್ರು ಸ್ವಾಮಿ ಆಕ್ಷನ್ ಹಾಕ್ಬಾರ್ದು ಅಂತ. ಬಟ್ ಆಕ್ಷನ್ ಹಾಕ್ಬಾರ್ದು ಅಂತ ಆರ್ಡರ್ ಕೊಟ್ರು ಆನ್ ಒನ್ ಕಂಡೀಷನ್. 31st ಆರ್ಡರ್ ಮಾಡಿದ್ರು. 1ನೇ ತಾರೀಕು 25 lakhs ಕಟ್ಟಿ ಅಂತ ಹೇಳಿದ್ರು. ಇದು ಸೇಮ್ ಕೋರ್ಟ್. ಬಟ್ 1ನೇ ತಾರೀಕು ಕೊಟ್ಟಕ್ಕಾಗಿಲ್ಲ. ಕಾಲ್ ಕೇಸ್ ಆನ್ 2ನೇ ತಾರೀಕು ಅಂತ ಬಂತು. ಬಟ್ ಡ್ಯೂ ಟು ಬ್ಯಾಂಕ್ ರೀಸನ್ ಒಂದನೇ ತಾರೀಕು ಕಟ್ಟಕ್ಕಾಗಿಲ್ಲ ಡಿ ಮಾರ್ನಿಂಗ್ 10:30 ಒಳಗೆ ನಾನು 25 lakhs ಡಿ ತಗೊಂಬಂದು ಬ್ಯಾಂಕ್ ಕಟ್ಟಿದೆ. ಈ ಓನ್ಲಿ ಅಲೌಡ್ ದ ಡಿ ಆಲ್ಸೋ. ದೆನ್ ಆಲ್ಸೋ ದೇ ಆರ್ ಆಕ್ಷನ್ ಮೈ ಪ್ರಾಪರ್ಟಿ. 5 ಕೋಟಿಗೆ ಹೋಗೋದು 2.25 ಕೋಟಿಗೆ ಆಕ್ಷನ್ ಹಾಕಿ ಸೇಲ್ ಮಾಡಿದ್ರು. ಬಟ್ ಅಕೌಂಟ್ ನಂದು NPA ಅಲ್ಲ. ಮಾರ್ಚಲ್ಲಿ ಅಕೌಂಟ್ NPA ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಬಟ್ ಜುಲೈವರೆಗೂ ಅಕೌಂಟ್ ಆಪರೇಟ್ ಮಾಡಿದ್ದೀನಿ. ಆದ್ರೂ NPA ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಕೊರೋನಾ ಸೀಸನ್ ಅಲ್ಲಿ ನನ್ನ ಬಿಲ್ಡಿಂಗ್ ಆಕ್ಷನ್ ಹಾಕೋದು.
ಮೈ ಹಂಬಲ್ ಸಬ್ಮಿಷನ್ ಸ್ವಾಮಿ, ಇದರಲ್ಲಿ ಇನ್ನೂ ಹಲವಾರು ಪ್ರಮುಖ ಅಂಶಗಳಿದೆ ಸ್ವಾಮಿ, ಹೇಳ್ಬೇಕು ಸ್ವಾಮಿ. ಒಬ್ರು ಹಿರಿಯ ವಕೀಲರು ಸಹಾಯ ತಗೊಳ್ಬೇಕಂತಂದಿದ್ದೀನಿ. ದಯಮಾಡಿ ಒಂದು 2 ವಾರ. ಐ ಆಮ್ ಫಾರ್ ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 and ಅಕ್ಯೂಸ್ ನಂಬರ್ 5 ಸ್ವಾಮಿ. ಅದರ್ ಅಕ್ಯೂಸ್ ಪರ್ಸನ್ಸ್ ಆರ್ ಆಲ್ರೆಡಿ ಡ್ರಾಪ್ಡ್ ಔಟ್ ಫ್ರಮ್ ದ ಪ್ರೊಸೀಡಿಂಗ್ಸ್. ಎಸ್ ಸ್ವಾಮಿ, ಐ ರೆಪ್ರೆಸೆಂಟಿಂಗ್ ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 and 5 ಸ್ವಾಮಿ. ಒಬ್ಬ ಹಿರಿಯ ವಕೀಲರು ಸಹಾಯ ತಗೊಳ್ಬೇಕು. ದಯವಿಟ್ಟು ಒಂದು 2 ವಾರಗಳ ಕಾಲ ಅವಕಾಶ ಮಾಡಿಕೊಡಿ ಸ್ವಾಮಿ. ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ ನಾನು ಫುಲ್ ಡೀಟೇಲ್ಡ್ ಹಿಯರಿಂಗ್ ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ, ಟು ಅಡ್ರೆಸ್ ಬಿಫೋರ್ ಚಾರ್ಜಿಂಗ್.
Something else.
ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಒಂದು ಶಾರ್ಟ್ ಕಂಡೀಷನ್ ಕೊಡಿ ಸ್ವಾಮಿ.
Compromise in possible ಇಲ್ಲ no?
But 5.5 crores over 2 crore 21 lakhs single bidder. That bidder is same adjustment with bank. Ide bidder on 10 to 18 properties ತಗೊಂಡಿರ ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ. They are same in this.
ಮಾತಾಡ್ತೀನಿ ಸ್ವಾಮಿ ಅದ್ರ ಬಗ್ಗೆ.
Not true, my lord. If such a submission is made, I'll have
I
to
got
respond.
all details.
Whether any other properties you have bought in auction?
By her, my lord, I'll check. She is the auction person. I'll check, my lord.
How
but I
many
don't-
properties she has bought a similar way?
I will check, my lord, but.
Petitioner, the
but my lord-
complainant to disclose on affidavit as to how many similar bank auctions she has participated in and bought the properties in the last 5 years,
I'll
in
disclose.
the preceding 5 years.
I'll disclose, my lord,
Okay.
but my lords may also consider this. It
Yes,
is,
sir.
it is
But
not
it is
only
body.
suits. See,
ನೋಡಿ,
brother,
ಏನಾಗಿದೆ ಅಂತ ನೋಡ್ಬೇಕಲ್ಲ ಈಗ ಜಸ್ಟಿಸ್
Please.
ಎಲ್ಲ ಆಸ್ಪೆಕ್ಟ್ ಈಗ 1 ಕೋಟಿ ರೂಪಾಯಿ 50 ಕೋಟಿ ರೂಪಾಯಿ ಪ್ರಾಪರ್ಟಿನ 5 ಕೋಟಿಗೆ ಮಾರಿ ಹೋದ್ರೆ ಮುಂದೆ ಅವ್ರ ಗತಿ ಏನಾಗಬೇಕು ಸಿಟಿಜನ್ಸ್ ಅದು. ಹಂಗಾಗಿ ಇದನ್ನ ಕೊಡಿ ನಮಗೆ ನೋಡ್ಕೊಂಡು ಇದೇ ಬಿಸ್ನೆಸ್ ಮಾಡಂಗಿತ್ತು ಅಂದ್ರೆ ಇಟ್ ಈಸ್ ಒನ್ ಆಫ್ ದಿ ಫ್ಯಾಕ್ಟರ್ಸ್ ಫಾರ್ ಅಸ್.
certainly, ma'am.
Correct.
Certainly, ma'am.
ಅದನ್ನ ಡಿಸ್ಕ್ಲೋಸ್ ಮಾಡಿ ಅದು ಮಾಡ್ಕೊಂಡು ನಾನ್ ಡಿಸ್ಕ್ಲೋಸರ್ ಆಫ್ ದಿಸ್ ಫ್ಯಾಕ್ಟ್ will be viewed very seriously against the complainant.
May I also make one other submission?
Huh?
May I also make one other submission?
Yes.
my lord? They continue to prosecute all those other cases. His brother files a partition suit, sister files a partition suit, those are pending, my lord. Then, my lord, the accused number 5, he files a suit saying.
ಆ
he's
ಎಲ್ಲ
at-
ಪ್ರೊಸೀಡಿಂಗ್ ಸ್ವಲ್ಪ ಫಾರ್ ದ ಟೈಮ್ ಬಿಂಗ್ ಹಾಗೆ ಇಡಿ ಏನ್ ನಡೆಸ್ಬೇಡಿ. ಓಕೆ ಎಲ್ಲ ವೆರೆವರ್ ಯು ಆರ್ ಎ ಪಾರ್ಟಿ ಇನ್ ಆಲ್ ದೋಸ್ ಕೇಸಸ್.
Joint family.
In this
ಯು ಆರ್ ಆಲ್ಸೋ
proceedings-
ಪಾರ್ಟಿ ಇನ್ ದಟ್.
I'm also party in that, my lord.
ಸಿವಿಲ್ ಕ್ರಿಮಿನಲ್ ಎರಡೂ ಇದೆ ಏನೋ?
Civil suits, my lord.
ಸಿವಿಲ್
My lord, brother files one, interim order is granted, we seek vacating. Then sister files another one in Anekal, one in Tumkur. Then, my lord, accused number 5, he files a suit saying he's a lessee, he withdraws it. He files another suit saying he's a mortgagee. That is, my lord, no injunction was vacated. Then he files one
ಎನಿವೆ
more suit again.
ಈಗ ಬೇರೆ ಕೇಸಸ್ ಎಲ್ಲ ಇದೆಯಲ್ಲ ಇದಾಗೋವರೆಗೆ ಅಲ್ಲಿ ಬರ್ಕೊಳ್ಳಿ. It is agreed by and between the parties which you are placing on record that the suits and other proceedings concerning the subject property pending before ಯಾವ court?
My lord, there is a
ಸುಮಾರು ಹಲವಾರು ಕೇಸ್
table, my lord, in
Several courts
para 14.
ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ ಸ್ವಾಮಿ ಕೆಲವು
shall not be precipitated till next date of hearing.
ಡಿಸ್ಪೋಸ್
First,
ಆಗಿದ್ದಾವೆ.
learned judges of the concerned courts are requested to abide by this direction. All. Okay,
Great.
not. The presence of the accused is noted. Okay,
Particular date, yes, sir. Accused number 1 and 5 are present before.
1 and 5.
Yes, sir.
Which are other accused?
Other accused
It's
are
not
accused are dropped out from the proceeding, drop out
Granted,
like that, sir. Yes, sir.
All right, accused, the presence of accused numbers 1 and 5 is noted.
Particular date.
Okay. We call this matter.
After vacation, a particular date may be given.
ಒಂದು 20th January. ಅವ್ರಿಗೆ ಕೇಳಿ 20th January ಅನುಕೂಲ ಆಗ್ತದಾ? Ask them. ಆಗತ್ತಾ? 20th January. Okay. All right.
Much more.
Okay.
Lord, I appear for petitioner. Lord.
Yes.
Lord, kindly pass 2:30. ನಿನ್ನೆನು 2:30 ಅಂತಾನೆ ಆಗಿತ್ತು ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಅದು 2:30 it may be
2:30.
published.
All right. 2:30 ಬರ್ಬೇಕು. ಈಗಾಗಲೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿದೆ ಬೇರೆ ಅದ್ರ ಮೇಲೆ ಅಷ್ಟು
Even
highlight
if it
ಮಾಡ್ಬೇಕು ಏನು
published.
ಬಿಕಾಸ್ ಅದರ್ ಡೇ Shanti Bhushan has said, no, you are maintaining equidistance from both of them.
Please, my lord, your
That's
lordship had directed me to get the records.
ತೊಗೊಂಬಂದಿರಾ?
ತಗೊಬಂದ ಅದಾದ್ಮೇಲೂ your lordship had directed us to make it very clear as with regard to the 16 persons, but Leonard
The list.
Kirti, pointed out, I have bought that also, madam.
Okay. Obliged.
Please, madam,
At 2:30.
please,
That
ಅದು
before
ಇದಾದ್ಮೇಲೆ ತೊಗೊಂಬರ್ರಿ. Okay.
please.
Okay. Ah.
So 19, Parvati Maya. CV Raju.
Yeah, Lakshmi Narayana.
The same question, that
ಇವತ್ತು sir.
termination of the agreement,
Ah.
which your lordships adjourned the other matter to second week. I told my learned friend, I'll get ready.
You want in second week? Second week ಹಾಕೋಣ?
All that not, I want to assist your lordship.
That's what.
Power to terminate unilaterally is unknown. Power to terminate comes from the breach of an agreement. And every term of a breach will not get you terminate. It is only fundamental terms, not on that aspect. Since your lordship
The other
indicated.
day you mentioned Cheshire, Fifth
Yes,
and
yes.
Farmston
ಅದೇ ಅದೇ.
and Chitty.
ಅದು ಹೇಳಿದ್ದೀನಿ ನಾನು.
Here there is a
ನಾಳೆ
slight
ಬರ್ತಾ
difference.
Difference.
I am not talking of the nature of termination. Whatever is the termination, if there is a termination, good or bad, if I say that if you yourself admit there is a termination, unless you seek setting aside of the termination, you may not be able to go further, is slightly different. You know, I leave, let them say.
Of course, Sikandar has been distinguished in Kantamani. We
Call
never
this
accepted.
matter in the third week of January 2025 as requested by both the learned senior advocate Shri so and so and Shri so and so. Okay. Yes.
I request to have it day after tomorrow.
Day after. Day after ಬೇಡ. ಈ month after ಇಟ್ಕೊಳ್ಳೋಣ. Call this matter, call this matter in the third week of January, because 2013 ಮುಗಿಸ್ತಾ ಇದೆ ಅದಕ್ಕೆ.
Please.
2025, at the request of learned counsel appearing for the respondents.
Much.
Very. Yeah, Mr. Naganand is waiting for which case? 22.
Therefore, the
ಏನ್ urgency ಇದೆಯಾ?
agency and God, I am.
ಜನವರಿಯಲ್ಲಿ ಹಾಕೋಣ.
In this case, 2004, I was discharged. 2017, I retired. They have not paid me anything. At least
For
what is
discharged,
2017,
you
I
attained age of
superannuated.
superannuation.
Yes, and the industrial court, my lord, directed back wages to be paid. One kasu kotilla. Some payment they could make, my lord. PF kotilla.
21 million. Serial number 21.
20.
Sorry.
I appear for
ಕೂಡಲೇ ಯಾರಿದ್ದಾರೆ? 22.
petitioner, my lord. I appear.
You are for petitioner.
Please. My lord, matter may pass over. We are ready to address arguments on merits. my lord.
ಇವತ್ತು ಸ್ವಲ್ಪ ಡಿಫಿಕಲ್ಟಿ ಬೇರೆ ಮ್ಯಾಟರ್ಸ್ ಹಾಕೊಂಡಿವಿ. In the second week
According
of
to them, whatever is due, my lord, let them pay, my lord. Or
ನಿಮ್
50%.
ಪ್ರಕಾರ ಏನ್ ಡ್ಯೂ ಇದೆ ಅದನ್ನಾರು ಕೊಡ್ಬೇಕಲ್ಲ.
My lords, we will ascertain that as my lord, whatever is anything is due or not. my lord.
The petitioner management bank management is directed to ascertain on its own what is payable to the respondent workman. And if payable, comma, the same shall be paid to him subject to outcome of this petition. Call this matter in the first week of February 2025.
Kind permission.
Okay.
Serial number 21 after vacation.
21
Yes.
after all. In the first week of Reddy,
ಆಗಿದೆಯಾ?
ಬೈ ಆರ್ ರೆಡ್ಡಿ ಅವರು ಡಿಲೀಟ್ ಮಾಡಂತಾನೆ.
ಹಾ ಸರ್.
ನೀವು ರಿಪೇರ್ ಆಗ್ತೀರಿ?
ಇಬ್ರು ಆಗ್ತೀವಿ.
ಇಬ್ರು ಇರ್ತೀರಾ? ಬಿಡಿ. ಆಲ್ ರೈಟ್, ಓಕೆ.
Payable as per order, as per impugned order.
ಅಲ್ಲಿ ನೋಡಮ್ಮ, ಅದಕ್ಕೆ ಇನ್ ಟರ್ಮ್ಸ್ ಆಫ್ ಆರ್ಡರ್ ಇಂಪ್ಯೂನ್ಡ್ ಇನ್ ದಿಸ್ ಪಿಟಿಷನ್. ಓಕೆ. ಹೋಗಿ ಇದು ಸ್ವಲ್ಪ ಎಲ್ಲ ಸೈನ್ ಮಾಡೋದಿರುತ್ತೆ, ಪಾಪ ನಿಮ್ಗೆ ಏನೋ ಕೆಲಸ ಇರುತ್ತೆ, ಕಾಯ್ಕೊಳ್ಳೋದಾಗತ್ತಿಲ್ಲ.
ಮೊನ್ನೆ ಮಂಡೆಗೆ ಒಂದು ಫ್ರೈಡೆ ಇದು ಕೊಟ್ಟಿದ್ದೆ ಮೆಮೊ ಬಂದೇ ಇಲ್ಲ. ನಿಮ್ಗೆ ಕೊಟ್ಟಿದ್ದೆ
24 ನೆಕ್ಸ್ಟ್ ವೀಕ್ 2:30 ಒಂದೇ ಮ್ಯಾಟರ್ ಸರ್ ತಗೊಳ್ಳೋದು. 2:30 ಅದೊಂದೇ ಅಲ್ವಾ ತಗೊಳ್ಳೋದು? 2:30 ಮ್ಯಾಟರ್ ಇದೆ.
ಸೀರಿಯಲ್ ನಂಬರ್ 24 ಸತೀಶ್ ಬರ್ತಾರೆ. ಸತೀಶ್ ಬರ್ತಾರ ಮಧ್ಯಾಹ್ನ
ಎತ್ಕೊಡ್ತೀವಿ ಫೋಟೋ ಕೊಡ್ಸಿ ನಂಬರ್ ರೀಚ್ ಆದ್ರೆ ಹಾಕೋಣ.
ಅದು ಅದೇ ಇರೋದು ಮೇನ್.
Court officer, court officer, serial number 18.
ಸ್ವಲ್ಪ ಇದೇ ತರ
22nd June, he submitted the
request.
May he completed.
May 28th, my lord, is a final exam is completed. Practical was completed, my lord, on 6th June.
No, after you have this matter. After vacation.
Obliged.
Yes. Yes.
Number 18, government advocate. Come on, Devi, number.
Please. No, it's a short point.
Yes.
In fact, on the last date of hearing, my lords heard it for a very short time. It is about the use of the word continuous service in the regulations, my lords, appointment by promotion regulations of the IAS. Now, my lords, the only question that arises for consideration is when the word continuous service is used, whether it means actual service or whether notional service also can be taken into consideration. That is the only point for consideration. But before I go further, my lords, on the merits of the matter before my lords, I just wanted to place, my lords, what happened before the tribunal, because my submission would be, if my lords are considering it or merits, my lords, we are ready on that.
Ready.
But still, it might be a fit case to remand the matter to the tribunal for this reason. My lords, what happened before the tribunal was when a original application was filed, the state, my lords, as well as central government filed their objections to the matter. And the contentions of the state as well as the central government were same that continuous means actual service. So since there was no actual service, notional service is there, no dispute about it. My lords,
You can't count the notional service is your version.
No, he has notional service.
That cannot be counted.
That cannot be
is your
counted.
stand.
Is our stand.
But we ask
Please,
you,
please, my lord.
in rest of the people,
Please, my
in
lord.
the case of rest of the people,
Please, my lord.
we have been enlisted in that.
No, my lord. Now it has, except for one case,
Ah.
which is Panigri's case, which arises out of
Panigrahi case.
Panigrahi case, which arises out of a decision, my lords, of the Cuttack bench of the central administrative tribunal. Now, my lords, that was the judgment that was sought to be relied upon by the applicant before the tribunal. Now, on the same issue, in respect of the very similar provisions under the IFS rules, very same parameter provisions, there was a Madhya Pradesh High Court judgment, which was placed, my lords, by the state on behalf of the, which we had pressed into service, and Supreme Court judgment, my lords, of Girish Kumar, where the word continuous service was defined, though not was considered, though not under these regulations, but Supreme Court had said how it has to be considered when the recruitment rule from the feeder cadre provides two different set of rules. When we use 3 years of service or 3 years of continuous service, how it has to be interpreted. So two judgments were placed before the Central Administrative Tribunal, one of the Supreme Court, one of the Madhya Pradesh High Court. But for some reason, my lords, what the tribunal does is, it says, I will follow, though it is recorded in the order sheet, tribunal, my lords, does not consider, my lords, either the Madhya Pradesh High Court judgment on the point, Supreme Court judgment on the point, says that I will follow the decision of a Cuttack bench of the Central Administrative Tribunal, and on the basis of that, without any consideration on merits, there is no consideration. It says
Cuttack bench considered the very same rules.
Cuttack bench considered the very same rules.
1 second.
Please.
What the Madhya Pradesh High Court considered which rules?
My lords, IFS rules, but
These are not very same.
no, same.
Text may be same.
Text may be same. Please,
What
my lords.
Honorable Supreme Court said,
Please, my lords.
where two decisions are cited
Please, my lords.
of almost equal value.
No, that was a Cuttack bench tribunal.
Tribunal, very well.
It is Madhya Pradesh High
Tribunal
Court.
considered
Please,
the very same rules under which this case arises.
please, my lords.
Madhya Pradesh High Court considered pari-materia rules.
Please, my lords.
Can I say that way?
I can say.
Yeah.
Please,
As between same rules and pari-materia,
please, my lords.
there is the legal opinion, the opinio juris of grades
Please.
like Hamilton, Holland. They say, as between these two, the case which arose under that very rule will have some bearing on the matter.
Lords, I would have been, my lords, I would not be making this submission if the tribunal, in fact, had considered
that. Very well, we'll consider. It's a question of law.
It's a question of law. In fact,
therefore,
lots of-
need not be remanded.
Please, my lords. No, I just wanted to put it this way for this reason. Tribunal, my lords, in fact, if my lord sees the order, says talks about the law of precedents and other things, in the order sheet, in the earlier order sheet, which I'm placing along with the memo, all these contentions are recorded. But however, my lords, in the final adjudication, nothing
They
is
have not
considered.
taken now.
They have not been
Now there
considered.
is some adjudication that took place at the hands of the tribunal.
Please, they have
On
just,
facts, we have no issue at all.
please, no
On law, we have.
please, my lords.
Law, we will decide.
Please, my lords. I would be grateful. Now, my lords, insofar as Panigrahi's case is concerned, we'll put it, that was a case, my lords, arising out of the very same rules. And my lords, the central government, Cuttack bench of the Central Administrative Tribunal, the central government, my lords, implemented that order. It got implemented. Now, that is in my respectful submission. Now, in fact, my lords, we were asked to file an affidavit, or affidavit. Central government also was asked to file an affidavit because they had mentioned so many cases. My lords, I am informed that insofar as the state of Karnataka, on the basis of notional date, nobody has been considered. In fact, insofar as the case cadre is concerned, petitioner as well as all similarly situated persons, because of the nature of the rule itself, we have given notional. That is, there is no dispute about
how
that.
the rule is worded there?
Please, my lords, the rule that is worded insofar as,
Generally, the doctrine of pari materia
please, my lords,
is invocable
please.
when author of the legislation
Please.
is same, subject to exceptions, where the subject matter is same, but the authors of the legislation, statutes are different. There are judgments which say even their pari materia applies with lesser degree of force.
Please. Now, my lords, insofar as the in the present case, the petitioner, my lords, has been given the benefit of notional promotion.
Let us see the text of the Karnataka rule.
Karnataka, please, my lords. May I just pass on, my lords?
These rules are made under the Karnataka Civil Services Act.
Please, my lords. These rules, yes, my lords, they have been made under the Civil Services Act.
But they are made under the All India Services Act.
They are made under the All India Services Act. This is, my lords, for the purpose of Karnataka administration.
Karnataka.
My lords, the last page of that rule, I'll just pass it.
Must have put in service of not less than that column. Last column you are reading.
Oh, the last page, my lords. My lords, may kindly see the last entry because it we are talking about last entry. May kindly be seen.
Not less than 5 years in the cadre of Tahsildar grade 1.
He was, my lords, notionally given case junior scale, my lords, from 2006. In 2000, now from
This also says service only.
service assistant. My lords, here it is a case of by promotion. Promotion, my lords, is only on the basis of seniority. So, my lords, from junior scale to senior scale to selection grade to super time scale, petitioner, my lords, has been given notional promotion in terms of the court orders. Now, from this cadre,
Now, now we understood the point.
please,
Now, if you say
please, my lords.
pari materia,
No, this is not in parameter. I'm talking about the proviso that I am relying upon, IAS rules, my lords. That is a separate proviso. Now, this is just to show that petitioner has been given the benefit of notional promotion in KS cadre. KS cadre, he gets notional promotion. But on the basis of this notional promotion, on the basis of how the rule is worded here, promotion, my lords, under the IAS, appointment by promotion cannot be considered, is our case. Now, kindly see those rules, my lords.
simple what you are saying. Notional service cannot be counted. Actual service is
Actual
necessary.
service.
That's your stand.
And that is my stand. And there is a basis. my lords.
Cuttack court did not agree with this.
Please,
And
please.
central government accepted that version and gave the appointment also.
Please, my lords. And that was a stray case.
Madhya
because-
Pradesh High Court considered pari materia rules under
And-
the All India Services Act, they
Act
were
itself.
promulgated.
Please, my lords.
Same terminology. It said it should be actual service.
It should be actual
This is
service.
your stand.
Supreme
And-
Court considered the word phrase continuous service in a context of a different rule. And my
Different
lords,
rule. Which rules?
my lords, that was in the context of,
All India service rules.
it's not all India service rules. My lords, there were two, in the context of a recruitment rule and a seniority rule. Seniority rule provided for notional. Insofar as recruitment rule, court said, it all depends on the manner in which it is worded. Because if it uses the word continuous service, that means actual. Continuous service cannot be notional, is what the Supreme Court said. In fact, the Madhya Pradesh High Court has followed Supreme Court judgment in Girish Kumar's case to hold it, my lords, in respect of the IFS rules. Now, my lords, insofar as the central government has now also come out with their stand that except Panigrahi's case, in respect of all other cases which are similarly situated, this benefit has not been extended to anybody. So,
Let us see.
Please.
See, that except means ಏನು?
ಅಲ್ಲ,
All others
it is
actually
a
similar
stray-
such matters.
ಅಲ್ಲ, stray case ಅಂತ treat ಮಾಡಬೇಕು ಅಂತ.
ಹೆಂಗೆ?
I'll put it this way, my lords. There is no estoppel against a statute.
That's
Number one.
right.
Please, my lords.
But they are the rule makers.
ಅಲ್ಲ, they are the rule makers. It is their
They
stand.
have accepted.
No, in Panigrahi.
Position of
In Panigrahi, but here also they say it is to be continuous service. Here also they have filed an affidavit before my lords. Before the KIT, my lords, there was
We'll ask learned ASG is
ASG,
here.
please.
We'll ask him also. ಇಷ್ಟೇ ಕೇಸ್ ತಾನೇ ನಿಮ್ಗೆ?
ಇಷ್ಟೇ, my lords. Lords, my lords had directed us to file an affidavit with regard to
You said that nobody is given promotion on the basis of
notional.
notional.
But in case we have given including the petitioner.
Once, I'll just make gist of your
Please,
submission.
please. my lords.
Learned AG submits that in the text and context of the subject rules promulgated under the All India Services Act, comma, the expression continuous service means actual service in the post in question, and therefore the notional service cannot be taken into account. First, the respondent who was employee, who was applicant before the tribunal, admittedly does not have actual service in the post in question. First off, in support of this submission, he banks upon Madhya Pradesh High Court judgment in
Please, my lords.
Girisha
My lords, Madhya
Allah.
Pradesh High Court judgment.
in so and so, so and so, and also apex court decision in Girish
Kumar.
versus so and so, to contend that the court considered the meaning of that expression as employed under the
Indian Forest Service.
Indian Forest Service rules and held as contended by him. Therefore, he adds that the Cuttack CAT decision in Panigrahi versus so and so, though rendered in terms of the subject rules themselves, comma, should be treated only as a sporadic incident, though it is accepted by the central government and promotion accordingly has been accorded to the candidate therein. First, he further says that in terms of order of this court dated so and so, an affidavit is sworn to by a higher official of the department concerned to the effect that in none of the cases promotion has, the candidates have been considered for promotion to IAS on the basis of notional service. First. Therefore, he seeks invalidation of CAT order.
Lords, just
Yes,
one
more to submit?
Lords, insofar as Panigrahi, one more distinguishing factor, if my lords may note it. There, the state government had forwarded the name. Here, it is not.
You are not forwarding.
We are not forwarded.
How that's relevant for the rule?
No, just on the facts. A
He-
Panigrahi case.
He lastly adds that in Panigrahi, comma, the Orissa government had forwarded, sponsored the candidature of the Mr. Panigrahi,
Please.
unlike in this case where the state has declined to do it.
Please.
And this makes all the difference to the precedential value of the judgment. Okay. Yeah, any other thing I want to say?
Lords, I want to say.
Yes.
Lords, insofar as there's one judgment, my lords, of this honorable court. Lords, in Lata Kumari's case, where, my lords, we had not cited it, my lords, before the CAT, but I'll just pass it on, my lords. That was in the context of the very same regulations. There, my lords, the fact situation is almost similar, where a notional promotion was given. But this honorable court had, my lords, passed an order interpreting the very same proviso.
One second, in one sentence. Learned ASG has placed at our hands The Karnataka Administrative Service Recruitment bracket nalli tiddupadi amendment rules 2018 and in all fairness submits, though the expression continuous service, not less than 5 years service in the cadre, inwards complete, is employed, comma, promotions have been accorded even on the basis of notional service.
Including the petitioner.
Even to this petitioner.
Please.
Even to this petitioner. And that does not make much difference to the argued case of the state.
Please.
Okay.
Lords, this judgment, Lata Kumari's case, my lords, this is also considering
Did it interpret?
IS same proviso. A
Where is
direction
that?
was given by the tribunal, my lords, to send the name. And that has been set aside by this honorable court.
On what ground?
On the ground, my lords, that the proviso, there has to be actual service.
Where is that?
Kindly see, my lords, 12, page number 12. Internal page number 12. my lords. Ali 106 and the pink page al bardidare.
Well,
Top of the
106. huh?
Alla.
But the state government has taken.
My lords, on top of that, that is the same proviso.
Not consider the case of a member of the state
Civil
civil
services, unless on the 1st day of January, so and so.
substantive in the state service. Completed not less than 8 years of continuous service. How this 8 years of continuous service is treated?
That is the only question, my lords. Same proviso. Now, my lords, at 14, we had stated that that person, my lords, Lata Kumari was the officer in question was
Does
given.
not fulfill that qualification.
It was in 2017. Again, it was a
Where is that paragraph where it is treated?
Please, my lords. Para 18, my lords.
That aspect is not treated.
No, my lords. What the court here said was that since the name was not forwarded by the state government, the tribunal could not have given a direction because the tribunal could not have substituted its opinion, is what the court said.
That it operates on the premise
Please, my lords.
for approaching the tribunal.
Please, my lords.
The sponsorship by the state is a sine qua non.
Please.
On that premise, it is acted.
On that premise, but
But the continuous service means this ಅಂತ ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ?
ಇಲ್ಲ, on law regarding continuous service, my lord, has not been laid down. But on
Presses
facts,
into service, a coordinate bench judgment dated 8 February 2018 in WP number 1252-1256 of 2018. More particularly, paragraphs paragraphs
14 and 18.
14 and 18 to contend that on the same premise which is now being put forth, comma, the relief is denied to the litigant therein. First off, para 18 is structured on an inarticulate premise that in the absence of state's sponsorship of a candidate, comma, the tribunal could not have directed consideration of his case for promotion to IAS cadre. First off, the interpretation of the expression continuous service is not considered in any of the paragraphs of this judgment. We have considered this judgment.
it is not, but it was a case where similar person, my lords, who had got notional.
What is the, how we are, see, we have two important tests to find out what is the ratio of a decision.
Please.
One is Wambas test, which we call as inversion test. Another is Dr. Upendra Bakshi test. Something should emerge from these tests. Then that is ratio,
Please.
not otherwise.
Please, my
Okay.
lords, have noted the affidavit. I'll just place it on record.
All right, good.
Lords,
Affidavit
the
file.
judgments that has been relied upon
Okay.
by us, my lords, it is along with this memo.
Just mark. Paragraphs on mark ಮಾಡಿಕೊಡಿ.
Please.
All right. What
we'll
is
mark
your
it.
stand, Mr. ASG?
Stand, okay, on a principle of law. Is
Yes.
that the expression 8 years of continuous service appearing in regulation 5(2) would mean actual service.
Actual.
That is our stand on a principle of law, actual service. On facts, whether the R1 has completed 8 years, it is left.
It is for them to, this one.
As far as the 16 cases that the R1 had pointed out,
My instructions are that 15 of them had actually completed the actual service.
Service, one had a notional.
This Surya Madhava had not done. He was given the benefit of notional service by the CAT. And because there was a direction, we have complied with it. In case of Surya Madhava Panigrahi.
That is
direction by
that
the
is
Cuttack
Panigrahi.
Panigrahi case.
But you could have challenged it, that one.
We have not challenged it. In fact, before the CAD, when we filed the reply statement, a statement was made on behalf of Union of India that Panigrahi judgment of the Cuttack bench was complied in persona. So when I saw it, I objected. I said there is no concept of a compliance in persona. So therefore, we modified the statement filed, and we said the tribunal may decide in accordance with law, whether on the application of the Panigrahi judgment. So we left it to the tribunal. The tribunal has accepted. Therefore, to summarize the stand of the central government, our consistent stand is that the expression continuous 8 years service is understood as actual service. But for Panigrahi, we have complied with the order of the CAT and given him the benefit of added his name in the senior list.
Whether Panigrahi discussed law?
Panigrahi judgment law? Yes, it did.
And you did not, you accept, having heard you, it discussed the law.
Yes, there was a discussion. The judgment does refer to other Hyderabad bench judgments from other Supreme Court. There is a discussion, and my instructions are that that was not changed.
That's all. Learned ASG appearing for UOI submits that all through their stand is that the expression 8 years of continuous service is actual service only as contradistinguished from notional service, although they accepted Cuttack tribunal judgment in Panigrahi, which held in variance with the stand of the central government. First off, he hastens to add that the central government did not challenge the decision in Panigrahi, and the said decision was rendered after referring to decisions of Hyderabad CAT and other CAT after hearing the central government. First off, he in all fairness submits that out of 16 persons enlisted for promotion to the IAS cadre, 15 had continuous service, that is actual service, and that the one who lacked actual service was also given promotion because of the direction of the CAT.
Want to correct himself with regard to group case, he would choose to. I will not interrupt him.
Who?
No, this
No,
petitioner
that-
trying to
it
say
is
that.
stand of the, he said what has actually happened.
I want to correct.
No,
I
this,
did not say.
no, this does not maybe look so good, my lords, where the respondent is trying to. No.
Who is he batting? He should tell us.
No,
first,
no,
then it
no,
will
no,
be
that's-
easier.
It's all right, it's all right. At least after lunch, we should be little.
No, we need to digest it. So for that, a little exercise.
But as a counsel, in a very contentious case, I have always preferred to argue in the second house. In this, I have placed before this on report, the instructions received from the UOPT, page number 3.
Yes,
The
3.
Central paragraph have said 15 officers had completed 8 years of actual continuous service.
Correct.
In the post of deputy.
One officer, Surya Madhava Panigrahi,
Yes.
Cuttack.
Yes.
Ha.
There. And then you have that one para 2, with regard to Shri Yashwant Gurkar, appearing at page 469.
It is submitted if directed to the IAS officer and not a promote IAS officer. Therefore, the issue that whether he was concerned.
That will not arise at all.
Because he was a direct.
ಅದು ಔಟ್ ಆಫ್ 16 ಅಲ್ಲಿ ಒಬ್ರನ್ನ ಅವರು ಅಲ್ಲಿ ನೋಡಮ್ಮ ಔಟ್ ಆಫ್ 16 ಇದ್ದಲ್ಲಿ 14 ಅಂತ ಮಾಡ್ಕೋಬೇಕು ಗೊತ್ತಾಯ್ತು. ಅದರಲ್ಲಿ ಒಬ್ರು ಡೈರೆಕ್ಟ್ ಇಕ್ವಿಟಿ, ಹಂಗಾಗಿ 15 ಲೆಕ್ಕಕ್ಕೆ ಬರ್ತದೆ. ಅದರಲ್ಲಿ 14 ಡೈರೆಕ್ಟ್ 14 ದೇ ಹ್ಯಾಡ್ ಆಕ್ಚುಯಲ್ ಸರ್ವಿಸ್, 1 ಡಿಡ್ ನಾಟ್ ಹ್ಯಾವ್, ಬಟ್ ಸ್ಟಿಲ್ ವಿ ಅಕ್ಸೆಪ್ಟೆಡ್ ಕವಣಿಗ್ರಾಹಿ, ವಿ ಅಕ್ಸೆಪ್ಟೆಡ್ ದಟ್. ಅಲ್ಲಿ 14 ಮಾಡ್ಕೋಬೇಕು, 15 16 ಬದಲಿ 15 ಮಾಡ್ಕೋಬೇಕು. 15 ಬದಲಿ 14 ಮಾಡ್ಕೋಬೇಕು. ಫಸ್ಟ್ ಅಲ್ಲಿ ಬ್ರಾಕೆಟ್ ನಲ್ಲಿ 1 of the 16, namely Yashwant Gurukar, was not a promotee officer but a direct equity. Okay. Yes, Mr. Katie. You appear for UPSC. Ha. What it says. What is? Which paragraph? Where have you stated? 5.2. 5.2 was considered. Page 24. This office memorandum issued by whom? Saying come to para 4. Come to para 4. Para 4 discusses it. Notional service render can be considered or not. Where is the answer? Which paragraph? Which paragraph is answers the question? Okay. All right, read that. Merkel. Learned panel counsel appearing for the UPSC takes stand consistent with the one taken by the state government and by the central government, pressing into service the DOPT OM dated 3/11/2020, more particularly paragraph 4, which raises the question, and paragraph 5, which in a way answers the same. Any other? No, that's not the point. Point is not that. Point is very specific. National service, actual service. So simple. Yes, next.
Lords,
Oh,
just
that-
one interruption, if my lords may permit. Lords, whatever has been read out now, the same stand, my lords, is also reflected in the central government's affidavit, para 5.11 to 5.13.
Yes, yeah, we have said that.
Please,
That is their stand.
the reason on the basis of for why it was being insisted, because
But
there
our
has to be a
question
logic
is-
for insisting on certain.
Our question is,
Please.
CAT shares writ jurisdiction of the court.
Please.
CAT, after adverting to decisions of various other CATs,
Please.
has rendered that judgment to which central government was a party. And its contention that continuous service means actual service in contradistinction to notional service was not given imprimatur by the CAT. And that judgment they have accepted. What is the effect of they accepting the stand in terms of Panigrahi will be relevant for us. If you want to throw light on that finer aspect, we permit you to argue, otherwise not.
Please, my lords, yes. Lords, in respect of that, may I just make my submission?
Yeah.
My lords, there is one Hyderabad decision. Hyderabad bench, my lords, was followed by Cuttack. Lords, insofar as that was the only thing. There is one Hyderabad bench of the CAT and the Cuttack bench of the CAT.
No, and then the ASG said,
please, my lords.
the Cuttack bench considered, because I have not read the file.
Please,
We are making observation based upon what is being traded here.
Please, my lords.
Learned ASG said, Cuttack bench inter-alia considered Hyderabad bench judgment also. Whether that judgment you are citing?
Yeah, that's Hyderabad. Hyderabad was, my lords, followed by Cuttack. Hyderabad follows Rajoria of the Supreme Court, where, my lords, the issue was not of continuous service. Madhya Pradesh High Court considers Rajoria and Girish Kumar and follows Girish Kumar. That is, my lords, there is one judgment where Rajoria says this notional service can be considered. That is of Supreme Court. Maybe we'll place it also, my lords, because
under which rule it is?
My lords, it's under a totally different rule. It was only about general interpretation, about continuous service, not continuous service. Rajoria, there is one case, my lords, we don't have it. That has been followed by the Hyderabad bench, and it is also referred to, my lords, in the Panigrahi's case. So, my lords, there are two Supreme Court judgments, Rajoria and Girish Kumar. Madhya Pradesh High Court finally says that it is Girish Kumar that is applicable on the facts of the case. So, my lords, my respectful submission would be that would be the view to take, my lords.
What is the impact of Madhya Pradesh High Court judgment in the light of that another Kusum Ingot?
Please, lords. Insofar as, lords, Madhya Pradesh High Court arose out of a
Have you seen Kusum?
I've seen Kusum Ingots. My lords, here what happens is, since my lords refer to Chandra Kumar, lords, what happens is, though my lords, they have the power to issue writs, though my lords, they are literally, my lords, exercising my lords, the powers, my lords, of the High Court, and there is a division bench supervision, my lords, by the High Court insofar as 227 is concerned. But Madhya Pradesh High Court arose out of 227, supervisory jurisdiction arising out of the order passed by the tribunal. So therefore, my lords, insofar as presidential value is concerned, there are inferior tribunal orders. There are two orders, my lords, of the Central Administrative Tribunal. And, my lords, when Central Administrative Tribunal of the Bangalore bench was considering, it had, my lords, before it two judgments, my lords, of the
Madhya Pradesh High Court and Cuttack bench.
No, my lords, Cuttack bench and Hyderabad bench, and then the Madhya Pradesh High Court.
No, why do you say two benches? Cuttack judgment considered Hyderabad also, even according to you.
It follows.
That's what.
Hyderabad is also a Central Administrative Tribunal. But at the end of the day, my lords, what they do is that is not even referred to. And finally, my lords, it is recorded in my, in the earlier order, this stand has been specifically recorded based on the judgment, my lords, of Madhya Pradesh High Court and Girish Kumar. But in the final order, there is no adjudication at all. They just say you consider in terms of Panigrahi because central government has accepted the stand and because they amended their reply to the original application.
But my question remains unanswered.
Please, my lords.
What is the impact of Kusum Ingot?
Please, my lords.
On Madhya Pradesh High Court judgment?
Please.
Because some courts have taken the view, some high courts in the country have taken the view, where the other high courts interpret the central legislation, and those judgments will be binding, not just having persuasive value, but they will be virtually binding on rest of the high courts ಅಂತ ಒಂದು ಲೂಸ್ ವೀವ್ ಇದೆ. ಅದರ ಬಗ್ಗೆ ಏನ್ ಹೇಳ್ತೀನಿ ಅಂತ ಕೇಳಿದ್ರು. Presuming got para 22, something like that.
Please.
Para, Kamat, para 22 or something like Kusumin.
26.
It appears Mr. Fali Nariman wrote an article
Please.
on this criticizing, said it upsets the principles of federalism. There is one article like that, right, Indian Bar Review or something like that. I don't remember. Anyway, we will consider since.
No, it's in
Yeah,
fact, if
Any, Mr. Khetty?
To resort to sort of discovery proceedings twice this matter,
Discovery, that order, etc.
2 rounds of order.
asking us to file affidavit says what?
He has a flowery language. He's gifted with that great thing. Anyway,
Aspects.
can you put on your mic? Yes.
No, there are two aspects which were dealt with by this court at the inception before we went into the arguments per se. One is with regard to 5.2, my lords had asked them whether there is any notification with regard to the post of deputy collector or equivalent. I'll take my lords through that in detail, but just preface it a bit. They come back with an affidavit saying there is no post of deputy collector in Karnataka, and they follow it up with or equivalent is explained, because those are the two posts for which I am entitled to be in that feeder cadre, that I can then be promoted to IAS. When it came to the equivalent part of it, they say there is no declaration of equivalence either. The next part of it is in their written statement before the CAT, they say, we decide this on a case-to-case basis. While that stands now, as far as the state government is concerned, my lord, with regard to the IAS promotion rules, it is the DOPT which has the final say in this matter. And for that, even the UPSC has put it down in their statement of objection, or rather in their written statement before the CAT, where they say interpretation and clarification with regard to the IAS promotion rules is within the domain of the DOPT. So the central agencies are very clear and the central departments are very clear that it is with the DOPT to decide on this issue. As far as the state government is concerned, I can only say that the state government is a busybody in this matter to the extent we shall discover why and how. My first submission in this, therefore, would be, how did this entire issue come about?
No, we are
This
asking
issue-
you.
No,
Instead
shall
of
we
all
go
that,
ahead? I'll just,
can we say?
can we start?
Because many, otherwise you'll have it after vacation.
No, my lord may continue.
Then you have to
My
be
lord may
very
continue to
concise.
address.
So many people, we have to ration the court time. We are asking you 2 questions now.
Yes,
They say continuous service means actual service.
that's right.
You contradict it because
I will deal
of
with it.
Cuttack, I understand of that they have accepted Panigrahi and therefore they cannot contest. This you have argued on the other side. The next one is collector is deputy commissioner and deputy collector is assistant commissioner.
Where do we get that?
Equivalent.
That is my,
That's the
that was our poser.
Give that.
Where do we get that?
Give that.
That's a poser and that's been denied. My lord, I will deal with only one aspect first,
Ah.
which is captured in my lord's statement, my lord's,
ಅದನ್ನ ಅಷ್ಟು ತೋರಿಸ್ಬಿಟ್ಟು
my
ಮುಗಿದು
my lord had
ಹೋಗ್ತದೆ.
asked
ಅಷ್ಟೊಂದು
this.
argument
Just 2
ಬೇಕಾಗಿಲ್ಲ.
lines.
ಅಷ್ಟೇ.
My lord, give me a little leeway.
Ah.
My lord, this is what the court had asked the central government on the previous occasion. Learned DSG has to state as to whether the 16 candidates enlisted so-and-so by name Yashwant Gurukar appearing in page 469 were considered for promotion. Instead of 2, it should be in IAS, within IAS, on the basis of notional service, though they had not put in actual service, officiating or substantive in the feeder cadre. That's the sum and substance of what they are trying to say with regard to Girish Kumar's case. Now, this is what I have to first point out from the records of this case, my lord, that consistently they have been giving promotion to persons. And this has not been done just like that. This has been done because there are rules to that effect and there are OMs to that effect. In my case, they do not wish to bring those things to light for the simple reason they do not wish to give it. It is not that I am
Or
trying
which
to
are
say
those?
that
Give
they are
us.
wrong.
Give
I am
us.
trying to say that they are not pressing those rules into service.
Give them.
In the instant case, they are not even bringing it to the notice of the court, my lord. So I would like to point out what the UPSC has read, my lord.
ಅವಶ್ಯಕತೆನೇ ಇಲ್ಲ. ಇಲ್ಲಿ ರೂಲ್ ಮೇಕರ್ ನಿಮ್ಮ ಮಗ್ಲಲ್ಲಿ ಕುತ್ಕೊಂಡಾರೆ. ಅವ್ರು ಏನು ಅಂತ ಹೇಳಿದ್ರು. In all fairness, he said, we have not challenged Panigrahi also.
No, not having challenged Panigrahi meant what?
Means
it is
accepting the legal exposition of law done by the CAT, arguably.
And also, now I am adding to that. If that comes, I'm fine on one wicket. The second part of it is, as far as Girish Kumar is concerned, Girish Kumar has also been complied with. Girish Kumar requires to be done, and Girish Kumar does not take into account the fact that, as my lord had posed the question, this is in the context of which rules? These are in the context of certain Maharashtra rules, recruitment rules and pay rules, not in the context of these
IAS rules.
IAS. And in this context, I would like to take my lord's
Mr. Khetti
the particular rule.
tells us that Girish Kumar was decided in the text and context of state rules, which are much different from the IAS promotion rules, and therefore it cannot be cited as an authority in support of the proposition of the state. Okay, next point.
My lord, may kindly take page 474 of my volume 3.
For the proposition?
For the proposition that there is a particular OM which enables the central government to grant promotion retrospectively and without reference to actual service.
Is it?
Yes.
He submits that central government has issued OM dated. Mr. Khetti, dated.
My lord, OM number 22011
Dated
/5/ just dated is 10/4/1989.
10/4/1989, providing for the grant of IAS promotion, even with retrospective effect, on the basis of notional service, correct?
Yes.
Service. This OM is found at page number?
This is also found in its entirety. The extract is at page number 474. But the entire OM is at page 543. The entire OM is there. I have annexed the entire OM.
543.
The relevant portion is here.
Paragraph
20.4.1.
20.4. 20.4.1. Not a is found at page 543, PB3. Wide paragraph 20.4.1. It relates to retrospective promotion. And obviously granted taking into account the notional service. Yes.
This is to be traced back to the origin of this entire matter, where persons with disability were not provided with any form of reservation, despite the act having come into force in 95. Till 2004, there was no arrangement made. In the state of Karnataka, the act was not implemented. Therefore, the concerned petitioner went, applicant before the KAT, went ahead and fought for this, and after, he was the harbinger of this. He started the whole process, and that is why he is being victimized till date. It is 2 decades plus. The entire issue arose out of that, and that is why if he was denied that, he was given promotion with retrospective effect. But that was pursuant to a second round where the order was modified by the state government. And this modification came about not just as a gratuitous manner. It came about pursuant to establishing that he was entitled to a Group A promotion.
Yeah. Mr. KT points out the legal saga which his client had fought to get accommodation in the policy enacted in the Act of 2016 Act.
95.
95, it's repealed.
First one.
But he
After
fought
that-
under the old act only.
Yes, because it was,
Under the erstwhile 1995 Persons with Disabilities Act, na?
yes.
Yes, Act 1995. 95.
Manoj, may kindly see the modified order of the state government and then the promotion orders that have been given by the state government. Now I'll move
No,
on
they
to
relate
to the relevant rule.
Promotional promotion.
Similarly, like this, there is also another rule of the state government, my lord, which enables them to do it. Why I am drawing my lord's attention to the particular order by which he was granted this appointment to the KS pursuant to the order of the KAT is because of this reason, my lord. There is the RPP rules. Those rules enable the state government to do it. The order is there, which is read with that. In these situations,
Rules under the
yes,
Disabilities Act rule,
no,
under service rule.
under the service rules. Kindly see these rules, my lord. Page 474 again. That is also produced by me at page 554. The entire rules.
Five 54 is Act rule.
No, that is the one which I had pointed out earlier.
554. Five 49.
That is at, the extract is at page 478.
Four 78.
And the entire enactment is at 554.
That is triple P.
I'll just read it. Not may kindly see. Page 478
470.
of volume 3. This is the relevant portion. The rest of it is there for perusal of the court in its entirety, my lord. It is by using this provision volume 2.
How this provision is applicable to you?
Not 7. Your final order. Modified order.
That was under the context where a person is denied consideration of his case for promotion because there is a DE pending against him, where he comes out unscathed in the DE, then in retrospective promotion, it speaks of.
Yes,
But this is not that case, very simple
it
case.
may not be that case, but in all situations where if a person is deprived of that, then this is the provision that is the enabling provision which enables them to do this. In any scenario, whether while in service, the service is stymied by virtue.
This is a state promotion.
This is state promotion. So I would,
Central.
so this court had posed two questions, one to the central government, one to the state government. My learned friend said that, no, we have not done anything to that effect, that we have not given promotion without actual service by anyone in the feeder cadre.
No, in the state service, they have done. That's what he admitted. He opened very fairly, he said. So in the state, we have promoted even on the basis of national service because our rules are a bit different.
The entire crux of the Girish Kumar case is that unless there is actual service in the feeder cadre, you cannot be promoted. There cannot be a concept of notional service. That is the crux of his argument, wherever it may be. He has drawn upon Madhya Pradesh, he has drawn upon the Indian Forest Service, he has drawn upon all over.
No, he did not go to Madhya Pradesh without justification. He went to Madhya Pradesh because Madhya Pradesh High Court considered pari materia provisions of Forest Service, Indian Forest Service. They have almost identical term is his version that way. Not that, no, what we fail to understand is how the rules in the state which provide for promotion in the state cadres will be relevant for considering a case under the All India Service rules.
But that is the principle involved. This court had again called upon them. There was no occasion to call upon them to explain this as to how you have, how they have done this. This
Mr.
court had
Khedi
asked
submits
based
that
on this.
even within the state cadres, promotions are accorded on the basis of national service, and that too with retrospective effect. In support of that, he draws our attention to page 470, rule 9.2.
Yes.
9.2, called out in page 478 of PB3. Next point.
No, this has been done in respect of the petitioner himself, pursuant to the order of the KAT.
And this has been done in the case of very respondent employee.
And by invoking this very provision.
Next.
The order reads, read with this provision and the order of the Honorable KAT. That is the order that has been passed.
Next point.
Now, coming to the proposition that their sole objection is, as mentioned even by the UPSC Council and also by the TOPT, their point is, we need to have an assessment of the person during the period, and for that person, for that purpose, he is required to be in service during that period. And therefore, he needs to be there in actual service. Now, for that, my lords had called upon them to produce their file, my lord. My lord may kindly take their file. I had marked the...
We'll have this immediately after vacation for further hearing. Next. Third. Yes, Mr. Lakshmi, Mr. Naik.
My lord,
yes, immediately after
the
vacation.
matter has been made part heard.
Grateful.
Okay. All right.
Not
Yes, Mr. Naik.
How
How is your health now?
Fine.
Fine. You can sit and argue also.
No.
No problem.
Absolutely.
Okay.
Several councils have preceded me and have assisted the court in the matter that has arisen before the court in batch of cases. Most of the cases, as I have noticed, dealt with the posts other than the post-assistant processes with which we are dealing with. Because on facts, there may be some changes, my lords, or the process in which the selection at
Your clients belong to the cadre of assistant, they are in the posts of assistant professors.
assistant professors, my lords, they have different set of procedure which was evolved and they have undergone. So on facts, there may be slight difference because most of the cases
The selection process.
in the selection process. Now, having said that, my lords, it's my handicap is that several councils have argued, and I don't want to repeat, but I need to point out some relevant factual position, my lords, insofar as my case is concerned.
Yes.
The on facts, there was, my lords, a notification dated 8/7/2020 called Karnataka Education Department Service.
So and so rules.
Collegiate Education, Recruitment of Assistant Professors.
Page.
Special rules.
Page.
That are found at page 30 of, we have a compilation, if your lots of
Very good.
permit us.
Buddy, we have a lot of time. This time we have 4 more days in the vacation. In addition to usual 10. But
That's page 30, my lords will find this notification of 8/7/2020. I'll not trouble taking my lords through that.
page 30.
Yes.
Yes, sir.
So as can be seen from this, these special rules were framed to subserve, work out and implement the objectives of provisions of Article 371J.
Yes.
Read with the Karnataka Public Employment Reservation in Appointment for Hyderabad, Karnataka Region Order 2013. These provisions specifically refer to filling up of the vacancies of assistant professors in Collegiate Education Department under Hyderabad, Karnataka cadre, notifying 221 posts and residual parent cadre for 1021 posts by direct recruitment.
Where are you reading?
Yes, milords, that is in clause 3, milords, of at page 31. Page 31, milords, of the compilation.
31.
Rule.
Recruitment rules 2008.
Yes, milords, and clause
Governing
3
authority
thereof,
shall apply
1(3).
Hyderabad, Karnataka cadre.
Yes,
So specially made for that.
yes. So of 200,
And 121 residential parent cadre.
yes.
221 Hyderabad, Karnataka
Karnataka
local cadre.
cadre. So this has a direct nexus to, or rather the special rules were provided for working out the scheme of recruitment or the opportunities to be provided in terms of Article 371J.
Yes.
But these among others provided for by Rule 3, the qualification and the age. Under Rule 4, notifying the vacancies. Rule 6, method of selection. Rule 7, mode of competitive examination. And
Select list.
Rule 8, list of selected candidates to be notified.
9 is appointment.
Appointment. So it spelled out, my lords, the various provisions required to be adopted in making a recruitment by this special rule. But after this rule came into force, the government of Karnataka, my lords, had designated Karnataka Examination Authority as the agency for conduct of selection process
Yes.
by a notification dated 15/7/2021. But in furtherance of this notification, the applications were invited by an notification dated 26/8/2021,
Yes.
notifying the vacancies, which I read out in the special rule, under two separate cadres for working out the reservation. I'll presently explain how the cadre is identified, the vacancies are noted, and apportion takes place. They are treated as separate units for the purpose of recruitment in terms of clause 4 of this notification
Yes.
of the governor's order, I'm sorry,
2014 order,
13 order,
13 order,
specifically provides that they shall be treated as a separate unit,
unit.
cadre wise.
Correct.
So there's a cadre for Hyderabad, Karnataka cadre. There's a cadre other than that cadre with apportionment of the available vacancies which are notified, which has the pertinent reservation in terms of Article 371J, the provisions made thereunder, read with governor's order.
Correct.
So this is a scheme, Lords, of making a selection. In furtherance of this, when applications were called for, we applied, we took the written examination. Lords, this was pursuant to another circular instructions which prescribed the modality of making selection. That notification was, my lords, on 6/6/2020. That, my lord, will find at page 143 of the writ petition.
47 of the company.
ಇದರಲ್ಲಿ ಹಾಕಿಲ್ಲ ನೀವು
ಇದರಲ್ಲಿ ಇದೆ.
compilation ಅಲ್ಲಿ ಇಲ್ವಾ?
At page 47, I'm sorry.
Yes.
This, my lords, among others, I won't go into the details of this because they may have already mentioned,
10th on this.
among other, it provided for what is known as an option given as a special measure for persons coming from the Hyderabad, Karnataka region to opt for consideration in the cadre outside HK cadre, but with a caveat that once you opt for that, you would lose your categorization falling under the cadre of HK cadre and lose benefits of whatever comes out of that cadre for future, namely for promotion, for all other purposes, my lords, because they would opt voluntarily to be considered for a post outside the HK cadre. So that was the caution given under this circular, but it enabled them to opt for being considered based on their merit for a position outside the HK cadre. That's the scheme, my lords, of this circular. Accordingly, my lords, many of the candidates falling within the definition of HK region, who were, my lords, the residents or who had this benefit of being considered as coming from that, based on having born in that region or by domicile, etc., which has been noted in the governor's order. They had this option of doing that, and some of them had opted. But by that option, they did not lose being considered based on their merit in the HK region itself, because they were being, lords, the persons for whose benefit the entire scheme of 371J and the governor's order is made, had that of being considered under their Lords, I will say quota loosely for the purpose of
Our
my
understanding.
argument, understanding, to be considered, but with an option that they would also be considered outside that cadre. Now, those were the conditions on which all the candidates desirous of being appointed applied. They underwent the examination. After examination, my lords, they were based on their merit. The authorities worked out the merit list and entitlement for appointment. A provisional selection list was prepared. After provisional select list was prepared and made known, there were certain pressures from the political entities.
Prepared and published?
Yes, my lords,
Published.
it was required to be notified. It was in the public knowledge.
When it was published?
But I'm told it was published on 31/2023. That is, my lords, Annexure A to the writ petition. Sorry, A7, I'm sorry. Annexure A7 to the writ petition.
This is provisional seniority list?
No,
Provisional select list?
select list was published. And these petitioners, my lords, are all persons who find in that provisional select list. Because their grievance emanates from that position of the government having put into works the scheme of appointment in terms of the provisions of 371J, read with governor's order, read with circular of 66/2020, having undergone through the process of selection, a provisional list was notified. Next day, that is, my lords, on 2/1/2023. My lords, this was notified on 30/1/2023. That is, my lords, the provisional list. 2 days thereafter, that is on 1/2, another circular was issued by the first respondent, withdrawing the circular.
Withdrawing the circular dated
Of 6/6, my lord, 6/6, which was preceded before my selection, was a clarificatory circular which recorded that large number of representations have come from the people of that area and the political representatives of those candidates, saying that there should be a separate recruitment cadre-wise, that is HK region cadre and non-HK cadre, because rule para 4 in fact says so, that it should be treated as a separate unit for the purpose of selection.
Governor's order.
Yes. In the light of that, the government under this circular of 15/6/2022 informed or notified that without affecting the ongoing selection process, henceforth in future, it would be separately conducted. But they pointed out to the grievances made by the political representatives of the candidates. It made reference to the ongoing procedure. That becomes relevant, lords, for the purpose of consideration of one other issue as to whether the rules of the games were changed after, lords, the game had started being played. I'll come to that a little later, but the fact remains that to the understanding of the government itself, that the process had commenced, and therefore they used the word in that circular without affecting the ongoing selection process. It would be separately conducted henceforth. The last sentence of that circular said it would not affect the ongoing process. That last sentence was withdrawn by this impugned circular 1/2/23. After, my lords, the publication of the provisional select list, probably, lords, there was a pressure because candidates had known that by virtue of their
Selection.
option and merit, they would not be able to make to the positions which are available. Therefore, there was some pressure on the government. The government withdrew it on the ground, on the excuse that we intend to give them a better opportunity. In order to give them a better opportunity in terms of 371, whether it's permissible or not is the other issue, my lords, which is required to be considered at the ends of this honorable court. But that was the excuse, saying that by our changing the process, by giving them the first option to choose any vacancy which is available, irrespective of the cadre or the quota, would, based on their relative merit, would serve for the better interest of the merit of the candidates coming from this region.
That is 2/1/2023. 2/2023.
Yes.
So that is subsequent to publication of provisional select list.
Yes, my lord.
On 30 January 23.
Yes.
Correct.
That,
Which
my
is
lord,
that circular? Of
is
course,
at
many
page-
have referred, but let us see together.
that is at page 68.
Not produced in the compilation.
It is there,
It's in there.
68, annexure A8.
One to 23.
Yes. ಉಲ್ಲೇಖಿತ ದಿನಾಂಕ 15/6/22
You
ಸುತ್ತೋಲೆ
can read the last one because many others have already read it
yes,
many times.
yes.
ವಿವಿಧ ನೇಮಕಾತಿ.
ವಿವಿಧ ನೇಮಕಾತಿ ಪ್ರಾಧಿಕಾರಗಳು ದಿನಾಂಕ 15/6/22 ಸುತ್ತೋಲೆಯು ಜಾರಿಗೆ ಬರುವುದಕ್ಕೆ ಮೊದಲು ಗೆಜೆಟೆಡ್ ಪ್ರೊಬೇಷನರ್ ಹುದ್ದೆಯನ್ನು ಹೊರತುಪಡಿಸಿ ಬೇರೆ ಎಲ್ಲ ಹುದ್ದೆಗಳ ನೇಮಕಾತಿಗಾಗಿ ದಿನಾಂಕ 6/6 ಸುತ್ತೋಲೆಯನ್ವಯ ನೇಮಕಾತಿ ಅಧಿಸೂಚನೆಯನ್ನು ಹೊರಡಿಸಿ ಅಂತಿಮ ಆಯ್ಕೆ ಪಟ್ಟಿ ಪ್ರಕಟಿಸದೇ ಇದ್ದಲ್ಲಿ
ಅಂತಹ ನೇಮಕಾತಿ
ಅಂತಹ
ಪ್ರಕ್ರಿಯೆಗಳಿಗೆ
ಪ್ರಕ್ರಿಯೆಗಳಿಗೆ
ಸೀಮಿತವಾಗಿ
ಸೀಮಿತವಾಗಿ ಮಾತ್ರ
ಅರ್ಜಿ
ಅರ್ಜಿ
ಸಲ್ಲಿಸುವ
ಸಲ್ಲಿಸುವ ಸಮಯದಲ್ಲಿ ಸ್ಥಳೀಯ ಅಭ್ಯರ್ಥಿಗಳಿಂದ ಪಡೆಯಲಾಗಿರುವ ಆಯ್ಕೆಯನ್ನು ಪರಿಗಣಿಸದೆ, ದಟ್ ಈಸ್ ಆಪ್ಷನ್
ಅನ್ನು ಪರಿಗಣಿಸದೆ
ಮೆರಿಟ್ ಪಟ್ಟಿಯಿಂದ ಆಯ್ಕೆ ಪಟ್ಟಿ ತಯಾರಿಸುವಲ್ಲಿ ಸ್ಥಳೀಯ ಅಭ್ಯರ್ಥಿಗಳನ್ನು ಮೊದಲಿಗೆ ಮಿಕ್ಕುಳಿದ
ಸ್ಥಳೀಯ ಅಭ್ಯರ್ಥಿಗಳನ್ನು ಮೊದಲಿಗೆ ಕಾಮ ಬೇಕಿತ್ತಲ್ಲಿ ಮಿಕ್ಕುಳಿದ ವೃಂದದಲ್ಲಿ ಲಭ್ಯವಿರುವ ಹುದ್ದೆಗಳೆದುರಾಗಿ
ಪರಿಗಣಿಸಿ ಆಯ್ಕೆ ಪಟ್ಟಿ ತಯಾರಿಸುವುದು, ನಂತರ ಸ್ಥಳೀಯ ವೃಂದದಲ್ಲಿ ಲಭ್ಯವಿರುವ ಹುದ್ದೆಗಳಿಗೆ ಪರಿಗಣಿಸಿ ಆಯ್ಕೆ ಪಟ್ಟಿ ತಯಾರಿಸುವಂತೆ ಸೂಚಿಸಿದೆ. 15/6/22 ಸುತ್ತೋಲೆಯ ಕೊನೆಯ ಖಂಡಿಕೆಯನ್ನು
ಮಾತ್ರ ಹಿಂಪಡೆಯಲಾಗಿದೆ.
ಇನ್ನುಳಿದ ಎಲ್ಲ ಅಂಶಗಳು ವಾಗಿ ಜಾರಿ ಇರುತ್ತದೆ. 15/6/2022 ಸುತ್ತೋಲೆ, where is that page? Which is at page 60.
ಎಲ್ಲಿ ಕಾನ್ಫ್ಲಿಕ್ಟ್ ಇದೆ ಇದು ಹೌ ದಿಸ್ ಈಸ್ ಗೋಯಿಂಗ್ ಟು ಇದು ತಕ್ಷಣದಿಂದ ಜಾರಿಗೆ ಬರುವಂತೆ ತಕ್ಷಣದಿಂದ ಜಾರಿಗೆ ಬರುವಂತೆ, ಪೂರ್ವಾನ್ವಯದಿಂದ ಜಾರಿಗೆ ಬರುವಂತೆ ಅಂತ ಇಲ್ಲ. ಅದು
6/6/20
ಆಗಿತ್ತು ಇಲ್ಲಿ.
ಸುತ್ತೋಲೆಯಲ್ಲಿ ನೀಡಲಾಗಿರುವ ನಿರ್ದೇಶನಗಳನ್ವಯ ಆಯ್ಕೆ ಬಾಟಮ್ ಆಫ್ ದಟ್ ಪೇಜ್ ಈಗಾಗಲೇ ಗೆಜೆಟೆಡ್ ಪ್ರೊಬೇಷನರ್ ಹುದ್ದೆಗಳನ್ನು ಹೊರತುಪಡಿಸಿ ಒಂದೇ ಅಧಿಸೂಚನೆ ಹೊರಡಿಸಿ ನೇಮಕಾತಿ ಪ್ರಕ್ರಿಯೆ ಜಾರಿಯಲ್ಲಿರುವ ಪ್ರಕರಣಗಳಿಗೆ ಸೀಮಿತವಾಗುವಂತೆ ಮಾತ್ರ ದಿನಾಂಕ 6/6 ಸುತ್ತೋಲೆಯಲ್ಲಿ ನೀಡಲಾಗಿರುವ ನಿರ್ದೇಶನಗಳನ್ವಯ ಆಯ್ಕೆ ಪ್ರಕ್ರಿಯೆಯನ್ನು ಅಂತಿಮಗೊಳಿಸುವಂತೆ ಸೂಚಿಸಲಾಗಿದೆ.
ಏನಿದೆ ಅರ್ಥ ನಿಮ್ ಪ್ರಕಾರ?
ಯು ಕಂಟಿನ್ಯೂ with the process which you have commenced in terms of 6.6 and all this representation and wanting to have a separate selection process would be for the future. That's the purport of this. circular.
ಈಗಾಗಲೇ ಗೆಜೆಟೆಡ್ ಪ್ರೊಬೇಷನರ್ಸ್ ಹುದ್ದೆಗಳನ್ನು ಹೊರತುಪಡಿಸಿ ಒಂದೇ ಅಧಿಸೂಚನೆ ಹೊರಡಿಸಿ ನೇಮಕಾತಿ ಪ್ರಕ್ರಿಯೆ ಜಾರಿಯಲ್ಲಿರುವ ಪ್ರಕರಣಗಳಿಗೆ ಸೀಮಿತವಾಗುವಂತೆ ಮಾತ್ರ ದಿನಾಂಕ 6/6/20 ಸುತ್ತೋಲೆಯಲ್ಲಿ ನೀಡಲಾಗಿರುವ ನಿರ್ದೇಶನಗಳನ್ವಯ ಆಯ್ಕೆ ಪ್ರಕ್ರಿಯೆಯನ್ನು ಅಂತಿಮಗೊಳಿಸುವಂತೆ.
Kindly read the last paragraph at page 60, which may possibly make it easier to understand the purport of the circular. ದಿನಾಂಕ 6/6/2020 ಸುತ್ತೋಲೆಗೆ
Page 16.
60, it's the last paragraph.
You are right.
The second
ದಿನಾಂಕ
paragraph.
6/6/20 ಸುತ್ತೋಲೆಗೆ
ಕಲ್ಯಾಣ ಕರ್ನಾಟಕ ಭಾಗದ ಸ್ಥಳೀಯ ಅಭ್ಯರ್ಥಿಗಳಿಂದ ಹಾಗೂ ಆ ಭಾಗದ ಜನಪ್ರತಿನಿಧಿಗಳಿಂದ ತೀವ್ರ ವಿರೋಧ ವ್ಯಕ್ತವಾದ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸದರಿ ವಿಷಯವನ್ನು ನಿರ್ಣಯಕ್ಕಾಗಿ ದಿನಾಂಕ 7/5/22 ನಡೆದ ಸಚಿವ ಸಂಪುಟ ಉಪಸಮಿತಿ ಮುಂದೆ ಮಂಡಿಸಲಾಗಿದ್ದು, ಸಮಿತಿಯ ತೀರ್ಮಾನದಂತೆ ತಕ್ಷಣದಿಂದ ಜಾರಿಗೆ ಬರುವಂತೆ ಉಲ್ಲೇಖ 6/6 ಸುತ್ತೋಲೆಯನ್ನು ಹಿಂಪಡೆಯಲಾಗಿದೆ.
The entire circular.
Which is withdrawn, which basically provided for having a common procedure of recruitment applicable both for the HK cadre and
Local,
the rest of the cadre, that is non-HK.
non-resident cadre.
Yes, let's
Resident cadre.
residuary
cadre.
residual cadre. That was accepted because there were representations, and therefore the circular of 2020-6, which provided for a common procedure, is stated to have been withdrawn, but it also
With a
says,
saving clause.
it also says the process which has commenced
He saved.
is saved and would not be affected. This last paragraph is withdrawn by the impugned circular.
In other words, the 6/6/2020 circular is withdrawn
Yes.
to cover ongoing selection process, recruitment process also.
Yes.
So Mr. Lakshmi Narayana argued other day.
Yes. So in the light of this, the net effect is that you are absolving them of the option which they had exercised, B, enabling large number of vacancies being made available based on the merit of the candidates to choose the positions which were available to persons who were outside the HK region. Let's just to give a rough idea of how it has worked out. 80/20 is the reservation made for HK cadre. That is, Milords, people who come from HK region were facilitated with a preferential or a reservation of 80% of the available vacancies, and 20 would go to others other than people. Stand corrected, 75/25. Lord, 75 of the available seats, which are 221, would go to persons who come from HK region, and the balance 25
Yes.
the balance 25 would be available to the others. Now, my lords, leaving this, what was reserved as 221 vacancies, identifying it as available to HK region vacancies, there were 1,021 vacancies, which were meant for the others. That is persons all over the state. What is the number?
1,021.
Yes. That
221, 1,021.
in that 1,021, 8% was again reserved for people having the benefit of reservation hailing from the HK region. That's 75% within the region, 8% outside the region of all vacancies. So those were to be given to them on priority basis based on that reservation worked out. Now, the other side of this would be that 92% of 1021 would be available for others, plus the 20%, 25% which is available in HK region.
Please repeat.
The reservation which is relatable to the cadre in terms of clause 4 of the Garner's rule and the vacancies are determined by the authorities and made known to the public. Before, my lords, the process of selection takes place. Now, out of 221 which are vacancies which are available for HK region, 75% of that would go to the persons from that region on priority or based on their reservation. 25% of that would be available to rest of the residents of the state of Karnataka.
May not be. May not be.
Sorry, what he's saying, Lord, is correct. Lord, there are two cadres.
Eradu kade.
What they have done is they have actually combined it. Sir.
No.
This 1021
1021
represents the 92% plus 25%.
Well, that's what I'm going to explain.
Everybody can apply, even
Other than HK also, that way.
that is not as far as HKE vacancies are concerned.
No, I was trying to explain roughly how this system has worked and how it has affected by the circular. Therefore, I gave your lordship may not go strictly by how many number or any illustration wise. Lords, out of 221 which is available, it is apportioned 75-25, 75 going to the persons of that residents of that area by way of reservation, the other 25 being available to rest of the everybody. Likewise, in the other cadre, which has identified 1021 as the vacancies available for them, 8% is carved out and made available to the HK region candidates. The rest of the 92
8% to
rest of the 92 plus 25 of out of 221 of that cadre is available for rest of them, like the persons who had completed and who have got
open market
in the provisional select list. Now, by upsetting by this circular, what was done by the government based on their principle of wanting to apply principles which are available for reservations for SC/ST based on the judgment of the Supreme Court, where you, based on their merit, you give them the selection, keeping them as general category, and then again apply the reservation to the persons who otherwise come under the reservation. That principle was sought to be made available here, which runs in the teeth of the very very guidance issued under 371. That's going to be my submission. Now, what the government did was that it opened up the entirety of 1021 plus 221 to all the candidates based on their merit. Thereby, people who were merited falling within the HK region got the vacancies which were not available to them on priority, but taking it from the other region, that is other group. Thereby, people who were entitled to be appointed based on their merit in the other group lost out and are now being denied. That's their grievance. That's the sum and substance of their grievance. Whether such a process of changing
is
is permissible or not is the main issue, my lords, for your lordships' consideration.
Two things. What happens by these circulars?
Yes.
Which are put in challenge, and whether such circulars, such action is permissible.
Correct.
Two things.
No, my lords.
Effect of the circulars is one thing.
Yes. My lord.
Permissibility of the effect is another.
Yes.
Okay.
My lords, in my humble submission, 371 is something made by the Parliament. No person, my lords, can meddle with the provisions provided under 371J. Nor anybody can alter or meddle with the Governor's order made under 371J. The Parliament, through the President, enables discharge of certain responsibilities by the Governor, and in exercise of that power given to the Governor, based on the input which had come from the state government, an order is made. That order cannot be meddled with by the state government. But it can supplement for the purpose of giving effect to Governor's order by various rules, circulars, etc. The limited power of the government in supplementing is in aid of working out the Governor's order and not to destroy that or not derogate. It can't supplant what is provided for under the Governor's order. Now, what has been done by the government, by the impugned circular, is to supplant, destroy what is provided for under the Governor's order. The Governor's order contemplated, you identify the vacancies, you identify the cadres, you identify and provide for selection based on the merit. The aspect of supplementing was something, whether it is permissible or not is an issue which has been considered by this honorable court in the case of Vimalakshi, which I will point out to the limited extent, which said you will have 8% in the other cadre as well, which has been held to be not in derogation of the Governor's order. Now, what has been done now is that the entirety of 100% as against 75 plus 8 is made open for the persons coming from HK region to opt and get selected by this impugned order. That, in my humble submission, is impermissible, without competence, arbitrary and unreasonable, is not permissible, strictly construing the provisions, enabling provisions given to the Governor and by the presidential order. Now, my lords, having pointed out that in the factual background, kindly come to, my lords, come to the provisions of 371J itself, lords, which my lord will find. At page But this must have been read several times, but just to make my submissions complete, I'll repeat it, my lords, by
Very well, very well. No
reading
issue,
it.
no issue. We got that. That article is not produced along, you have produced
Is
that?
there, but then there is a slight
One.
typo, my lords, therefore I chose to
Very well, very
read it from the book. Page 1 is, my lords, the props. You made the
371J.
Okay.
President may.
President may, by order made with respect to the state of Karnataka, provide for any special responsibility of the governor for. So I will.
Establishment of A.
1 and 2, because they do not have direct nexus to the list, my lords, before your lordships. C, 3, equitable opportunity. The president may by order provide for any special responsibility of the governor for
Equitable opportunities and facilities
facilities for people belonging to the said region in matters of public employment,
education, vocational training.
subject to, my lords, these are the important words for my purpose. One is equitable opportunity. Second is subject to the requirement of the state as a whole. The
Hangandrenu, subject to the requirements of the state as a
Lords,
whole. Andre.
this has been explained by the judgments, my lords, in Dixitulu as well as in other judgment dealing with 371D. But to answer your lordship's question, when you provide for equitable opportunities, you will keep in mind not only the interest of the HK region, residents of HK region, but interest of the entire
State as a whole.
population of the state as a whole. So you balance the equities both for them as well as the others.
Now, Mr. Nayak, what is meant by equitable opportunities and facilities?
Yes.
Generally, equality we have heard
No,
of.
it is not equality.
It is equitability.
Equitable is not something which is in the context of doing equity. Lords, as courts have done in several pronouncements of equity, considering the just thing or reasonable approach or doing it in a right way, doing it in the constitutional scheme of the reasonableness. Those are the aspects, my lords, which go into the concept of equitable opportunities. Affording equitable
They
opportunities.
need not be equal opportunities.
No, it can be.
Equitable.
It can
cannot
never
be.
be.
Purpose will be defeated.
Yes, my lord. But cautioned with the word subject to the requirement of the state as a whole. That is, you can't discard in giving this equitable opportunities, disregard of the
State's
requirement of the state as a whole. So therefore, you are duty bound to keep.
The requirement of the state in view,
Yes.
then you should work out equity.
Yes. The other guidance in my humble submission built in 371J is found in, what is the other concept? Found in clause B of subclause 2. Identification of post, my lord has that. Identification of posts or class of posts under state government and in any body or organization in control of the state government and reservation of a proportion of such posts. Reservation of a proportion of suppose for persons who belong to that region by birth or domicile. So the three guiding principles laid down in this is, one, it should be equitable opportunity. B, you should keep the state as a whole in mind while working out this. 3, the reservation which you are providing for should be proportion. These were the guiding principles enunciated by the Parliament itself in enacting 371J. This, my lords, was the purport of the governor making the order discharging his responsibility entrusted under this. So therefore, my lords, government makes an order in terms of 2013 order.
Presidential order.
No, this is the governor's order. The presidential order comes in between. Well, it's based on the 371J.
President issues the order.
Order.
Very skeletal in nature, we have seen that.
Yes, he merely spells out that there would be special responsibility in the governor
Correct.
for matters referred in 371J. That my lord will find at page 5 of the compilation.
Correct.
In furtherance of this, the governor makes an order, which my lord will find, my lords, the next page.
Yes.
So I should point out here that the arguments were made, which according to me have no relevancy for the purpose, that whether it should be by aid and advice or whether it is under his discretion, etc. Lords, according to me, have no bearing in the issue that arises in my case. Now, my lords, necessarily when governor makes this order in 2013, he needs to have the input from the state government, whether it is termed as aid and advice or otherwise.
No, in the sense, Mr. Lakshmi Narayana said, he also said that way only. Aid and advice in our constitutional scheme, aid and advice in terms of Maruram.
So therefore,
Governor will be bound by that.
no, I'm wanting
Not
to,
bound by anta or some argument.
I want to stay clear of that controversy because in my case, it doesn't really require to be gone into. I would go to the extent of saying that when governor made this order in 2013, whether it was by aid and advice or otherwise, he had the input from the government. Necessarily, he has to have the input from the government because when you assess what is proportionate reservation, when you assess,
Inputs are necessary.
when you assess what is subject to the requirement of the state, it has to necessarily come from the state.
No, one second. I'm sorry for interrupting you. Mr. Lakshmi Narayana said, if it is aid and advice of the state government,
Yes.
then government will have power to issue the circular. If it is not with the aid and advice of the government, though inputs you may have, naturally, governor has to have the inputs from the state machinery only.
But strictly construing the power of issuance circular emanates from that. I beg to differ for this reason. Once there is an input, any issuance of circular to work out this scheme of order by the government is not prohibited. The circular only
It cannot run
supplements.
counter to what governor has said.
Yes,
This
but
is how he also
you
said.
can't have a derogatory provision under a circular.
Your circulars cannot run in derogation to what the governor has devised as the plan.
Or destroy that what has been
That's all,
provided
that's all.
for.
We are saying less than that.
Yes.
Even derogatory you cannot run.
Yes. Now that we are on this aspect, kindly see Rule 19 for a moment, please. At page 5 of this governor's order. The last provision, my lords, under the governor's order.
The governor shall.
No, the public employment reservation and appointment for Hyderabad
2013 rule order.
13 order, the last provision of that. Clause 19. This was in fact inserted, my lords, by a notification of the government DPR on 21/2014. It reads, my lords, state government shall.
Who has made this? These are promulgated by whom?
My lords, this governor's order is notified by the state government after the governor makes this order.
But this is the order made by the governor.
This is an order made by the governor.
The power to interpret is retained with the state government.
No. Therefore, it should be read carefully and construed strictly. I want to read it, my lords, for the
Okay.
purpose of my argument.
Okay.
The state government shall have powers of interpretation and competent to issue clarifications regarding the provisions of this order. It can only interpret this order and issue clarification about this order, not do something contrary to this order. Notice, I'm buttressing what I stated earlier, that the power of the state in exercise of its power, even assuming such a power is given
Available.
under 19, is limited to interpret what this order says and clarify what the order says. But that clarification and interpretation can't result in throwing away the entirety of the order, the scheme under which it seeks to subserve the purposes enunciated under the provisions of Article 3.
In other words, you are invoking Rule 90, paragraph 19.
Yes.
To say that it virtually restricts the power of the state to meddle with the scheme devised by the governor with whatever instrument under that.
Yes.
Only it can interpret it.
Yes.
And clarify it.
Yes.
If occasion arises,
Yes.
clarification may be sought for deputy commissioner or some other high functionaries of the concerned district area, that they can clarify.
The other limb of my submission is that after the governor makes this order setting out how it should be worked out for the benefit of the residents of this region, the state can supplement by circular instructions in tune with this order how to work out the scheme of the benefits which are to be passed on. But it does not enable the state by circular do something contrary to what is intended under the governor's order. That's the submission, my lords, which I wanted to make it at the inception. Let's the legal issues that arise for consideration at your lordship's hand is that under Lord's Chapter 21, 371J has been notified, has been legislated by the Parliament. Your lordships have also taken note of 371 to 371I. Most of them had the non-obstante clause.
Unlike here.
Unlike this. I would say because 371J came later in point of time, and the Honorable Supreme Court had enunciated the various nuances of Article 14 by that time, explaining how the rights are found in Article 14, rights are found in Article 21. So you can't derogate those rights founded on the basis of notwithstanding anything contained in the Constitution. You're still duty bound by
To the larger constitutional
scheme of protection given to the citizens of this country. So therefore, the difference between 371J, absence of non-obstante clause,
Makes
and
no
other
difference at all.
provisions is limited to the Parliament itself being conscious and accepting that you can operate 371J in consonance with the other provisions of Part 3 of the Constitution and not ignoring it, as may be thought of by the state governments keeping in view the non-obstante clause. It may become debatable whether it's permissible or not, my lords, is the aspect. In case of Andhra Pradesh, they said that notwithstanding the word not this thing,
Still you are bound by
you are bound
14, 19.
and other
such other
provisions of the Constitution. In that case, which was pronounced, my lords, which is known as Chief Justice of Andhra Pradesh versus Dikshitulu, the issue was whether the provisions made under the Constitution, I think 234 or so, giving powers to the High Court, could still be controlled by the principles evolved under 371J. They said no, they can't operate in a field which is specially provided for by the High Court under the various provisions of the Constitution.
In other words, the word non-obstante clause, that notwithstanding,
Yes,
was virtually, its efficacy was robbed away,
yes,
robbed away.
yes.
Now,
No,
here that word is conspicuously absent.
not only that, my lords, it was also not used in this case.
That's what.
Because by that time, the judgments of
Had
the
come.
Andhra Pradesh High Court had explained what is the scope of the power to legislate, But so let's not take note of one important fact. 371(1) as initially framed. Let's kindly take
Yes.
371 for a moment. What is-
371, one is deleted.
So 371(1) was a provision made for state of Maharashtra and Gujarat.
Correct.
But if you're lots of to see the 4x's or 5x's, which are indicative of what is deleted, your lordships would note the footnote. It was also made applicable to Andhra Pradesh, but it was deleted. Item 3, my lords, at the footnote. So
Make it
initially,
very-
when 371 was enacted, it applied to, the special provisions applied to Andhra Pradesh as well. Now, Andhra Pradesh had the provisions of making within a time frame the various categorization and providing for reservation. I'm using the word categorization in place of, what is that concept? Organization, cadre.
Cadre.
Yes. That was a case where Andhra Pradesh had three different reasons with three different areas coming from various neighboring states. And therefore, they had to provide for the cadres. And the cadre having been provided only for one area by the Andhra Pradesh government, in order to facilitate the employees in the Jilla Parishad and other places, it was struck down. Therefore, the parliament enacted for the benefit of state of Andhra Pradesh by a parliamentary enactment, which was subject matter of proceedings before the Supreme Court, which considered and said, no, you don't have power. Once 371 provides for a process by which you will provide for, nobody can meddle with that.
Only the
Yes, yes.
president and governor.
Yes, I'll read that, my lords, so that instead of my putting it in words, my lords, it may be more clearer once I read those, the paragraphs, my lords. Which is,
This judgment in case of Waymarried,
which one?
serial number 3.
No, do you read case?
No, Waymarried.
Let's just have the compilation, lots of the case clause. What is it? There is a spiral bound compilation.
Yes.
The third judgment is Government of AP versus P. Vemulu Reddy.
Page number?
86 of the compilation.
86.
Let's, as far as I am concerned, I can continue, but I don't want to hold your lordships. And I don't want to stop at the middle of this, reading this and then continue next day. I would rather complete this, it may take some time, but I am ready to.
Can we have it, because many orders we have to see.
I'm at your lordships and that's why, my lords, I did not want to,
Yes.
let's go on reading without drawing your lordships' attention to the
86.
Yes. All right. Okay. Does he want to read it? You want to read that one?
No, no, I
No.
just wanted to
Okay.
draw your lordship's attention to the paragraphs so that if your lordships get an occasion, then your lordships could
I'll read. out.
possibly
Yeah.
read it. But I'll read it, my lords, on the next date of hearing
Very-
because
very-
it's necessary to read to understand how the concept of 371J with reference to other pronouncements under 371 series are to be understood. For that purpose, lords, it may be necessary. But I would rather, lords, in case if your lords are reading on your own, the very opening paragraphs in para 2,
Page number?
lords, this is at page 86.
86, para 66, 67, that way.
At page 86,
Ah.
on top, lords, is the pagination.
Part 6.
Yes, it gets merged with the SCC online details.
That Dikshitalu
No, no,
judgment.
no. This is, my lords, Government of AP versus Vema Reddy.
No. Page 80. This is not the. Where idea?
ಎರಡು volume ಇದೆಯಾ?
Okay.
Page 86.
The one.
In fact, my
This
lords,
one.
it makes a very
That is
interesting.
correct. Correct. That is the second volume, page 86 of this.
But I'm sure your lords would read entirety of it because it makes very interesting reading.
Okay.
And my lords, if your lords find some time, lords may.
I'll also.
But I will certainly read this
I have
again.
lot of time, Mr. Naik. We don't have any other one.
I don't believe that. lords. So I will continue, my lords, on
Very
the
good.
next date of.
Very
hearing.
good. Very good. Which, holiday declared? High Court also declared. Okay. Monday, Tuesday. Can we have this on Monday?
Except Monday, any day, I have not some function in AT place.
Thursday. Start ಮಾಡಲು ಮತ್ತು ಡಿರೇಲ್ ಆಗಲ್ಪಡ ಇದು Thursday.
This
Thursday, no matters.
Free ಇದೆ. Can we?
Thursday, I can
Thursday we can
continue
continue.
this Thursday or any day after 16th, any day subject to your lord's convenience.
17, 18. ಅಲ್ಲ ಈಗ Thursday ಇದೆ 17, 18 ನಾನು ಇಲ್ಲ.
For whom?
Aforesaid, yeah. Single ಇದೆ.
May I make this tentatively, your lords may have it on Thursday, but if there is some inconvenience to the court, then it can always
That
be
we can.
called
Thursday, I
another.
can go with it. Suppose if possible, we'll take up.
Yes, lords.
Otherwise,
Otherwise
we'll have
another
it some
date
other-
convenient to the court. lords.
That's good.
Because I want it to be, the continuity should be
Yeah,
there.
understood. We understood. Therefore, in the middle also, we don't want to hear arguments of others. In this line.
Yes.
During vacation, we want to,
We will give whatever date you want.
but complete
you have
it
to
before onset of the winter vacation.
Yes, it should Thursday, there's no, Thursday, there's no other matter.
Yes, sir. Thank you. Thank you. Sir. So.
Where do you say it is very cold in the court? I'm sweating here. He must have heard you and switched it off.